Hello, everyone, and welcome back once again to another very exciting episode of Immigration and Jobs Talk Show. I'm your host, Sam, and before moving ahead, let me read out this very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not a legal advice. So, use of information is at your own risk. All right, after this very important disclaimer, once again, friends, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam, and today we are going to dive into a very important and a very timely topic, and that is about H1B modernization rule. So, in today's session, we are going to understand that how will the 2025 H1B modernization rule is going to transform the US employment for foreign workers. So I'm sure, most of the people are getting very much concerned about like how the new policies will be, how the new rules will be, and how will be the process all about. And I think to understand that everything in detail, I have a best expert advice for you, friends. So please help me in joining the attorney who has been joining us for the second time in Immigration and Jobs Talk Show. So let me welcome attorney Karen Lee Polak, who is the managing attorney of Polak PLLC, a top immigration law firm based in Dallas, Texas, and Florida. And the firm provides a full range of immigration services to business, families, and individuals as well. So, Karen, first of all, very much, we are really happy to have you again with us, and we are honored that you have joined us. So, thank you so much for joining. And how are you doing right now?
Hi, Sam. Thank you so much for having me. It's an honor and a privilege to appear on your show again, and I'm excited to delve into this new topic of the 2025 H1B modernization rule.
Absolutely. I think today the topic is going to be very much important, for us to know about. So I'm sure that we are going to gain lots of information, lots of, knowledge about today's topic. So once again, welcome everyone, and it will be great if you could also join us from any of the platform, that is YouTube, LinkedIn, Facebook, or Twitter, as well, as we are live on these many platforms. So post your questions and let us know what questions you are having for today's topic. Karen is here with us for an hour. So we will definitely take those questions and provide the best solution and the best answer to it. So, Karen, without any further ado, I would like to know from you that what our viewers can expect from today's episode.
Well, I think we're going to delve into the 2025 H1B modernization rule, what it is, what changes they can foresee in filing H1B petitions, what different rules there'll be, and different standards in adjudicating things. And then we have some good news for H1B self sponsors by entrepreneurs who want to file their own H1B through their own company.
All right. So I hope today's session is going to be very informative, and I'm super excited for it because our last session, I remember, it was very much informative, and also, the explanation that you provided was in a very simple term, and our audience also loved that. So I'm sure today's session is also going to be the same. And with that, Karen, here's my first question: that what is actually the H1B modernization rule?
On December the 18th, 2024, the Department of Homeland Security announced its new H-1B modernization rule, which went into effect today, January 17th, 2025. The DHS's freshly minted rule aims to bring the H-1B program, as USCIS says, into the modern era. The stated objectives that USCIS claim are to enhance efficiency, incorporate new benefits and flexibility, and bolster integrity measures within the program. They claim that these changes are designed to not only streamline processes, but also to ensure the program remains robust in an ever evolving global landscape.
All right. So, Karen, now I would like you to know about like what's the current scenario, or because now I would also like you to make our viewers understand about the current system of H1B that most of the people are aware of, and what can be the changes that we are going to expect in this new rule.
Well, first of all, under the new rule, there is a new form I-129, which is the application form for an H-1B, among other types of visas. There is a new form. It went into effect today, January 17th, 2025. There is no grace period. If you use any other form, it will be rejected. So that went into effect today. The most important or key change is that USCIS, or Department of Homeland Security, has revised the definition of specialty occupation, which now goes into effect today, January 17, 2025. Under this change, a specialty occupation necessitates at least a bachelor's degree in a directly related specific specialty or its equivalent. USCIS specifically states that if a petitioner requires attainment of a general degree without further specialization for entry into an occupation, that occupation is not eligible for an H-1B. So now what this actually means is USCIS is going to look not only at the degree title, but at the actual course of study. And there should be, and I quote, a directly related logical connection between the required degree or its equivalent and the duties that the employee is going to perform. So, for example, if you have a bachelor's in economics, but you're being hired as a software developer, that's no longer going to fly. They're no longer going to accept that. They want to see that you at least have courses related to computer science in your degree if you are going to be a software developer. So the degree now needs to be directly related to the job offered. That is one of the biggest changes in the modernization rule. It's designed to cater to a lot of these new AI jobs that haven't been here before, and it will accept a range of qualifying degrees. So no longer do you have to have a degree in computer science. It could be computer science, information technology, or a related field. And more importantly, the courses that you've studied should be related to the job offer. They've also changed under the H-1B modernization rule, nonprofit research or governmental research organizations must demonstrate research as a fundamental activity rather than their primary mission in order to be CAP exempt. So it can be just one of the activities that they're performing in order to be CAP exempt, but it must be a fundamental activity. An exciting thing is students who are on F1 visas in the US, this extends CAP gap. Previously, the CAP gap, which would allow you to continue working while you determine if you selected in the lottery. Normally that CAP gap was extended until October of the new fiscal year. Now that will go until April of the new fiscal year. So it's been expanded by December, January, February, almost 5 months. So CAP gap has been extended by 5 months, which we're excited about. It ended typically on October 1. Now it will go until April 1. The one thing that I am most excited about is owner beneficiaries can now petition for themselves. So if you have your own company, you can petition for your own H-1B. This allows entrepreneurs and startup owners access to the H-1B visa, which is crucial for driving innovation, job creation, and economic growth in the US. The only thing is these H-1B visas will be valid for 18 months, not for 3 years. There's also going to be greater scrutiny by USCIS fraud division of applications that are filed. USCIS will now do site visits at the workplace. It could be at a third-party site. It could even be at the employee's place of residence if they are working from home. So people should be very aware of that. The H-1B modernization rule also allows USCIS to ask for documents such as contracts, client letters, and statements of work to confirm the bona fides of a job offer, and educational requirements at third-party work locations. So that's very important. USCIS has also evaluated third-party job requirements for specialty occupation classifications, and they will look at if the beneficiary will be performing work as part of the staff at a third party. They are going to look at the third party's job requirements, not the petitioner's. If they'll only be doing services at a third party, then USCIS will look at the petitioner's job requirements. So it's very important to see whether the beneficiary is going to become part of the staff of the third party or if they will only be performing services, because USCIS will look at the appropriate job requirements of whether it's the third party in the case of a staffing company, and if it will be the petitioners, if they will only be performing services at the third party. The H1B modernization rule also codifies existing policy to defer to prior decisions. So if you do have an H1B approved and you're doing a renewal, they will defer to prior decisions unless there are material errors, changes in circumstances, or new adverse information. DHS has finally put in the regulations that they will defer to earlier determinations on issues like whether a job is a specialty occupation or a worker has demonstrated that they have suitable qualifications for the position. This deference reduces risks that we'll get inconsistent decisions where one immigration officer says one thing, but on renewal an immigration officer says something different. So we are very pleased about this deference policy. The general deference policy was rescinded under the first Trump administration, but now the Biden administration, by codifying this rule, now makes it less likely to be rescinded.
Wow. I think that was in a very detailed way. And thank you so much, Karen, for letting us know for each and every rules that are going to be implementing. So I think there's a lot of new rules that are coming up on our way. And we have to be very much, aware of these new rules. But with that, Karen, you mentioned about specialty occupation. So here's a question that I would like it to know from you, that it shouldn't be a word to word degree, or it shouldn't be like if you're having a computer science course, then is it okay that the courses that are under computer science, they can opt for that also? The H1B workers will get visa according to that, or they have to be very much particular about the exact course or the exact job that they are going to have it? I mean, how it will be.
They're definitely going to look at the courses that were taken to see that they directly relate, and that is an actual quote, are directly related to the job. So they will look at the courses. So if you have taken computer science courses and you are in a software developer's position, that should be very good.
All right, I think that's pretty much clear. Okay, and with that, Karen, I have another question in my mind, and that is about the new wage based system. So, as we are seeing that, the new wage based system is coming on our way, and applicants with higher salaries are going to give more priority as compared to those who are with lower salaries. So, how is it like how someone can check if the salary they are being offered is competitive enough to improve their chances of getting selected for an H1B visa under the system?
Well, first of all, there is no new wage-based selection system. It's still the same system that's under flag. It has not changed as of yet, and I definitely don't think it will change, at least for this H1B season. People can look at wages that to see if they're competitive by going to the Department of Labor flag website. They can go to flag.dol.gov. They go to the tab that says wage data, and they can see the wages for the position. I think there's going to be greater scrutiny at level 1 and level 2 wages, and probably we will get requests for evidence on those levels. At levels 3 and 4, you should be good to go. But people can check to see if they qualify based on their wages that they're getting by going to the flag website and clicking on the tab wage data.
All right. So, Karen, is it not true that there won't be any new wage-based system because most of the time, we have heard that Trump is going to implement that system.
It's
So,
going to, he may implement that system, but it's going to take time. It has to go through a regulatory process, and he certainly doesn't have time to do it before this H1B cap season. So nothing's going to be done this year.
all right. Okay. And with that, Karen, I have another question for you, and that is, will the modernization rule implement the lottery system entirely, or will it just reduce its role in visa selection?
The modernization rule does not impact the lottery system right now. It doesn't even really address it. It's going to be the same normal lottery system that we've had in past years. I think the Trump administration may change that in future H1B seasons, but for this current season, the lottery remains the same.
All right. And also, Karen, we have been through different news updates that's Trump is mostly he's going to eliminate the lottery system. So, do you think that it's going to happen because lottery system is one of the major process, for the H1B visa. So, do you think it's going to happen?
That's a tough question. It's certainly not going to happen for this H1B season. We'll definitely have the lottery, or it's just would be very, very hard to abolish the lottery before April 1. And the selection process typically takes place in mid-March. So I think that he has more important things on his agenda. But going forward in future years, they may eliminate the lottery.
All right. So, do you want to favor in the elimination of lottery system, or you like this lottery system? What's your call on that?
I don't like the lottery system. I think that we should just let market forces dictate if people are eligible. If there's no jobs available, there won't be people entering the lottery, entering the H1B process. So if employers have jobs for immigrants, I'm all in favor of a market condition regulating this.
Wow. All right. So, Karen, here's another question, and this question is for the smaller companies. So, how will smaller companies that can't offer high wages compete in the H1B selection process?
That's a really tough question. If they can't offer at least a level 1 wage, which is generally pretty low,
Right.
then they can't compete. So they won't be able to enter the lottery because under the lottery, you're filing a labor condition application where you warrant that you will be paying the level wage that you state. So if smaller companies can't pay those wages, then they cannot enter the H1B selection. But a level 1 wage is pretty low. So you've got bigger problems if you can't afford to pay the level 1 wage.
Absolutely. All right. So, Karen, here's another question that is, how does this rule address the backlog of H1B workers who are waiting for green cards, especially for Indian and Chinese nationals?
Unfortunately, this H1B modernization rule is designed to streamline the process. It does not address at all any backlogs.
All right. And meanwhile, I think I should also look for, our viewers, those who have joined us. So, welcome, friends. And I can see Jay Prag, then Neelanjana also, and then Subhash also. So, friends, it's great that you friends have commented here, and we will definitely take these questions because after completing my questions that I have prepared, I'll definitely come back to these questions. And meanwhile, you can still post, you can still have any follow up questions or any other questions that you would like to know from today's episode. So, that would be great. And with that, here's another question, Karen, that I would like to know it from you, and that's about that how this new rule, is going to impact those employers who want to switch their job while on H1B visa, And what are the changes to the H1B visa transfer process? Yeah.
I think you've got to be careful now with the redesigned definition of specialty occupation and make sure that the person's courses that they took in their studying are directly related to the job. So they might have got away with before a degree in economics, not done any courses in computer science, and got the job as a software developer. We'll have to wait and see, but I think that could be problematic in a job transfer now because the specialty occupation definition has changed.
Absolutely. And that's how I think we all have to be very much careful and need to be updated with all the changes, that's happening. And that's how only you can look for it and can save your process or the problems that you might face.
Right. It
And
only went into effect today. So we'll just have to see how USCIS is going to handle the new definition of specialty occupation and H1B renewals and H1B transfers.
absolutely. All right. So, with this, I think this could be the follow up question because switching job and the grace period is somehow relating. So, Karen, will the grace period for finding new employment be extended, or are there other protections for workers?
At this time, there's no other protections for workers, and the grace period is still 60 days.
Oh, all right. So, can we expect some changes regarding the grace period?
I don't, I don't think so right now. It's a process to make changes, but the Trump administration may make some changes to the grace period, but I don't think it will be for the benefit of beneficiaries.
Oh, all right. Okay, so I think let's see what can happen. And with that, Karen, here's another question that is, how does this rule affect spouses of H1B visa holders, and especially those on H4 visas in terms of employment authorization?
It doesn't change employment authorization for spouses of H1B visa holders. A spouse of an H1B visa holder can get employment if the H1B beneficiary has an approved I-140 petition. Otherwise, there is no basis for an H4 beneficiary to work in the US.
All right. And I think now, after a while, I should take some questions from our viewers. So let me take this Neelanjana question. And Neelanjana is asking that I'm currently employed as a software engineer on an H1B visa, and my employer has filed a green card petition on my behalf. How will the 2025 H1B modernization rule impact my existing H1B status? And are there any potential risk or benefit to my ongoing green card applications?
Okay. I'm just reading through it.
Sure. You can answer one by one, Karen, also. You can just go firstly with the how is it going to impact her H1B status?
Um, I don't think it's going to. The green card application isn't going to be affected by the H1B modernization rule. It's two separate tracks. We don't know, but we will have to see if this new change to the definition of specialty occupation will impact any renewals of an H1B. So, as long as the courses in her study are directly related to the job position, she should be fine.
Absolutely. And also, Karen, what are the potential risk or benefit to her ongoing green card application?
I don't think there's any further risks to the green card application or any benefits. It's two separate tracks. And as long as she remains in H1B status, in lawful status, she should be fine for her green card petition.
All right. I hope Nilanjana, you got your answer. And still, if you have any follow up question or a follow up doubt, then please go ahead and post them on the comment section. We will definitely take them up.
We
And
can have we can have another discussion in a couple of months when we see how USCIS has actually implemented this rule and we'll be able to answer a lot of these questions then. It only went into effect today, so we don't know how USCIS is going to really interpret the rule.
Absolutely. I think that's very well said. And, we can also have another discussion, another session on this particular topic regarding USCIS. So that will too be very much informative. And meanwhile, thank you so much, Karen, also for taking these questions and, explaining each things to our viewers. Next up, I would like to take off Subhash question, and he's asking that our company relies heavily on H1B workers to fill critical skills gap in our IT department. With the introduction of the 2025 H1B modernization rule, what specific changes can we expect in terms of wage requirements? So this is a pretty long question. So Karen, firstly, we are going to take the wage requirements changes.
I think as long as the wage falls within level 1 through 4 of the wage data that the Department of Labor have set, you should be fine. I think there, as I said earlier, there will be extra scrutiny of level 1 and level 2 workers to prove that it's a specialty occupation at a lower wage. But I think you will be fine as long as your job is directly related to the courses of study.
Absolutely, and that's very well said. And next up is about visa caps. So, Karen, can you please go ahead about visa caps and then documentation procedures as well?
Sorry, can you just go? Can you just scroll up to the beginning of the question?
Sure.
I don't, for right now, the H1B modernization rule does not change visa caps. It's still 85,000 visas per year. 20,000 are reserved for people with master's degrees from the US. There is no change in that. We can't predict what's going to happen in future H1B seasons. In terms of documentation procedures, the law is going to remain the same in regard to H1Bs. There's no changes with that for beneficiary in submitting documents, except to make sure that, again, the courses of study in their degree are directly related to the job. They're not going to accept anymore just a general degree with arbitrary courses.
So, Karen, do you think that this general degree concept is going to benefit the US companies? Because now it's not about the specific qualification needed for that role or for that responsibility. So, do you think it's going to benefit the US company?
Well, they're not going to allow general degrees. You absolutely have to have degrees which have courses of study that are directly related to the job. So I think that may be tricky for some people who've got away before by just proving that they've got a bachelor's degree. Now they have to show that they have a bachelor's degree with courses directly related to the area of the job.
Absolutely. And I think that will be challenging because those who already applied courses, in the wage field, and now they have to be very much particular about which course they are going to choose for, especially for the jobs. So I
Yes.
think that's very important, and that's a very new rule, that we are going to see in this H1B modernization. And with that, Karen, here's a follow-up question that is from Subhash. That are there any proactive steps we can take to ensure a smooth transition and minimize disruptions to our business operations?
I think just to have all your documents in place, hire your attorneys for H1B cap season early so that they can evaluate wages to see that they are within the prevailing wages, that they can evaluate educational transcripts to make sure that the courses of study are directly related. They may have to tweak job descriptions. So I think the earlier that you get in touch with your attorney, the better.
Absolutely. And I think with that, we should also like to share contact details of our attorney, Karen Lee Polak. And
Thank you.
Subhash, you can also connect with her. You can personally connect with her and ask any question, and she will definitely give you the best advice. And here's her detail that is, you can call her on 214 504 1227. And you can also email her on KarenLP at polackimmigration.com. And the website is that is www.polackimmigration.com. So I think it would be great if you could, let her know about your concern, about your problem, and she's definitely going to help you out. All
It's
right.
always
And
best to get hold of me by email. So
okay,
you can always email me, and that's always the best way to get hold of me.
absolutely. I think Subhash will definitely email you and will let you know about his problem or about his, the concern that he's going through. And with that, I would like to take up Jay Prog's question. So, welcome, Jay Prog. And the question he's asking about what are the changes being planned with the new modernization program that we need to pay attention to?
I think again, we've gone through it a few times, but make sure that your degree, the courses of study are directly related to the job that is being offered. That's going to be key since they've revised the definition of specialty occupation. If possible, I would get a level 3 wage if you can to try and avoid RFEs on level 1 or level 2 wages, and have all your documents timely to your attorneys who are doing your H1B so they can evaluate everything in light of the new modernization rule.
Absolutely. So, Karen, do you think that this directly related concept is going to make the employers or the employees work more difficult?
Um, it may. It may. It depends on what your courses of study are. If you, as I say, have an economics degree with finance subjects and you're applying for a software developer role, I think that the H1B modernization rule is going to prejudice you because you no longer fulfill the definition of specialty occupation.
Absolutely. And thank you so much, Karen, for letting us know about it. And I think meanwhile, we should also take other questions as well. But before that, before Ankit question, Ankit, please stay tuned and follow up this question also. We will definitely take this question after a while. And with that, here's another question that I would like it to know from you, Karen, that how do you think that the 2025 rule is going to impact the foreign students on F1 visas who hope to transition to the H1B status after graduation? Will there be any changes in how they navigate the system?
I don't think there's going to be many changes other than what I stated, that there's going to be an extension of the cap gap, which is to their advantage. So now cap gap season extends from it typically ended on October 1. Now it will go through April 1. So that's to their advantage that they've got that cap gap while they're waiting for a decision.
Absolutely. All right. So here's another question, Karen. That about now, I would like to know about the potential drawbacks in this new rule. So, what are the potential drawbacks or criticism, of the 2025 H1B modernization rule, and how it could create any unforeseen issues for foreign workers or employers?
Well, I think the criticism is there are people who are highly qualified in jobs who don't necessarily have the degrees that match those jobs. And now, with the change in the H1B specialty occupation, that's going to be problematic, and we will have to try and explain away how their experience qualifies to make them qualified for the position, because straight away the government's going to go, they don't have a degree in this field. So we would have to explain how their prior experience and get evaluations from experts to show that their prior experience is equivalent to courses in those fields.
Absolutely. So I think now we are getting into lots of information about this new rule, and we are pretty much clear about the basic understanding what this new rule is all about, and what are the changes that we can expect. So with that, there are another set of questions also, Karen, that we got from our Facebook group. So if you allow, we could also like to take questions from there as well.
Sure.
Okay, so here's a question that we got from our viewer, that is Teja. So Teja is asking about the consular H1B transfer, that my friend's H1B was approved in October 2024 under the consular process, and she received her visa stamp. She was supposed to come to the US in November 2024, but didn't because her project was put on hold due to budget issues. Now she's looking for C2C jobs but hasn't found any in the current market. She found some W2 jobs, but the new employer would need to do an H1B transfer. So her first question is that does she need pay stubs for the transfer?
Yes, she will need pay stubs for the transfer because she actually is not in H1B status. She got her visa overseas, but has not entered the United States. So she is not in H1B status. So she would need some pay stubs.
All right. And there's another question that are there any complications with transferring from a consular H1B to another employer?
There shouldn't be any complications if she's got pay stubs and has actually worked for them. But if she hasn't worked for them in H1B status, there's nothing to change. So she can't do a consular transfer.
All right. I hope, Teja, you got your answer. And as Karen said, I hope it will be helpful for you. And with this, we would like to go to next question of that we received from Facebook group. And that is from anonymous member. And the question is about H1B transfer and expired visa. So I used just 1 year, 10 months of H1B max out. I returned to home country last month as my employer did not bridge in amendment as client was being changed, while extension is pending approval with USCIS. Since my visa has been expired, can H1B transferred while in India to a new employer? What's
Yes,
your
it
thought?
wouldn't be a transfer, it would be new employment. You would check the box that says new employment, but it is possible as long as they can show that they have the last three pay stubs while they were in the United States, they left the country, they will do a new employer H1B.
All right. And there's another question that we got from our viewer. It's about hello, I'm currently on STEM OPT till June 2026 and have a master's degree from the United States. My employer applied for my H1B visa last year, but I wasn't selected. This year, is there a greater opportunity? Yeah, Karen, let's go one by one.
Okay, there's no greater opportunity. There's 20,000 H1Bs reserved for people with master's degrees from the United States. So they would first go into the general pool, and if not selected, then they will go into the master's cap. So they would have a second bite at the apple to see if they are approved. But there's no changes in the selection process or greater or lesser opportunity.
All right. Okay, and in addition, my employer told me that he would apply for a green card on my behalf if I didn't select it this March. Do you think there will be enough time to do so?
Uh, he's from Lebanon. I'm not sure what he means by will there be enough time to do so. And a green card through employment is going to take at least 4 years for somebody from Lebanon. So if he means will he get his green card um, before his STEM runs out in 2026, the answer to that is no, he won't. It's going to take 4 years. And applying for a green card doesn't allow you to stay in the country. So he'll need to apply this year and next year, if not selected in the H1B cap or change to a student visa to stay here while he waits for his green card, which will take 4 years.
Right. So I'm hoping that this answer, this advice is going to be very helpful for our viewer. And with this, I think we should move ahead with our next question that we got from our Facebook group participant. And Okay, this I think we took. So let's take up some other one. I think this is also the one that we took, Teja. Yeah, this is the one that we should take. Okay, so Karen, is there any difference after I-140 approval between EB2 normal perm and NIW perm? Any possibilities of getting GC faster in NIW process?
No, no, the EB2 process for national interest waivers and general EB2s is determined by the visa bulletin, and it's the same time.
Okay. And the other question is that is day one perm is a myth? An employer is promising me to file the perm within 1 month of joining with them, saying they already have the PWD. Is it a doable thing or what?
Well, it depends how far they are in the process. If they've got a prevailing wage, which typically takes 6 to 7 months, and they've already done advertising for the job, and that person meets the requirements, then yeah, they could possibly file perm on day one if they've done all those steps and they've got them and the employee qualifies for the job. They would have to have advertising that's up to date, so it's not more than 60 days old. I'm sorry, not more than 6 months old, and it's possible. Yeah, it's possible. Unlikely, but possible.
All right. Okay, and Control, if you could show us some other questions also, if there's another question regarding the H1B thing. Okay, so here's another question, Karen, that I would like to take up. That is, my company filed the H1B petition extension on 18th November 2024 in premium, but still online status is showing they are actively reviewing the Form I-129 and nothing is outstanding. I asked my attorney why it is getting delayed in premium. Usually it takes 15 to 20 days for approval, and he said he will be refiling the upgrade to push my case. Just wanted to check if anyone else is facing the same issue, and Karen, please go ahead and share the advice.
Well, I don't know what the answer to this is. It normally takes 15 business days, and if you write to the if you email premium processing, they're pretty good at responding to you. So something doesn't sound right here. I don't know why he would upgrade again and pay another $2,805. Perhaps they never filed in premium processing in the first place.
Questions that we got from. Hello, Karen, can you hear me?
Now I can, yes.
Okay. Okay. So yeah, I think so. These were the questions, that we got from our Facebook participants, as well as they mostly put up these questions regarding the H1B and the different visa categories. So we took this question, and now I think I should take Ankit's question. So Ankit is asking that I am a Canadian citizen working in the US on an H1B visa, and I'm planning to get married to a US citizen. How will the 2025 H1B modernization rule impact my ability to switch to a different visa category, such as a K3 or CR1 visa? And what are the implications for my immigration status and future US citizenship eligibility? So
Well,
that's a lot.
congratulations on your wedding. Congratulations. The H1B modernization rule will have absolutely no impact on you filing for a green card through marriage to a US citizen. In fact, that's a really easy process, and it has very few problems associated with it. It's a very easy process. It's a lot of documents involved, but if the documents are completed properly with the supporting evidence, you should be fine. But it has nothing to do with the H1B modernization rule, and there'll be absolutely no impact.
All right. So I think Ankit, you got your answer, and still, in case if you would like to know more about it, or if you have any follow-up question, then please go ahead and share them on the comment section. We will definitely take them up. And with that, I think we already took most of the comments, most of the Facebook questions also. And I think JPROC has asked about, is this started? So I think it's the date is only this 17th January, right, Karen, that it's going to implement.
It went into effect today, January 17th.
Right, absolutely. So I think Jay Prag's question also we took, then Subhash also, Neil and Jana. So there were different viewers who joined us and who asked these questions. So it was really good to know about it. And with that, Karen, here's another question that I would like to know it from you. And this is a different question, like it's going to be a little political question. So I would like to know it from you that politically the H1B visa has often been a very topic of debate, between different parties. So, how do you think that the 2025 H1B modernization rule will be received by Biden administration, Congress, or other stakeholders?
Do you mean the Trump administration? The Biden
Oh,
administration is almost over. So
oh, right.
I
Sorry,
think,
sorry.
um, well, there's been a lot of controversy over this. Um, so far, there's been a little Twitter war or X war between Elon Musk and others over the H1B. And Elon Musk is very in favor of the H1B petition. He was on an H1B.
Yeah.
Trump seems to have Elon Musk's ear. So I think that Trump will favor the H1B. Now, there are people in his party who are very anti immigrant and anti the H1B, saying the H1B suppresses salaries, it makes people indentured slaves, all sorts of things out there on that. It's taking jobs away from Americans. And so there are people who are against it. But I think as long as Elon Musk is in the position that he's influencing President Trump, we are good to go with the H1B.
Absolutely. And I think we should hope for that also, because nowadays we are seeing more Trump and Elon Musk. They are getting close together and they are having a very friendly relationship, because also
Until
the
until
business.
they fall out, which will happen. There will be a fallout. We just don't know when.
Right, right, right. Absolutely. But also, Karen, I mean, what do you think? Because, most of the people, they are saying that H1B workers, they are getting less payment as compared to the actual US people, US born people. But still, there's a different criticism that's going on, because for the same job, the US people are getting paid highly as compared to the H1B workers. So, how is it like why people are into this discussion that H1B workers should be banned or it shouldn't be allowed? I mean, what can be the reason behind it?
Well, it's, I mean, I don't know, but I think it's fear. People are scared and they're worried about their jobs being taken. They're worried about layoffs. Sometimes you hear about these big companies laying off hundreds of thousands of people, but they're still hiring in H1B. And people question, and it's a good question, why are you laying off people but still hiring H1B workers? If there's
Right.
a layoff, it means you don't have enough jobs. So, there is that argument by proponents who are anti-immigration. Um, but generally, wages cannot be paid, American workers cannot be paid more than foreign born workers. It would be wage discrimination. And that's why the Department of Labor has prevailing wages that you have to pay so that it can regulate the wages that are paid.
Right, right. And there are, so many criticism also that most of the time H1B workers go through. But still, most of the time it's like anti-immigration or anti-H1B workers. So I think automatically, H1B workers, they are benefiting the US nation a lot and contributing a lot in US economy. But out of that also, most of the time it happens that they have to face lots of discrimination, lots of criticism also. But I
Yeah.
think, Karen, it's very evident, that H1B workers are really contributing a lot in US economy. And that's pretty
Absolutely.
much well known by Elon Musk and by Trump also this time. So I would just like to know it from you that there's a kind of conflict going in Trump's administration, Trump's team itself, because it's like Mega versus Elon Musk, and
Right.
there's a conflict, right? So it's very interesting to know about it, because now what Trump used to say in his first term, that he's going to be very much strict about the H1B workers, and now we are going to see his statements that he's favoring H1B workers. So, what's your call on that? I mean, do you think that Trump is going to favor Elon or his mega team members?
I think right now it's clear that he's favoring Elon Musk, and as long as um, Elon has Trump's ear, then we're good with the H1B program. But President Trump is very erratic. We just, can't tell.
Absolutely, we can't say. And he's also very unpredictable,
Right.
because there's so much, that he says, and that too without even a second thought. So, that's what we can expect in this year. And I think we have already talked a lot about today's topic, and with that, Karen, here would be my last question from you for today's session. That what final advice would you like to give to foreign workers and employees who are navigating the 2025 H1B modernization rule?
I think that they just need to have their documents in a row. If they don't have courses of study that are directly related to the job offer, they need to get expert opinions that their work experience counts to be like courses that they've studied. And it's not just simply getting registered in the lottery, it's a matter of getting all your documents to your attorneys as soon as possible so they can do an evaluation.
All right, I think that was pretty good. And Karen, here we have another comment that we received from AJ. So AJ is asking about like national security, sovereignty, and economic security must be considered when crafting employment and immigration policy that strains Americans' resources to accommodate these foreign nationals. What would you like to add on that?
I'm not sure what they're asking.
Uh,
It's not
I
clear
think
to me.
he's. Mhm.
I think they're just making a statement that,
Yeah.
national security must be taken into account when issuing H1B visas. Well, national security is taken into account. Um, you've got to provide a lot of documents. You've got to provide past visas. Often you've got to go to the consulate for an interview. They go through a whole lot of questions. Have you been convicted of a crime? Have you ever overstayed your visas? So I think those things are being taken into account.
Absolutely. I think, yeah, AJ was about to have a discussion. So he's not asking any question, he's just putting up his point. So I think that's what, yeah, he wanted to add. But, anyways, I think that's pretty much discussed. And thank you so much, Karen, for, I mean, sharing these insightful answers with us, and also letting us to know about so much, not only just the H1B modernization rule, but also about what we can expect in Trump's administration, and how everything can go. So there were lots of important points that we discussed in today's session, and
Mm.
I'm sure that you also liked it. So, Karen, would you like to give any last message to our viewers about this topic, or anything that you would like to share with our viewers?
Well, thank you again for having me on the show. It's an honor and a privilege to be here. And I just want to wish all potential H1B applicants good luck in the lottery. Get your documents together, get any expert opinions together sooner rather than later, because that's going to impact your registration.
Absolutely. And to have an expert opinion, I would like to recommend attorney Karen Lee Polak contact details. You can go ahead, friends, and give her a call. That is 214-504-1227. Or it would be best if you could email her on the email ID that is KarenLP at polakimmigration.com. With the website, also you can go and visit her website. That is www.polakimmigration.com. And with that, thank you so much, Karen, for joining us today. It was our pleasure, and we are really happy that you joined us, and we will definitely have more sessions together. I hope we will have, right?
Wonderful. I enjoyed it. Thank you very much.
Thank you so much, Karen. And thank you
Take
so much, everyone, also for joining us and asking these questions and commenting here. It really gives a lots of motivation that you people are watching us right now. So that's all. Thank you so much, everyone, and stay
care.
informed, stay connected, and also don't forget to like, share, and subscribe to our channel. We come up with lots of information and lots of webinars with different attorneys, and we'll make sure to let you know about each and every details, each and every updates that's happening in the world of immigration. So thank you
Thank
so much
you.
for joining, everyone, and
If
thank
you
you,
can share
Karen, too.
this,
Yeah.
if you can share this with me, that would be appreciated.
I would definitely do that. And we will be happy to share that as well. So, anyways, I think now it's almost time. So, thank you so much, Karen. It was lovely, wonderful having you again. And thank you so much to our viewers also. Good luck and take care, everyone. Bye bye.
Thank you. Bye bye.
Bye bye.
Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa, and I'm here with another webinar for you. Very exciting one. It's going to be very insightful. But before we head on with today's topic and who's going to be our guest, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, we are streaming live right now on YouTube, LinkedIn, Facebook, and on X. So, please feel free to join us by commenting in whichever platform you're watching. And better even, you can join us on call, and our guest is going to be here. Maybe you can ask your questions directly by joining us on this call. And the number is 425-436-6335, and the access code when they ask for it is 988-888. And once you're in, just speak. We will be able to hear you. So, thank you so much, friends, for joining us. And yes, today's topic is actually a very, very significant one, especially to the Indian community, in the United States. So, what do the 2025 US visa rules mean for Indian workers and students? That is our topic for today. And the new rules, especially with regard to H1B, are really creating curiosity among all the folks out there. And understandably, some are concerns about what lies ahead, especially for Indian workers and students. So, to help us, get insightful knowledge about this today, we are going to be joined by a distinguished guest, none other than attorney Justin Rivera, a renowned attorney from Walston Immigration Litigation. And he has years of experience, about different complex immigration policies. And Justin is going to be here to share his valuable insights on what these changes mean and how can we prepare for them. So, without further ado, please help me welcome attorney Justin Rivera from Walston Immigration Litigation. Hi, Justin.
Hi, Nipasa. How you doing today?
I'm doing great, and this is our first webinar in 2025, so I'm very excited. I'm really wishing you a great year ahead, and yes, I'm looking forward for the session.
It's gonna be busy.
It is indeed. So maybe you could give us an overview, what can folks expect from today's session?
Yeah, well, I think, we'll all continue to delve into our crystal balls over what we can expect with this year, with the caveat that there's a little bit more information now kind of starting to trickle out. As we
Mhm.
were talking about a minute or so before we started talking, I actually just got off another call that was a pretty extensive webinar with people who actually worked in the State Department and at some of the consulates around the world during the Trump administration. So it was a very insightful opportunity to kind of learn a bit about what it was like under Trump's first administration, what things were done, and how those policies were implemented and rolled out. And they also ended by talking about the relationships that they have with people who are going to be going into the next administration, going into this iteration of the administration. And so if you guys will humor me for about 2 minutes, I did want to kind of give you guys kind of a peek behind the curtain, because this was a call that was particularly for attorneys, more so for all of us to get ready to think about challenging things through litigation or devise new strategies to kind of deal with what's going to change. So I'm going to be looking at the notes I took, which were very interesting. Biggest thing that I wanted to kind of bring back, there's been talk about the travel ban. Will there be another travel ban? It looks like yes. Pretty much it seems, if not set in stone, then absolute, then close to, that there's going to be some new iteration of the travel ban that's released shortly after the inauguration. The thing that seems to be up in the air is about whether the travel ban will be a set number of countries, specifically countries like Iran, Iraq, Libya, Somalia, Sudan, Syria, Yemen, or if the Trump administration is going to ask DHS to create their own process where they would make a list of countries based on whatever prerogatives there is that they think are necessary to create this travel ban, or Muslim ban, whatever you'd like to call it. So the travel ban is going to come back. It's just basically what countries are going to be listed on it. I guess we'll have to wait and see. It was really interesting to talk to some of the consular officers who were a part of the last administration about the travel ban. The way that travel ban initially worked, it was a lot of stop and starting, meaning, it was instituted, it was stopped, it was instituted, it was stopped. There's a lot of confusion, not only at the consulates, but even at CBP. I think people, if you remember, there was, days where there were protests at airports because people were not being let into the country because of all of this confusion over who was admissible and who wasn't admissible. The consulates had the same kind of insanity. My understanding is they basically were given a short memorandum and told, hey, 72 hours, this is going into effect, and you're going to have to figure this out. One officer actually went so far as to say that it was not until 6 months into the implementation of the ban that they received a formal training, which I think anyone in any profession would have to say that's insane,
Insane.
But the fact of the matter is, we saw with this previous administration, it's a lot of just shoot first and ask questions later. We're going to go try and do X, and you figure out a way to make it work, or it gets stopped and then we move on. So kind of moving on from that, extreme vetting coming back. The Title 42 ban. The Title 42 ban was previously used during COVID at the southern border as a reason to deny entry to migrants because they were in a country that had a communicable disease. COVID obviously was the name of the game there. There is talks that they're going to attempt to use that again. What communicable disease they're going to use, I'm not exactly sure. I know bird flu is really hot right now. Lots of people scared of bird flu. Maybe that. But that looks like it's something that's going to come back as well. Things that are important for everyone and not just specific nationals. Interview backlogs. Hoping that those will be improved, but I was not very hopeful from the call that I was on that that's going to be the case. Interview waivers being removed. There was talk about what were the easiest ways to make the immigration system function worse, meaning making it more difficult for people. The removing of immigration waivers, which was something that did happen in 2017, is an easy way to make a slow system even slower. So that's a possibility as well. And the last one really hurt me, honestly, because I thought it was one of the things that the government actually had done well, the removal of the domestic visa renewal program. Sure, some people are aware that there was an implementation of a pilot program for the domestic visa renewal. It saw, tons of positive feedback from the community. And of course, that would make sense that if it was a positive thing, it'll be taken away. So those were some of the big things that were noted during the call that I thought that was really, really interesting to bring up. If you're a Russian foreign national or a Chinese foreign national, get ready for, enhanced vetting, probably an increase in the provision of 221Gs. That's going to come up as well. A really interesting facet was the idea of moving consular processing to DHS from the State Department. That argument was basically done under the guise that the State Department isn't adequate or equipped to handle consular processing, and so it should all be brought under the purview of DHS. That's really interesting because it would kind of change the game on how everything worked. Because then you're looking at basically USCIS kind of holding all of the cards. And I'm not sure if that would be beneficial because it could open them up to more scrutiny from a litigation standpoint, or it would be harmful because it'd make it easier to implement more restrictive policies. That would require statutory action, though. So that's something that's not a day one sort of implementation. That's something that would have to actually be thought out. The last stuff, which was kind of the hot button issue that I think everyone was aware of during the election, is the challenge to birthright citizenship. Realistically, like I've said, and I will continue to say, I don't think this is something that could really happen. I would be surprised if it did. But what the people on the panel brought up, which I thought was interesting, was you're going to see more of an attack on this idea of birther tourism. So what birther tourism essentially is this idea that you're obtaining a visa for the reason of entering the United States to have a child in the U.S., because if the child is born in the United States, they're a U.S. citizen. So the idea is making it more of an issue at the consulate, making it more open for consular officers to deny visa applications to individuals that are pregnant unless the travel to the U.S. is done so for medical reasons. And right away, and I don't say this to be crass, I'm being genuinely honest. Right away, I thought, and I even asked the panel, so do the officers then have to just make decisions on who looks pregnant or who doesn't look pregnant? Do they assertively ask someone if they are pregnant at the outset of every interview, if that person is capable of birthing a child?
Maybe there will be a pregnancy test too.
Maybe. So, but what they actually came back and said was the consular officers, by and large, they likely don't want to do this because it's an uncomfortable thing. But you know who'd be psyched about doing it? CBP. Apparently, CBP officers seemingly have no problem with doing something like that and would be more than welcome to refuse someone entry to the United States under this guise. Now, I don't have a bad opinion of CBP, but if I could kind of give you an idea of what I deal with CBP on average, I had someone on Monday night in secondary inspection for 3.5 hours because they were related to an employer that had been found guilty of fraud. Now, this person had gone through a lawsuit in which they had won the lawsuit, their fraud claim had been removed, and they were carrying with them a copy of the document that confirmed that the fraud finding had been removed. Despite all of that, secondary inspection detainment for 3+ hours. So my opinion of them is not very favorable, in that I feel that they abuse their powers, and I feel that they definitely make an effort to target not even people of certain nationalities, but people with certain immigration history backgrounds, people that have been in the United States on F1. I think they're much more diligently going after those people than somebody who, is just coming in on an H1B. All that being said, my understanding of all of this was the restrictions on birthright citizenship would outright be very difficult, but there's ways to get around that, and I think it's something that they're going to try to take advantage of. One person made a very interesting point, and they talked about passport applications. And I had never thought about this before until this person had brought it up. They said, what if there is an implementation of a process to determine if someone is a U.S. citizen for the purpose of obtaining a passport? Were their parents on visas when they entered the U.S.? Or something like that. That isn't necessarily stripping them of birthright citizenship, but is creating mechanisms and systems that are in turn going to make their life more difficult. That might be something that we're going to see. And so all of that, which I've taken up, 10 minutes of our hour with that, all that was to say, I just wanted to relay that information while it was fresh in my
That was,
mind.
great information, seriously, and latest information, great updates. I think we shouldn't have missed, and we are lucky that you were a part of that webinar and you have so much information to share with us today. Justin, thank you so much for that.
You're welcome.
And what
And with that
how is
being said,
it?
we
Sorry, please
sorry.
go on. Carry on.
No. I think we had a little bit of a connectivity issue. No, I was just saying. With that being said, I know we had a couple questions we wanted to address today, so we can turn to that if
Yes,
you're ready. It's
yes, but from what you have shared, it really sounds like, Trump 2.0 is going to make everything more complicated, more lengthy, and a lot of scrutiny. They're going to make it difficult, and seems like there are going to be longer wait times as well. So let's see what's going to happen.
Mhm.
All right, so Justin, let's head on to our topic and some questions that we had prepared. So, my first question to you is, what changes in February 2025 visa bulletin will benefit Indian students and even professionals who are applying for US green cards?
So I did take a moment to look at the visa bulletin before the call. The February bulletin's actually already come out. Usually does around middle of the prior month anyway. There was some slight incremental growth. I think your EB1 still sitting at Feb 1, 2022, which isn't terrible, but not the best. EB2, you're looking at October 15, 2012. EB3, December 15, 2012, and you have your final action dates being used right now. It's very slight, very minute incremental growth. I don't know if we're going to see much change moving forward with this year in that regard. I think there's a lot of people putting their eggs in the Doge basket, which is like quiet. Which is like this idea, that there's going to be an increase in government efficiency, particularly within employment-based immigration, because obviously there's been signals from this administration that there's a favorable view of the employment-based visa programs. I know the H1B has gotten a lot of particularly love recently, or hate if you're on the other side of it. But how that relates or doesn't relate to what we're actually going to see with the visa bulletin, it's kind of a wait and see. We're going to have to see what happens and if there's any sort of big changes planned. I know that there was this idea that it's just something that was floated by Trump, which get ready to go back to that, right? This guy says something, we all think, what does that mean? And then we pretend we know, and then we see what happens. But I know there was an idea floated about tying H1B visa sponsorship to a faster green card path. Obviously, if that's possible, I'm all for it. Let's do it. But until somebody actually sits down and says, this is how we're going to do that, we're stuck with the systems that are in place presently.
Right. Right. Thank you so much, Justin, for taking that up and for the update for Indian nationals. So EB1 looks good, and the others still just have very slight changes. Thank you for the update. And let's go on to my next question to you, Justin. And there are so many new rules coming up, US visa rules. And do you think that there are new opportunities for Indian students who are looking to stay in the US after graduation?
So I think for people that got, that get picked in the upcoming lottery, they really got lucky with the cap gap extension, because that's legitimately beneficial. Previously, the way cap gap worked is basically if your case was selected and you were working subject to work authorization, you had a gap. Basically, let's say your STEM OPT ended in May or something like that. If you had a timely filed H1B change of status, you were able to continue working all the way up to 10-1 on what's called cap gap. However, that ended on 10-1. So unless your case was approved by then, you would still be able to stay in the United States, but you would lose your work authorization. The problem with that is if you're an employer and you have an employee and the employee can't work, why are you going to keep the employee? So what I thought was a very interesting and beneficial move from the DHS was they moved it to April 1st of next year. And what that does is it no longer puts pressure on the employer and the employee to rush to get that case approved by 10-1. A lot of times what you would see is the wait and see filing and regular processing around, May, June, whatever. And then a rush to upgrade to premium in September, because everyone needed that 10-1 work authorization. Now that that's not the case, I think you have two circumstances. The employee continues to have that work authorization until April if they don't want to pay the 2805 for premium, the employer. And CIS no longer sees this mass strain where they're having to prioritize all of these cases and instead can just allocate their workload accordingly, keep it at the same level. The other thing that I think was legitimately beneficial was the ability to move the start date. Most of the time, all the time, 10-1 was the definitive start date. First date you're eligible for H1B, 10-1. Looks like now you have more wiggle room. You can move that back. And I think that that's great for someone who has, let's say maybe another 8 months, 10 months of STEM OPT that they want to utilize before they start that 6-year clock on H1B. I think that's a benefit as well. So I think we've gotten some good wiggle room, things that are going to be helpful for anyone transitioning from F1 to H1B, and that should give people more opportunity. The other thing that's beneficial for graduates, they have expanded the qualification for CAP-exempt employers. For anyone who lacks familiarity, CAP-exempt employer is an employer that is able to sponsor an individual for H1B without that individual having to go through the lottery. Now, it was fairly restrictive to basically like nonprofit organizations and research institutions, universities, things of that nature. They have opened the door so that individuals are now able to work with companies who are maybe placing somebody at that research institution, or maybe they're working for a company who not all of their job falls within the prism of the nonprofit or whatever service it is to be CAP exempt, but what they're specifically doing does fall within that prism. It'll be interesting to kind of see how those rules are implemented and how that dynamic is shaped once those cases start to get filed and there begins to become precedent, essentially. But I think that it's beneficial, and I think it's going to hopefully open the door to more people being able to obtain H-1B sponsorship without having to go through the lottery, which does cap at $85K every year.
Yes, definitely. And these are some good news. Thank you so much for the updates, Justin, and for the detailed explanation. Thank you for taking that up. So now I have another question, and that is with regard to permanent residency. So how will the surge in visa availability this year, 2025, affect the timeline for Indian nationals who are awaiting permanent residency in the US?
Um, can you hear me okay? Uh-oh, I think we had a connection issue.
Are you able to hear me? So my next question is on the screen already. It is, how will the surge in visa availability in this year, 2025, affect the timeline for Indian nationals, who are awaiting permanent residency in the US?
Yeah, I can't really see anything.
Yes, we can hear you, but Justin, can you hear me? I really hope there's some connectivity issues though at your end. Really hope that. Maybe you can just rejoin. Yes, that'll be great. So, folks out there, thank you so much for joining us. In fact, you can even contact Attorney Justin Rivera. He's going to join us very, very soon, immediately, I guess. And what you can do is call him up on his number or even leave him an email. But definitely go check out Wasden Immigration Litigation in uh, LinkedIn. And his phone number is 844-592-7336, and that's where you can call him. You can even email Justin at support@wasden.law, and go visit www.wasden.law to get to know more about Justin Rivera. And Justin is back, so I think yes. Let's take up the question. I'm going to repeat, Justin.
I got
So
it.
yeah, thank you so much for just coming back. So my question is, how will the surge in visa availability in this year, 2025, affect the timeline for Indian nationals who are awaiting permanent residency in the US?
So, I mean, I'm hoping that people who have that 485 filed or close to filing, they're going to at least see a timeline drop. I mean, you can even go look right now, and if you even Google it just off the top of your head, and you're like, what's the timeline for I-485 processing? You're looking at, like, I saw 8 months to 2 years. I mean, it's so ridiculous that they're not even willing to put out a defined timeline. That being said, this is where I'll kind of hope that we do see an efficiency boost as a result of the administration change. No offense to the Biden administration, but I don't think they did the best job at processing these green cards. That's just my opinion. I think you could see it. I think that there was a lot of times where these cases dragged on for a long time. And yes, people have the opportunity to work subject to an EAD. And yes, they can travel with AP. And yes, they can remain in the United States while their case is being adjudicated. But they're in the United States in a constant state or a near constant state of worry, because unless they've remained on their non-immigrant status, their future is dependent on the adjudication of the 485s. I'm hopeful that with this suggestion that there's a favorable view of employment-based immigration, that we're going to see 485 processing become more streamlined. That is a hope and not a certainty. You could even say it's a wish, but it's something that I would like to see, because I think it's an area where they could actually implement fairly quickly changes that are going to help streamline something. I think for a lot of these employment-based cases, these 485s, it should just be a quick review of immigration history. I mean, 9 times out of 10, you're not dealing with somebody that was a member of a terrorist organization, or has ties to a questionable community, or entered the country in an unauthorized status. All of these people are typically people who have come to the U.S. legally, have remained in the U.S. legally, and just want to move over to a green card holding position so that they're not constantly having to renew their H or whatever that they're on. So I'm hoping to see processing improve. From what I explained earlier, I don't know if that's going to be the case at the border. I mean, at the consulates, but maybe with USC.
Okay, okay. Thank you so much, Justin, for taking that up. And, we have a lot of Indian workers who are working or are looking for jobs in the tech and healthcare sectors. So, if you could update us with what new visa rules that are coming up this year, 2025, that they need to know about, especially with regard to green card and processing times. I think we lost Justin out there. But folks out there, thank you so much for joining us. Hi to Yash and Sneha. You can even join us on call. You can dial this number 425-436-6335, and the access code is 988-888. It'll be really great to have you here. And I think we should take a short break. Oh, and I think Justin is back actually. So, yeah, Justin, something is wrong with the internet today, but technical issues are always there, I think. Anyway, so were you able to hear what I was asking? And even if not, I'm going to repeat the question. And the question is, we have a lot of Indian workers in the healthcare and the tech sector. So, and there are new rules and updates this year, 2025. So, if you could tell us what they need to know, especially with regard to green card processing times. Are you able to hear me, Justin? Looks like some bad connection out there, but we really hope that Justin can be back, So, of control, if you can just maybe guide him a little bit.
what's happening, guys. I'm
But we're
trying.
just glad you're back somehow. Uh, are you able to hear me properly?
I can hear you, and then what keeps happening is I can hear you for like the first 15 seconds, and then you freeze up, but I still have audio, and then it says oops and kicks me out. Now, I just closed out a bunch of windows. I did have Zoom open still, so I don't know if that was a problem.
Probably.
But I got rid of that, and I'm hoping maybe that helps. I did get a message from Xfinity, who's my internet provider, who conveniently has decided that they're going to be working, which is like the worst possible timing. See, and there we go again.
I know. But as long as you
So
can hear me,
I
I think we can
Yeah,
carry
I
on.
think, sir, control here. Sir, I think this is a bit of your connection issue. Did you try clearing your browser's cache?
no, it's
Maybe,
me. It's my end.
and maybe try to remove
Yeah,
close all the windows, and then we can pick it up from there again. Nipasa, let's go for a break.
Thank you, folks, for being patient, but stay tuned on Immigration and Jobs Talk Show because we have Attorney Justin Rivera from Wasden Immigration Litigation. And don't forget to go check out Wasden Immigration Litigation on LinkedIn as well. So, yes, let's go for a short break and don't go anywhere.
I'm back. Maybe. We'll see.
Welcome back, sir.
Wait 5 seconds and then we'll know.
No, let's not wait as long as it's working. So let's go for it. My next question for you, Justin, is that, we have a lot of Indian workers in the tech and healthcare sectors, and there are new rules and updates this year, 2025. So if you could tell us what they need to know, especially with regard to green card processing times.
So, not so much for tech, but I would definitely say for healthcare, I think that there should be a really close look at the new changes for cap exempt employers. I know that healthcare was definitely one of the institutions that people could attempt to utilize, especially for those hospitals that are connected to universities for cap exempt employment. So I think that with the expansion of the cap exempt rules, hopefully that gives even more opportunity for people in healthcare to find an alternative to having to go through the H1B lottery. Tech, we're going to have to kind of see what happens with EB2 NIW. For people that are familiar with the national interest waiver, it's one of those few ways where someone can actually self-petition for a green card. Really kick off that process. Now, that being said, I have heard through the grapevine, if it's not one thing, it's another. I have heard through the grapevine from people who specialize in EB2 NIW that we've actually seen kind of a more stringent application of NIW over the past couple of months that could correlate to a little bit of oversaturation in the market, particularly from individuals in the tech industry. And what I mean by oversaturation is you have bad attorneys filing bad cases. And what that has done is put officers on guard, essentially, put them in a circumstance where they're saying, oh, if this is a tech case, I don't know if it qualifies by virtue of the fact that, 5,000 other people in the tech sector think that they qualify for an NIW. So I will be interested to see if there are any changes policy-wise that are made for NIW, especially for tech, when we're going into next year. Because as we've heard from Elon Musk, who seemingly sits at the right hand of the president, tech is good and we need tech immigration. So that might be something where we see a little bit better of a path for people to getting green cards in tech.
Thank you so much, Justin, for taking that up. And looks like it's going to be good for healthcare sectors, even if not for tech yet. So thank you for that update. And next up, I wanted to ask, what are the key differences in the 2025 US visa rules and the previous years, and how do they specifically benefit Indian applicants?
So I think that kind of goes back to if you're already here and you're working on F1, that cap gap opportunity, the extension of cap gap, I think is going to be really positive. Um, I think that'll be very beneficial. Moving the start date, the fluidity of the start date, I think is going to be beneficial too for everyone. But you have a lot of Indian foreign nationals, Chinese foreign nationals that are on F1s that work subject to STEM OPT. Maybe they want to push that start date back, giving them an opportunity to remain on, their NIV, their F1 status. Where I think it's going to be interesting is part of the modernization rules for the H1B did include this idea of the bona fide job requirement. And the bona fide is allegedly a way for USCIS to adjudicate the viability of an H1B petition based on the fact that there must be a bona fide position available for the person that's a specialty occupation.
Mhm.
And how does that work against moving a start date? Or how does that work when you're filing a case in, let's say, April or May, and the start date of the H1 is October 1st? Supply documents that show that there's going to be work available on October 1st, or by virtue of the offer letter showing that you're providing the position to the person, is that enough to get you through the gate of this bona fide job offer? If you're only able to provide state orders that show that there's only work available for 6 months beyond the start date. USCIS is claiming it won't, but it's also claiming that it now has the right to request all of those documents in order to determine whether the position is a offer. So I think things are going to be wacky for the first 3 or 4 months. I think where decisions come out as officers begin to play with these new definitions. Hopefully it's all more established by the time we get to quota and people are filing those initial H1Bs, to go through the cap. Because cap denials are always terrible because you only get so many shots at the lottery. But yeah, I think the one thing that I've taken away from this is there are things that I like that have been changed. I do not like the bona fide job requirement change, and I'm hoping that it's something that sees litigation pretty quickly after it's implemented.
Absolutely. I think, yes, we will have to have some buffer time. I mean, Trump is only joining after 5 days. So after he joins, we will hear a lot of rules coming up and more updates. So we'll just have to wait a little more and see what's coming up in 2025.
Well, and it's wild. You think about it. These new policies, the H1B modernization, they were going into effect whether or not Trump won. They go in on 1/17.
Right.
That's on
Yes.
Friday. And then the following Monday, his administration's inaugurated. And then I'm assuming they start issuing EOs on the 21st or the 22nd. So there was already change that was going to happen regardless of who was president, whether Biden won or Trump. And now on top of that, there's a new administration. So yeah, I definitely think it's going to be a crazy first 2 months. I cannot imagine middle of January to February being fun for anyone in this field.
So true. So true. And yeah, everything is planned, and we'll just have to wait what they're going to throw at us. So thank you, Justin, for that. And I have
Yeah.
another question, and that is if you can explain, if these 2025 updates, can ease green card process for Indian nationals who have been waiting for years, all these backlogs.
So yeah, I think like I said, you'll be seeing a wait and see for the 485 processing. I think there's mechanisms that can be put in place that can actually speed up the issuance of the green cards themselves. Whether or not they're able to actually move the bulletin up, I mean, we'll see. I think that's going to take a little bit more leg room. I think it's a lot easier to just issue policy memorandums, to USCIS to say, look, if everything looks good, just approve the case, rather than going into enhanced vetting of a process. I do think that barring any weird changes made by Stephen Miller, we should see hopefully a pretty streamlined lottery this year. I think, the beneficiary-centric lottery It was done last year. It seemingly has worked in that it's vetted out the ability for multiple registrations to occur, which is a problem that USCIS had. So I think that hopefully we see a better lottery process with the introduction of the extended cap gap and the moving of start dates. I'm hoping that there's less stress on filing for everyone. So I'm hopeful for all of that. And I do think that that'll be beneficial. I think for Indian foreign nationals, they do typically represent a large amount of the individuals that are selected for H1Bs. So I think these changes will specifically benefit them. So it's just, we'll have to see, but I do think that that'll help. Deference, I think, will be a big thing too. Part of the H-1B modernization is that we're supposed to be reinstituting deference. So if an extension is filed for, an H-1B visa and it's the same employer and the person's doing the same job, it's supposed to be a quick approval. You're not supposed to be rehashing old issues. So I'm hoping with that being instituted as well, we should see very quick approvals for people that are on extensions. I think the people that are hopefully that are going to be in the best circumstance are going to be people who are, they've already got their I-140s approved. They're maybe waiting for their opportunity to file their I-485, but they're just staying with the company and they're just working with that company, waiting for their time. Hopefully they get to just kind of run through the process and they're okay. And administrations are only 4 years long. So in theory, you should only have one extension. So yeah, but we'll kind of see how that goes. I think the other thing which I brought up on previous conversations is the entrepreneurial H-1B.
Yes.
This idea of people being able to do H-1Bs for themselves now, as their own owner of their own company. I think that's going to be really interesting and can be really helpful for someone maybe that's an Indian foreign national who's maybe been working in the industry for a couple of years and wants to strike out on their own. And they want to take an opportunity to open their own company or organization. That being said, I reserve the statements that I've previously made, which is those are only approved, I believe, for 18 months. Lots of new businesses fail. So we're going to have to see what those extensions look like. But I'm eager to work on those. I will promise you guys this. When I get my first entrepreneurial H-1B approved, I will let you guys know about it.
Thank you so much, Justin. And I do hope H2B is where Indian nationals are excluded. So I do hope that doesn't happen with regard to H1B ever. So
No way. What would they do in the tech sector if that were to happen? It'd be insane. No way.
all right, Justin, thank you so much. And I think we'll take up a few questions from our audience, and we have about 10 minutes from you. So let's take up some Facebook questions first. Control, if you can display them, please.
If I can stay online.
I really hope so. But yes, meanwhile, let's take up Yash's comment. And he's saying if the cap of H1B visas gets stricter, should Indian students like me consider applying under different categories like O1 or EB2 What's the realistic timeline for these pathways? Maybe you can give a comparison.
Yeah, so I mean, like I said earlier, the NIW, I think your biggest issue is scrutiny that you're going to receive from USC. Right now, I've heard that the scrutiny is pretty high on those cases. I think you're going to have to prepare work with a pretty knowledgeable attorney, and hopefully you end up coming out with a positive adjudication. But like I said, NIW, I've heard from others. I don't do very many of those cases. I really try to only take them if they're surefire wins. I've heard from others who dabble more so in it that the decisions are getting wacky. They're getting weird. There's cases that seemingly look like they should be approvals that aren't getting approved, or cases that are getting requests for evidence that seem like dead ringers. The O1 is one of the most heavily scrutinized NIV applications, okay? Can you qualify for an O1? Maybe. It really depends on who you are and what you're doing. Is it easy to qualify for an O1? No. Qualify coming out of school. You have to meet the though to do so. I would tell looking at an O1, you can look online. Go to USCIS's website. It's going to tell you the requirements. Ask yourself if you fall into enough of those boxes to qualify for an O1 before you're going to move forward. Benefits of an O1 are pretty immense. You don't go through a lottery. You're not subject to a labor condition application. And your company, if it's a startup, can even pay you in equity rather than having to pay you, high salary. So there's definite benefits to it. The caveat to that is that the O1 is going to be more difficult for you to get than an H1B. It's just going to be seen as a higher level of scrutiny. You can get them. Again, no one should file an O1 on their own. I would work with an attorney, make sure your case is set up from the outset, and move forward so you can get it done. I would say for anyone in the next couple of years, if you're going to be applying, if you want to do an O1 in the back of your mind and you're on F1 and you're trying to apply in the lottery, work on your resume for your O1 in tandem while you're building your H1B up. That way you're able to apply in the lottery. If you get selected, great. If not, you've got that O1 in your back pocket when it comes time. Maybe you're in year 3 and you're not sure if you're going to get selected or not. Register in the lottery and file the O1. Just do them both and see which one can work. But start working on that. You should be working on building up your O1 resume when you are finishing college, not the 3rd year where you're in your last year of STEM OPT.
Okay. Well, thank you so much, Justin and Yash. I hope that was very helpful. Thank you for participating. Let's take up our next one. This is from Sneha. Uh, Sneha is asking, will the potential changes in wage levels for H1B applications make it more expensive for companies to hire Indian workers? And how should we prepare for this impact?
I mean, you're going to have to see if that's an actual implemented policy where the wage levels are moved up. This has been something that's been toyed around with last time Trump was in power, and now it's probably going to be rehashed. The easiest way to make the H1B program less appealing is to make it harder to qualify for an H1B and make it harder for a company to pay someone an H1B. I think at the end of the day, if you raise wages, the people who are weeded out are the smaller organizations. Bigger companies aren't going to really care if they got to pay somebody $20, $30, or $40,000 more dollars. It's not hurting their bottom line. The people that care are the 25 and under employee companies, where that's a big thing, a big decision to make, whether or not you're going to pay this guy $40K more or maybe pay a less qualified person who you don't have to sponsor. And so that's kind of what becomes the issue. I think when it gets to that point, you're going to have to really start looking at what are the benefits that can be provided. I know that there are certain, and I'm not a tax lawyer, so please don't, pretend I know these things. I know there are certain tax breaks that people can get for someone that's on an H1B if they've only been in the United States for a set number of years. Look into those policies, see if that's something you can present to your employer as a way to recoup fees, if there is an increase in the amount of money that has to be paid. That being said, there's not really a great workaround because the wages are set if the wages are set. So if you got to pay someone X amount to be a software developer in Austin, Texas, that's what you have to pay them. If they're a level 2, you pay level 2, level 3, etc. But we'll kind of see what happens with that. I can't imagine that a business-oriented individual who has the ear of the president, that would be, Elon and Vivek. I can't imagine those individuals would seek to make companies pay more money for employees. So we'll see. But that would be it. I would just say you're gonna have to find workarounds to make yourself look more appealing in that circumstance.
Right. But thank you so much for taking that up, and thank you, Sneha, for participating with your comment on YouTube. So we'll take a couple more questions quickly, and Control, if you can display them, please. So this first one is my initial H1B was expiring on September 30th. Employer put in an extension for a few days before under premium processing. I received an RFE for maintenance of status since I got laid off by the end client, and my employer did not run payroll for 2 months. Now the employer told me they respond to the RFE. The deadline is 10th January. What are my options now? I'm really worried. Can I convert to B1 or F1 visa?
So not real. I would say a couple of things. First off, I would say you should report your employer to the DOL, because if you are still in the U.S. working subject to an H-1B with the employer and they're not running your payroll, that's a violation. I don't know if they're I don't know if they're operating under the guise that because the extension's not approved, they don't have to pay you. But at the end of the day, USCIS views maintenance of status pretty solely through the prism of, are you getting paid by your H-1B employer, and are you working where the LCA says to work? If you're not getting paid by your employer, you can't show maintenance of status. Yeah, I mean, it's very difficult for you to attempt to file a change of status to another status right now, because you're going to run into the exact same problem. At the time of filing, how are you maintaining status? If you couldn't show that at the time you were filing your extension, you can't show that now. So I would probably say, post a bag. Period of stay authorized by the Attorney General allows you to remain in the United States up until it's denied. If the only issue on your case was maintenance of status, they should approve your H-1B, but deny the I-94, deny the extension. So what that means is you should have an H-1B that you could subsequently utilize if you still have an active visa, or if you have to go abroad to get a new H-1B visa stamp, you could do that as well. A problem, though, with all of this is if your employer's not paying you, I'm not really sure how you're employed with them. So even if your H-1B gets approved for consular processing, the denial of the maintenance of status goes into your immigration record, and it's going to be available at the consulate. It's going to have to be something that you can explain. So you're going to need some sort of new support letter from your employer explaining that they intend to bring you back. That all being said, I don't really know what the employer put in your RFE response that was due on January 10th. So we would kind of have to wait and see there too. So I would say this: you need to see what the decision is and abide by the decision. The decision is denial without the H-1 being approved. You need to timely depart the United States and apply for a new visa abroad. If it's an approval of the H-1B, exit and take whatever steps are necessary to reactivate your H-1B to come in, and then you're going to have to work with your employer on that. But I would not really recommend filing an attempted change of status at this point to a B1 because it's just you don't have the ability to prove that you're maintaining status.
Right. Thank you so much, Justin, for taking that up. And all you folks out there, thank you so much for tuning in today. And a big thank you to you, Attorney Justin Rivera, for sharing your expertise today with us.
Thank you. Before we go, because I saw there was a couple of questions about F1. Oh, apparently I won't be allowed to. My connection is lost. Well, if you guys can hear.
Yes, we can.
Let me see if you guys can.
We can hear you.
Yes, sir. We can hear you, sir. No problem. Go ahead.
Nope. Again.
Oh, good. Sir, we can hear you.
All right. So I would just say thank you so much, all you folks, for joining us. And yeah, Justin, if you can just wrap up what you have to say before we leave.
Real quick, just a quick thing about F1. People who are looking at F1 status. OPT, initial ownership, not on STEM OPT. So no one should be taking unpaid internships on STEM OPT. I've seen a recent uptick in RFEs on that. OPT, you can take an unpaid internship. I have seen 2 decisions now, not my cases, for other people, where USCIS has denied STEM OPT, saying that the OPT employment, the unpaid internship, should have been paid. And they're using an interesting justification to do that. They're basically looking at employment law and basically saying they're kind of making up what can and can't be an unpaid internship, which is kind of crazy, but it's denials for these people. These people that are going for STEM extensions, their STEM is done. So they're in a bad spot now because they're now not able to get that extra 2 years. So what I mean by all that is this: everyone moving forward, be careful with working on an unpaid internship while you are on F1. I would recommend staying with paid if absolutely possible. If unpaid, work with your school to make sure that it's going to fall within regulatory requirements.
Okay.
And that being said, I am done. Thank you all very much for your time.
Thank you so much, Justin. Really, we had some great updates, and we're really lucky that you could share them with us today. So really a big thank you to you, Attorney Justin Rivera from Austin Immigration Litigation. I'm really looking forward for our next episode already. So thank you once again. You have a great day ahead.
Absolutely. Thank you. Pleasure speaking with you guys. Y'all have a good one.
Thank you. Thank you, Justin.
Bye.
So, folks, don't forget to like, share, and subscribe if you resonated with today's episode and you liked our insightful webinar with Attorney Justin Rivera. And yes, thank you so much for tuning in today. Don't forget to also hit the bell icon. Uh, we are Immigration and Jobs Talk Show, and we are on YouTube, LinkedIn, Facebook, and on X as well. So please feel free to connect with us. And you can also email me, and my email address is neepatstaffingme.com. And yes, connect with Attorney Justin Rivera. You can call him up on his number, and his phone number is 844-592-7336. And you can email him at support@wasden.law, and go visit www.wasden.law to get to know more about Wasden immigration litigation and Attorney Justin Rivera. Once again, thank you, folks, and stay tuned on Immigration and Jobs Talk Show, because I and Sam are going to come with a daily immigration dose at 4 p.m. Eastern Time. So until then, you guys keep having a great time ahead. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm really happy to be here. I'm Nipasa Pradhan, your host for today's session. And before we start off with today's webinar and we have our guest join us, I have this very important disclaimer. And that is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are live right now on YouTube, LinkedIn, Facebook, and on X. Please feel free to join us by commenting. And another best thing is that you can join us to even have a one-on-one discussion or maybe ask a question to our guest directly by joining us on this phone number. And the number is 425-436-6335, and the access code is 988-888. And once you're in, just speak. We will be able to hear you. So, yes, today's webinar is on this very, very important topic about, How is Donald Trump's proposed 2025 agenda, and how could it reshape the immigration policies in the US? So it's going to be very nice that we are going to be discussing further on this, all the way from the stricter border measures to potential changes with work visas and even family-based immigration. So everything about immigration today here and what we can expect this year 2025. And to help us make sense of this topic and this discussion, we have a very, very special guest today, and she is none other than attorney Ingrid Perez, who is an experienced immigration expert and an advocate who has guided countless individuals and organizations through the various complexities of US immigration law. So, Ingrid, welcome back. So good to have you back. So good to see you. And it's a pleasure to have you on our show.
Likewise, thank you for having me again.
Really good to see you. And I wonder, how's everything going at IBP Immigration Law?
We're very busy, starting off the year really well. Thank you for asking. And our team is growing, and we are excited for a very interesting year ahead for sure.
Me too, me too. And all the very best. Let's hope 2025 is going to be awesome. So, all the best to you and everyone out there at IBP Immigration Law.
Thank you.
So, coming back to our topic of discussion, Ingrid, if you can just give a short overview, to our viewers out there so that they can stay with us, as in what can they expect in today's session.
Sure, absolutely. Well, I think, based on the first Trump administration, there's a lot that we can predict that is going to happen. For sure, we all know that Trump is a critic of family-based immigration, and we can anticipate some additional scrutiny on requests for waivers for like that. And I think also heightened scrutiny for visa applicants from certain countries and in certain U.S. embassies. I think we can definitely expect that. There have been, reports of Trump wanting to implement some executive orders on day one, things like ending birthright citizenship, and deportation orders starting day one. So I think that is going to be something that he's probably going to focus on. However, we stand to see what's actually going to happen as a result of these executive orders, because a lot of these orders and policies can often be challenged in court. So although, Donald Trump may want to do all these things, I think there's also legal challenges and procedural challenges and practical challenges, especially when it comes to mass deportation. ICE and our infrastructure can simply not handle the level of deportation that he has promised. So it's interesting, it'll be interesting to see what happens with that promise.
Very, very well said. And this brings me to our first question, which is very similar and about the deportation and illegal immigration. So, how do you think Trump's 2025 immigration plans, especially with which is focusing on illegal immigration and even mass deportation, how's it going to affect work visas as well, like H1B and H2B for foreign workers, especially from India? Ingrid, are you there? Um, Well, I guess there is some connection issue, but yes, we are definitely going to take this up, and we would love you to join us also by commenting if you have any
I'm
questions.
here.
Yeah, I don't know what happened, but you were frozen for a while. Did you hear me
Oh,
ask
no
the
problem.
question?
Yes, I did.
All right.
So, in regards to the connection between the illegal or undocumented immigrants and the work visas, that's an interesting question, because immigration is really such an expansive area of, law. And we have work visas, we have permanent residency, and we definitely have a lot of issues at the border. And I think that, the Trump administration will focus on the priorities that he has promised, which is to curb illegal immigration, border crossings, and secure the southern border. A lot of resources have to go into that, right? We can expect a lot of resources from different federal agencies to be put into maybe perhaps building the border wall or implementing new technology to protect the southern border and close it up. So, as far as any direct impact between illegal immigration and visas like H1Bs or H2Bs, I'm not sure if there will be a direct impact, but if his promise is to secure the southern border, and that is going to take a lot of money from government, we can perhaps see longer wait times. And also, I think, in keeping with his promise of stricter immigration, more scrutiny on H1Bs and H2Bs.
Right. And when we talk about H2B, I think Indians are already out of the question. But H1B, definitely yes. So I do hope that it's going to be somehow better. I mean, people in his team, some are supporting it, some are not supporting it, some are against immigration. So what do you think is going to happen?
Well, I think, the conversation around H1B specifically has been really interesting, over the last few months. And I think that there's also a lot of wrong information out there about H1Bs. The conversation seems to be, centered around this idea that H1Bs are only for Indian nationals, which is not true. H1Bs is mostly used up by Indian nationals because of the per country limit on green cards. And unfortunately, Indian nationals have no choice but to be on H1B for years and years because they are lawfully discriminated against when it comes to getting green cards. And the backlogs are, insane. So that is just sort of, a result of this very unfair and unjust system. So we do have some level of legalized discrimination against Indian nationals and other people who fall outside of the rest of the world, column in the visa bulletin for sure. So, and this conversation around that H1Bs is only for tech workers.
For some reason, we are having a connectivity issue, but I do hope Ingrid is going to be back. And folks out there, please, participate as well. You also can join us by commenting in whichever platform you're watching. And we are live right now on YouTube, LinkedIn, Facebook, and on X. So please feel free to join us. And you can even join us on call by dialing this number 425-436-6335, and the access code is 988888. Today, we are speaking about how could Trump's 2025 agenda reshape U.S. immigration policies. And Ingrid is back. So sorry, Ingrid. Somehow there is some.
We'll deal with it. I mean, it is what it is, right? We'll keep the conversation going. But
You
I
can
think we
pick
were
up where
talking.
you-
Yeah, but going back to that very important conversation where we were talking about the misconceptions that this Twitter war has sort of unearthed, right? This idea that only Indian nationals have H1B visas, which is absolutely not true, and also this idea that only technology workers get H1Bs, which is also not true. It is true that many tech companies do workers and companies, nonprofits, universities, colleges, hospitals that have H1B workers.
Yes, for sure. And starting today, 17th of January, we have some new rules which we are going to discuss a little further, a little later in this show. So stay with us, friends. So, Ingrid, the next question to you is, if you could tell us what will the impact be, with Trump's proposed immigration crackdowns, which are going to be impacting temporary work visas as well, like H2B, and how will it affect Indian workers who are really seeking opportunities in the US?
Well, I think under Trump 2.0, we can expect a lot more scrutiny in the workplace as well, which is something that I think is important to talk about. The Trump team has talked about workplace raids, making sure that employers are employing people with work authorization. So we may see some of that as well. As far as the H2B, program itself, this program is already very highly scrutinized. Employers have to jump through lots of hoops to get H2B workers. I think that temporary visas like the H1B, the H2B visas, I'm unsure if we're going to see the impact right away, especially because I think that the initial focus will be on undocumented immigrants and perhaps the border. But we stand to see. I think that the tides have turned a little bit about the conversation with work visas, and we see Trump saying some things that are very different than what he said before, that he likes H1Bs and that he, uses H1Bs, even though I think really what he was talking about H2Bs, H2B workers in his hotels. So I think that, if the tides really are turning, there are definitely people within the Trump administration who don't want any immigration at all. But we stand to see, because I think there's lots of competing interests now with this new Trump administration.
Right. Thank you. I mean, yes, from what you have told us, very, very true. And thank you so much for, taking that up. My next question to you, I have is how could Trump's immigration policies, including mass deportations, though we spoke about it a little earlier, but if you could elaborate more, and stricter enforcement, with his team being like, we have the border czar and we have so many others in his team, and how are they going to affect Indian nationals who are already in the US and on work visas or student visas?
So I think Indian nationals in the United States with student visas will definitely be seeking opportunities to stay in the United States. And usually that is done through an H1B. And it is difficult to find an employer who is willing to sponsor you for the H1B. And getting an H1B in and of itself is difficult because we have a lottery that a person has to enter into in the in March of every year. And if they are, lucky enough to be selected, the employer has to file a petition. There are lots of hoops and jumps, and it is an expensive process that is controlled by the employer. So I think for Indian nationals, they need to be thinking about this transition from F1 to potentially an H1B very early on in their careers, taking advantage of any OPT, or STEM OPT time that they may be able to get, and really start thinking about transitioning to H1B very early on. As soon as they, start working. And I think that mass deportations and stricter enforcement, perhaps not so much mass deportation, but stricter enforcement, will certainly lead to greater scrutiny on H1Bs. And this new light that has been shed into H1Bs that unfortunately has a lot of misconception and a lot of, the Trump base upset with H1B workers and the H1B visa, right? We could see higher scrutiny in H1B petitions and perhaps maybe more denials like we've had during Trump 1.0. I think during the first Trump administration, the denial rates were a lot higher, significantly higher. If I'm not mistaken, I think I saw a statistic that in 2020 it was about 26.6%, as compared to the recent years where it was a lot better for H1B workers. So I think that starting early on, ensuring that the work and the employer that you are going to be working with is a legitimate employer, because there is a lot of, H1B fraud, and there is a lot of problems in the system. That is certainly true, and there's a lot of criticisms to be made and a lot of improvements that could be made. So I think ensuring that the student here who's in the United States seeking the opportunity is also very well informed and educated on the process and what they need, so that they can protect themselves from this heightened scrutiny. Because as we all know, the U.S. government doesn't give you a lot of flexibility if you're running out of time here in the United States, and that's really important to keep in mind. And have a plan B. If you're not selected for the H1B lottery, what are you going to do? Are you going to Canada, or are you going back to school, get back on your F1? Having a plan B is very important, because unfortunately, H1B is just not a reality for everybody. But, another possibility is exploring H1B capped exempt positions. And of course, these are perhaps a little bit harder to come by, and the employment opportunities, not so much, but that is a way to circumvent the lottery for those that are able to get a capped exempt job.
Right, right. And we also hear about the cap being extended from October fiscal year to the 1st of April the next year. And apart from that, we even heard like, schools are taking measures to not just give out their immigration status to anybody and everybody. Have you heard the news too, Ingrid?
Are you talking about giving I-20s to students?
No, I'm talking about, how the schools are protecting the students who are immigrants. And yes, the school rates. I'm talking about the school rates. And,
Oh, yeah.
have been, yeah.
So, I mean, there are places like historically that, like churches, hospitals, schools, where ICE is not supposed to go in and do immigration enforcement. So we'll see what that looks like. I mean, I think there's a lot of information out there meant to scare people and a lot of talk, but we just don't know. We're really entering a world of uncertainty. And I think that if it plays out in the real world where ICE is going into a place of worship or a school and doing these things, I mean, I think that there's going to be a lot of backlash. At least I would hope that there is a lot of backlash. And if Donald Trump and his administration are serious about, protecting US borders, perhaps they should focus on the border itself, or perhaps enforcing deportation orders for people who are a priority to be removed and not.
Okay, so I think there is again a connectivity issue, but I would really like to say hi to folks out there who have joined us. And hi, Rohan. Hi to Vikas. Thank you so much for joining us. We're going to take up your questions. Please stay with us. And Ingrid is back. So, Ingrid, please carry on.
Yeah, so what I was saying before is, if we see immigration raids in places where, people are worshiping or going to school or hospitals, I think there will be backlash, and I hope that certainly there will be backlash. And I don't think that should be the focus, but we stand to see. There's a lot of competing interests, I think, at least what we've seen with everything that's going on in the news and X and different people with the incoming administration. So we'll see. We'll see what happens. I certainly hope that immigration raids does not happen in places where people go to worship or school or to get medical treatment. But we'll stand to see.
Yes, yes. It's too early to say, but folks out there, I think, yes, there are a lot of changes coming up, especially with the new administration starting 20th of January, since Trump is hitting office on that day. But it's too early to say. We will need a buffer time. I mean, first off, he will start taking his actions only sooner than later, I think. So we'll just have to wait and watch. But very rightly said, Ingrid, that there's so much news out there, and so many of those news are really scaring people, especially immigrants or people who want to go to the US to live their American dream. All right, now next up, I have another question, and if you could tell us, the new immigration policies under Trump's 2025 agenda. I mean, stricter requirements for H-2B visas, and how could this impact, the Indians and people from other countries as well?
Well, I think anytime you have stricter requirements for any type of visa, the hurdles are definitely going to be harder for anybody trying an opportunity in the United States. I think also a potential impact is employers will be less willing to go through this process and find workers. However, I think if you're unable to hire H-2B workers and other temporary workers, and we are unable to find the American workers that can do those jobs, the economy will take a hit. I think that comprehensive immigration reform is important. However, we have to consider every aspect of our economy as well. And immigration, smart immigration policy really responds to the demands of the labor market. And I think the H-2B visas are, a great way to supplement the workers that we need here in the United States. I mean, even if you look at, for example, what's happening in California with the wildfires and the fact that California now completely needs to be rebuilt. We do not have the American workers here in the United States to help rebuild California after these tragic wildfires.
Right, Ingrid. Thank you so much for bringing that up. I mean, California is suffering, and there's so much loss. Everybody, celebrities, common men, and people out there. There's just been so much destruction, and it's still going on. I mean, we keep hearing the news updates, and I really hope and pray that that people find strength in all these difficult times. And Ingrid, if you're back, so yes, you were
Yes.
talking about the California wildfires.
I don't know what's going on with my Wi-Fi, so I apologize. But in regards to California, we don't have the American workers. We don't have enough workers in the United States to be able to reconstruct, and rebuild California. And construction companies rely heavily on H-2B workers to come do these types of jobs. And I think that is, such a benefit and a value to America to have these workers come in, do the job, do it quickly, do it well. And these are temporary jobs that really fill a need. So, that is one example, for example, where, America really only stands to gain from H-2B workers. I hope that the incoming Trump administration can realize that and not, make this process extra burdensome for the employers and the people that would really benefit from H-2B workers, not just the workers themselves, but also the American people that only stand to benefit from their labor.
Yes, so true. And when you just talk about in general, I mean, immigrants are also creating jobs. They're coming to the US, creating, I mean, I'm talking about entrepreneurs, they are creating jobs for many others out there. So I think, yes, it should be like a win win for everyone and not make it difficult for both the parties.
Yeah.
All right. So, yeah, yes. And let's go back to my next question, coming back to our discussion. So, how do you think Trump's stance on birthright citizenship and mass deportations affect family reunification for Indian immigrants, especially those who are waiting for green cards? And there has been a lot of backlogs for years
Yes.
now.
Yes. So that's a really great question because Trump has famously said that he's going to end birthright citizenship, even though that is guaranteed in the 14th Amendment of the Constitution. And he said that on day one, he will, issue an executive order ending birthright citizenship for children whose parents are here in the United States without documents, whose parents are here in the United States and are undocumented, which clearly by the language of the 14th Amendment, that is unconstitutional. So I think that is not going to hold up if it's, scrutinized. I also was watching and listening to the Attorney General's confirmation hearings, and she was asked the question, what are her, does she believe that the 14th Amendment protects birthright citizenship? And she refused to give a straight answer. She said that she had to study birthright citizenship in the context of the 14th Amendment, which I think is a very alarming and disturbing question, because if you are getting the job to protect and defend the Constitution, and here you are saying that you have to study birthright citizenship in order to give an answer, I find that alarming. So, I mean, I think that is one of those things that Trump, famously does. He says a lot of things to spark debate and cause a stir. I think if he were to issue an executive order ending birthright citizenship on day one, it will be taken up by the Supreme Court, and I think it will be struck down. So, he will get to say, well, I tried and they, didn't let me. I think that's the strategy behind that. And of course, we'll see what happens. I mean, I don't think that's going to stand. So, what I understand is that this executive order is meant to strip away birthright citizenship from children whose parents are here in the United States without documents, and not necessarily for people here with H-2Bs or H-1Bs or different visas, but we will see.
Yes, we will. It's too early to say. We still have about 3 more days for Trump really joining office. So I wonder how's it going. I know people have been so anxious and especially till before the elections and even after the elections. There's so much news to only make them more anxious. So,
Yeah.
uh, yes. So, do you have anything to say? I mean, 3 days early before Trump joins office.
Oh, wow. We've been down this road before. I think that during the first Trump administration, immigration was very challenging. Practicing immigration law was very difficult. It was very frustrating. So we've been down this road before. I think that the immigration bar is prepared to fight and advocate on behalf of immigrants. I am also perhaps cautiously optimistic that there have been some voices that are emerging and talking about high skilled immigration, H1Bs, and the need for skilled immigrants in the United States. Perhaps there will be some attitude shift on those fronts. I do think, though, that Donald Trump's priority is, undocumented immigrants, the border, and scrutinizing more family-based petitions and visas, and perhaps visa applications from people from certain countries or certain religions. But so I am somewhat optimistic, cautiously optimistic, that employment-based immigration will continue, be stable. However, I think if anything has taught us that over maybe the last six months or so, we have seen so many requests for evidence for people applying for, petitioning for EB2 and IW visas. We had this really great 2022 executive order on STEM from the Biden administration that really was supposed to be a way to attract more STEM workers in the EB2 and IW category. And it was great for a little while. And I think the floodgates opened and immigration perhaps had a little bit of buyer's remorse. And the last 6 months or so has really shown us to be very challenging when it comes to EB2 and IWs, and people trying to file self-petitions because the perm is taking so long, or perhaps because, people are here on H1Bs and they need an approved I-140 to be able to extend the H1Bs. And I see that USCIS has been very unfriendly to people in technology and especially people who work for big tech companies. So there has been, some shifts that were not necessarily, in my opinion, in the positive direction, in the way that the STEM guidance was supposed to, make EB2 and IWs more friendly for STEM professionals. And we have to learn to adapt. So just the same way that we learn to adapt, in an administration that was supposed to be friendly towards immigrants, we'll learn to adapt again in an administration that is, not so friendly to immigrants.
That's so true. That's so true. But I do hope that they are going to be at least how to say, they will have change of minds, change of ideas with Elon Musk also in the team, and yes, Sri Ramakrishnan and so many others in the team. So I do hope that he will change his ideas, and let's hope for the best for sure. All right, Ingrid. My next question is also, what changes in green card allocations could occur in Trump's 2025 immigration plan, particularly for skilled workers in sectors like IT and healthcare?
That's a great question. I mean, one way to perhaps, improve the system is to get rid of the per country cap. For sure, that would delay other nationalities' ability to get a green card, but I think it would even the playing field for a lot of people, especially Indian nationals, who's stuck in this backlog that is really absurd. So that is something that could happen. For skilled workers in IT and healthcare, I think those are just two very distinct fields. For healthcare, for sure, there's a lot of shortage and different opportunities for people in healthcare to perhaps get cap exempt H1Bs, and maybe explore other avenues for permanent residency. For IT, I think that is a more challenging industry because we see a lot of layoffs for people in technology, and we see a lot of people in IT and their positions being sent offshore. So I think for IT professionals, it's a lot more challenging, especially a lot of IT professionals work as consultants for one company that hires a lot of employees on H1Bs, and then they subcontract these people out to different customers or different companies. So it is a completely different industry with lots of challenges. And I think, self-petition options like EB1As or EB2NIWs, if an employer is unwilling to sponsor that professional for permanent residency, becomes a little bit more challenging, especially I think now that we saw the EB2NIW policy update, or the policy guidance update from a couple of days ago, that talks about people in technology, and how the benefit, for example, for an EB2NIW really cannot be for the employer. The benefit for an EB2NIW really has to be broader. And I think it makes it a little harder for IT professionals and people in technology to perhaps self-petition and be able to get their green cards on their own.
So true. Thank you so much, Ingrid. And IT and healthcare, these are two sectors where we see a lot of immigrants coming in and who want to work and live their American dream. So before we go on to our next questions, I would really like to take up some of our audience's questions because they have been waiting. So let's take up Rohan's one first. This is on YouTube. And Rohan is saying Trump has talked about tightening immigration laws and reducing the number of refugees. How would this impact individuals already residing in the US who might be waiting on asylum or refugee status or seeking other pathways to legal residency?
Well, I think the immediate effect will be most felt by people who will be seeking those benefits after Trump implements any changes. During the first Trump administration, we saw people who were applying for asylum get interviews in as little as 3 months. So there was a policy where, if you were applying for asylum, they would give you an interview really quickly. The idea was to get you in and out really fast. And that actually caused a significant backlog for individuals who had filed asylum applications and had been waiting in line for quite some time. So, I talk to people all the time, especially people from Venezuela who came to the United States maybe 8, or maybe 10 years ago, filed for asylum. And before Trump, and after Trump, they were stuck in this queue waiting for their interview because of so many people applying for asylum and getting their interviews earlier. So I think it may have, if that's the policy he's going to go back to, it may have an impact more on the people that will be applying after any policy changes, perhaps not so much the people who are applying before. But of course, if there is greater scrutiny, on asylum applications, CPS, seeking refugee status, then for sure that would apply to people whose cases have not yet been adjudicated. So it's important, I think, to be informed and work with your attorney to keep up with whatever latest policy there is, because these cases take so long to be adjudicated that you want to stay on top of it. You want to stay informed.
So true. Well, thank you so much for taking this up for Rohan. And Rohan, I hope you got your answer. And if you have any more questions, you can keep commenting. And why don't folks out there who are watching us, why don't you join us on call? Our phone number is 425-436-6335, and the access code is 988-888. All right, so now let's take up Vikas's comments. This first one is on Vikas is also on YouTube, and Vikas is asking, I've been working on an H1B visa for several years and have reached the 6-year limit. However, my employer is unwilling to sponsor my green card application due to company policies. Meanwhile, I received a job offer from another company that's willing to sponsor my green card. Yes, but it would require me to take a significant pay cut. What are my options for staying in the US? And how can I weigh the pros and cons of each choice to make an informed decision about my career and immigration future?
So if you're in your 6th year and you don't have an approved I-140 yet, it's going to be very difficult to have an employer file a perm for you and get an approved I-140 so you can take advantage of, an extension that goes beyond the 6th year. However, if you are somebody who may be able to get an EB2, have an EB2NIW filed on your own behalf, you could perhaps consider filing an EB2NIW petition, not premium process, and let it take the slow toll and perhaps you can take advantage from 1 year increments of your on your H1B. I think that's, perhaps a strategy that you could explore. However, this is not legal advice. I really would encourage you to talk to an immigration attorney to see if that is a possibility for you. But there is a section of our laws that says that if you have a pending I-140 and you're in your 6th year of H1B, you may be able to get extensions at 1 year increments. Aside from that, it's very difficult to perhaps stay in the United States longer without an approved I-140. You may have to explore perhaps, a different visa. But it sounds like you perhaps are coming towards the end of the road. So, I would weigh the pros and cons between, seeking an EB2 NIW on your own so you can take advantage of those 1 year increments, or, considering the job that your employer is willing to sponsor you for perm, see what that is going to look like, right? And consider perhaps taking the pay cut so that you can stay in the United States. I think it's a fine balancing act, and you have to really understand the options you have to make the best decision for you.
But there you go, Vikas, and I hope you've gotten your answer. Thank you so much for commenting, and please keep commenting if you have more questions. Let's take up Kavya's question now. Hi, Kavya. Thank you for joining us on YouTube. And Kavya is asking, given the current immigration landscape, do you anticipate any changes or updates to the IR3, IH4, IH3, IR4, or IH4 visa categories in the near future? And I'm asking because a family member is considering adoption, and I'd like to understand any potential implications for their planning process.
So I think that what Trump is, he does scrutinize immediate relative or immigrant in family visa petitions. So I think that there may be greater scrutiny on those petitions to perhaps establish the relationship between the petitioner and the beneficiary. I don't see any significant changes in the way right now that the visa categories will be perhaps affected in the future. I do think that there probably will be significant delays, because if people are outside of the United States waiting for, these visas, their priority dates to become current in order to apply for the visa, there may be some significant delays. So I think people need to manage their expectations and not, sell their house and pack up all their belongings to move to the United States. It's going to be a waiting game. It's going to be a waiting game at the U.S. embassies for sure. It's definitely going to be a slow process.
Yes, yes. And with all these new changes, I think, anytime there's a new change, a new rule, or maybe even a form update for that matter, I think it takes a little buffer time so that things are, again, followed the correct way, seeing that, the forms are right? Ingrid, what do you have to say from past experiences?
Yeah, for sure. And I think that, like, for example, today there's a new I-129 form that goes into effect without any real buffer time, right? So I think that you need to stay on top of this stuff to know what's going on with immigration so that you're not causing delays because you're just not aware of any changes. So I think that's really important. I think it's also really important to make sure that your information is correct in every piece of, any form, any documentation that you submit to any government agency, because they will be cross-checking and using a lot more technology to make sure that your information matches everywhere, because I think they are going to be looking for a lot more fraud and a lot more, misrepresentation, and doing a lot more scrutiny and perhaps using technology to do so. So I think it's really important to be incredibly detailed oriented and take your time up front so that you're not wasting time later on trying to correct errors.
EPS, right, from Sudan, Ukraine, and even Venezuela. So that too, I think we have new updates. So folks, I think I would always appeal to you to, do your research and stay updated with all these latest new rules, new updates, so that, you don't miss out on them. You're on time. And yes, I think that's it for now. So, Ingrid, let's come back to some of our questions since we have a little more time, and I do have more questions actually from our Facebook, and I would also like to say, folks out there who have joined us, you can even contact Attorney Ingrid Perez from IBP Immigration Law, and her phone number is 407 906 0068, and her email address is info@ibplaw.com, and go visit www.ibplaw.com. So, Ingrid, coming up, my next question to you is, how will Trump's proposed visa vetting process impact Indian workers who are applying for US visas or permanent residency, and what could this mean for, their chances of approval?
I think similar to what I was saying before, we can expect a lot more technology and scrutiny in any visa application. So I think that people that are applying for any visa, no matter whether they are abroad or in the United States, or applying for any green card here in the United States, or any petition, anything like that, should really take their time with ensuring that everything is correct, that the information matches everywhere. You don't want to inadvertently make a mistake on your form or on your application or petition, which will cause a delay and a headache later on down the road. And I think that also, plan for delays, and understand that it is going to be probably a lengthy process from now on.
Okay, am I audible? I don't know why am I stuck though.
Can you hear me?
Ingrid, can you hear me?
Yes, I can hear you. You're frozen.
Yes, for some reason I am frozen. I do not know what is the problem, but I can take up this next question, and as you answer, I could join back. So, my next question to you would be: how will Trump's 2025 focus on border security and immigration enforcement affect Indian students who are looking to study in the US?
I think for
Who have
Indian students looking to study in the US, they're going to be applying for their visas at a US embassy or US consulate. And I think similar to my last answer, it's important to plan ahead, plan for delays, and ensure that all of your documentation, your I-20s, your applications, your DS-160 is done, really, really well. I think those will be scrutinized. Another thing also that is important to note is that the upcoming administration said that they will be denying student visas and kicking people out of the state who perhaps support Hamas, right? So making sure that your social media is not showing anything like that could potentially be used against you, I think is also really important. And unfortunately, that is just where we are right now. I think Marco Rubio said something like that they will be not issuing student visas or kicking people out of the country who perhaps are friendly to these organizations that the United States do not support.
Okay, very, very interesting. And well, I really want to just say, just don't be scared. I really hope that you are abiding by the rules and the laws, and there should not be anything to be so worried about. So, thank you so much. Yes, and folks out there, you can join us, and I think we will take a short break for now. But before that, I just want to tell you that you can also connect with us, and for that, you can call us on our number, and the number is 425-436-6335, and the access code is 988-888. And once you're in, you'll be even able to speak with Attorney Ingrid Perez directly, since we are here for a couple more minutes. So why don't you join us to ask your questions? The line is on, and yes, we'll be very happy to have you. And also, you can contact Attorney Ingrid Perez, and you can do that by dialing her number 407-906-0068. That's her number. And her email address, in case you want to contact her for your case, you can email her at info@ibplaw.com, and go visit www.ibplaw.com to get to know more about Attorney Ingrid Perez and IBP Immigration Law. And well, another thing is you can also contact me. You can WhatsApp me on my number, and you can even call me on my number, and my number is 408-335-6444, and my email address is nipa@staffingly.com. So please feel free to join us and call me, tell me about yourself, tell us about your case, and we can direct them to our attorneys directly. So, yes, coming back to our questions, and Ingrid, we also have some more questions from people who have joined us on Facebook. So, Control, if you can display them, please, we can take them up. So, this question is from an anonymous member saying, "Hi, all. Is it worth doing day one CPT if H1B is not picked in all three attempts?"
Oh, that's a tough question. That's a tough question to answer without really knowing your individual situation, because day one CPT can be beneficial for many people, but you also have to be very careful with day one CPT because it is, it does sometimes cut into any other work authorization time that you may have in the future. I would perhaps not be in the best position to answer this question without really understanding your specific situation and what your future plans are, because I think if you're planning on doing day one CPT, you really have to have a vision for the future as well. And it's unfortunately a little hard to answer this question without really knowing a lot more about your situation.
Yes, yes, I feel that. Yes. So, folks, whenever you tell us about, whenever you have a question, it would be really nice to get more details about yourself, your case, where you're at, and more details, basically. So, all right, let's take up this next one. Control, please. So, my immigration team mentioned that nowadays there is lead time of 4 to 6 weeks to receive the RFE after USCIS sends it. Wonder if that would eat into the response time of 60 days. Is there a way to know the nature of the RFE? According to them, they can't tell until it is received in mail. I was in Canada at the time they received the petition amendment. Curious if it could be related to that.
So I don't think that it could be related to the fact that you are in Canada, but for sure, getting receiving an RFE 4 to 6 weeks after it is issued will cut into your time, and it does disadvantage you significantly, especially if immigration is requesting you know uh, uh, a lot more information on your petition. So I'm surprised if something like that happens. I would definitely work with your attorney to make sure that you respond to that RFE as soon as you can, and document all the attempts that perhaps you have made to contact USCIS to get a faster RFE in the mail, so that you can take advantage of all the time that you're given to perhaps respond to the RFE. And yeah, it's difficult to know what's in the RFE until you actually get it. But I think that if you don't get it within, if you look at the USCIS website and it says they sent you an RFE and you don't have it within like a week, I would definitely be contacting USCIS to request a second copy and documenting all of my efforts that I've made to contact USCIS and get that RFE. I would definitely do that.
Thank you so much, Ingrid. I mean, I'm sure that would be very helpful. I wish we knew the name, but it was an anonymous person. So, yes. Let's take up our next one. So, I had recently traveled to US on H1B and only in few days got laid off and today returning back to my country. I have few questions. How can I know if my H1B is cancelled or revoked? And the second is, in future, can I transfer or renew H1B with other employers? And the third is, will I get salary and pay slips for these few weeks? And if I am eligible to apply again for H1B, what documents required for me? What documents are required?
Okay, so let me answer, let me try to answer as best as I can some aspects of this question. Should you be getting paid? Yes, you should get paid for the time that you worked for your employer, for sure. If you don't, you should seek an attorney to help you recover the money that you were not paid. Those are unpaid wages that you earned. So you should definitely be getting paid. Usually when you are let go from a position, you have a 60-day grace period. Sounds like in this case, you left the United States so you don't have that 60-day grace period to be here in the United States and look for another H1B position. If you have an H1B, you can, if you have H1B time left, you can get another employer to file a petition on your behalf so you can get another H1B position. You can certainly do that. As far as documents that you need, I mean, that is going to be very specific to your case, but usually when an employer is filing an H-1B petition for an employee and it's a specialty occupation, we need the employee's diplomas, evidence of maintaining lawful status when you're here in the United States, information from the employer, for ability to pay, things like that. So you need a whole new petition, from a new employer, and you can get back to work on H-1B.
Right, right. Anything else you want to say on these questions?
How can I know if my H-1B is canceled or revoked? Well, if you have the H-1B, you're not going to be able to come into the country later on with the H-1B unless you have an employer. If your H-1B is revoked, if immigration decides to revoke or cancel your H-1B, you'd be getting a letter. But other than that, if you're outside of the United States, definitely maintain and keep all of your H-1B approvals so that if you are going to get back on H-1B, you can do so.
Okay. Thank you so much, Ingrid, for taking that up. And I think with that, we have covered all the questions from our audience. And also, I would like you to share with us if you have any experiences, especially related to immigration, or any case study from your end that you would like to share. That was very interesting.
Yeah, so recently we did an H-1B cap exempt for an Indian national working for a playwright. A theater company, which was a really interesting case to work on. This person did have an H-1B denied before they came to my office, and we were able to get this H-1B approved, the cap exempt H-1B, which is really wonderful because she did not have to go through the lottery. I think that, there is this idea that H-1Bs is just for a specific type of occupation, or, the most prestigious or mostly high-skilled occupations, and it can be. Perhaps it should be, I don't know. However, the H-1B is really designed for professionals. And I think sometimes that, you can be creative with the H-1B strategy in order to really show immigration that the job that you're coming to do is a professional position that qualifies for H-1B. So I would just say for people that are, maybe not selected to the H-1B lottery, or people who are stuck or perhaps don't know what to do, an H-1B capped exempt position may be the solution to your problems. And I would also start thinking about ways to secure your permanent residency here in the United States very early on in your career. And also, one on the last note, since we talked a little bit about students, right, wanting to come to the United States, I think for students who want to come to the United States and study here and take advantage of the employment opportunities, it's really important to understand and study the labor market, to understand and figure out an area that, is really in demand. Because what we see is that for a lot of technology companies, there's significant layoffs. And if you're here on H-1B, you could be affected. Not only can you get laid off, but your employer may not be willing to sponsor you for the perm if they have mass layoffs. So I think it's really important to, plan your immigration from the very beginning. Beginning with the degree and the area of study that you're going to be focusing on, so that you have the best chances of permanent residency in the United States through your job.
Thank you so much for sharing that. And it was a very, very interesting one. Ingrid, thank you so much. And I think we just have two more comments and we'll just take them. Vikas says, thanks for the information. And thank you, Vikas, for joining. And we have Luwain, if I'm pronouncing it right. Luwain is asking, hello, what kind of changes can we expect on EB1 and EB2 with Trump administration?
Well, Trump famously said that he thinks everybody who graduated from college here in the United States should get a green card stamped to their diploma. So, I'm hopeful that, or I'm, cautiously optimistic that under the new Trump administration, we're not going to see perhaps many new restrictions on EB1s and EB2 and IWs. We saw that under the Biden administration, there were so many executive orders and guidance meant to make EB1s and EB2s and even O's more attainable for STEM professionals to maintain America's competitiveness in these STEM fields. And then the people responded and the people applied for these benefits, and immigration sort of had to a little bit of recalibration as far as the way that these cases are adjudicated. So what can we expect? I'm hopeful that the tides have shifted a little bit. The conversation around employment-based immigration and high-skilled immigration have shifted. People are a little bit more aware of the benefits that these professionals bring to the United States, and really the need, right? We really need people with specialized knowledge and advanced degrees, and people here with EB1 extraordinary ability, achievements and things like that to push so many different industry sectors forward. So I'm hoping that there won't be any changes, but I mean, I think Stephen Miller, who was in the Trump administration, said that they will be restricting these kinds of petitions as well. But we stand to see. I haven't heard anything much about this. I think that we have had some recent guidance, and I think we need to adjust to that a little bit. I won't be surprised if we see something right away, but we'll just have to wait and see. I think under Trump, EB2s were, they were friendly towards, entrepreneurial endeavors and endeavors of that sort. EB1s received very high scrutiny, and they still do. These are hard visas to get. So, we'll see if anything will change right away. I think it's going to take a little bit of, the dust needs to settle a little bit with the recent changes, especially with the EB2, so that we can see what immigration is going to do.
Yes, yes, so true. Thank you so much, Luane, for participating, and Ingrid for your answer. And okay, we have one more who just jumped in just now. Hi, Dio. I don't know, but I hope I'm pronouncing your name right. But this will be our last question for the day, Ingrid, if that's fine. So, yes, we have Dio asking, hello, I'm an artist from Dominican Republic and I would like to move to US to continue with my music career. Is there any way to change my visa B1 to B1 B2 to work permit so I can perform in different places? Yeah.
So artists do have ways to come to the United States and perform. There are different options depending on the type of performance, how long you're planning to stay, what your itinerary looks like. Perhaps you could look into an O visa or maybe a P visa, depending on your specific situation. But for sure, I think it requires you to plan ahead, because you do need to inform immigration what your plans are, as far as the jobs you're going to be doing, the performances you're going to be doing, and you also need to make sure that you qualify for the classification that you were seeking. You're definitely not allowed to come to the United States with a B1 B2 to work, but there are options for artists, and I think it's important to perhaps talk to an immigration attorney and assess your background, the types of evidence that you have to show that you meet the qualification, and then start making your plans here in the United States so you can present your itinerary to the immigration authorities and perhaps get that work visa so you can come and perform.
There you go, Dio. Thank you so much, Ingrid, for patiently taking up all of these questions from our viewers. And Luane says thank you. Thank you, Luane, also, for participating. And I think with that, it's a wrap. And Ingrid, if you have any last notes, to wrap up our show for today.
Well, just thank you for having me. And I really enjoyed having this conversation, and I hope to come back. And, sometimes it's a little difficult to answer individual questions without getting into the details. But for sure, I hope that the information has been valuable. And if people have any questions, they can definitely reach out to me. And I hope to be back.
Me too. And I hope to really see you very soon, hopefully this month itself. But yes, we will see what we can do and when can we have you back. But definitely, folks, you can also contact attorney Ingrid Perez by emailing her, and her email address is info@ibplaw.com, and her phone number is 407-906-0068. And go visit her website, www.ibplaw.com, to get to know more about IBP, immigration law, and also attorney Ingrid Perez. Thank you so much, Ingrid, once again. And here's wishing you a wonderful day ahead. See you soon.
You too. Take care. Thank you.
Take care, you too. Folks, thank you so much for joining us. And if you resonated with today's episode, please do not forget to like, share, and subscribe to our channel, Immigration and Jobs Talk Show. We are here on YouTube, LinkedIn, Facebook, and on X. Follow us, connect with us, and also you can contact me. You can WhatsApp me or call me on my number. My phone number is 408 335 6444, and my email address is nipa@staffingly.com. So feel free to connect with us. Thank you so much for joining, and don't go anywhere. Stay tuned to Immigration and Jobs Talk Show. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. And we have another very interesting and very, very important session lined up for you. And before we have our guest in our episode today, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live on YouTube, LinkedIn, and on Facebook and on X. So, please feel free to comment wherever you've joined us, and maybe you would want to know more with regard to the topic. And it's super exciting that we are going to be joined by our very special guest who has been with us for over a year now. So please help me welcome him, none other than Attorney Chand Parvataneni from SPB Law Firm, Dallas, Texas. Hi, Chand. So good to have you back. And this is our first episode this year. So here's wishing a wonderful 2025 ahead.
Yeah, thank you, Nipasa, and thank you for all the viewers watching, and a happy new year to all. This is my first show with you this year, and hopefully, we'll have a lot of engaging, knowledgeable sessions throughout this year.
I am already looking forward for all of them, and especially this one today because, we hear a lot of changes that are coming up, and yes, with regard to H1B starting tomorrow, right? It's the 17th of January, so we are going to have a lot of updates, and also with those new changes, new rules, we are going to have new H1B RFEs, site visits. So, would you like to tell us
Yes.
what people out there who are watching us right now, what can they expect from today's episode?
Sure. So what happened is Biden's administration, under Biden's administration, Department of Homeland Security, DHS, they published a final rule in December. So December of last month, that's 2024, the final rule was published. And 30 days after the final rule is published, it takes into effect. So a lot of changes were codified and they were published. And the 30th day ends today. So tomorrow, starting tomorrow, which is January 17th, all these new rules kick into effect. And these rules are proposed to strengthen the H1B program. And some of the rules are good, some of the rules are bad. But overall, I think yeah, I mean, one thing that's going to happen is things are going to change because now we have new rules. New rules have been codified. So a lot of things will change. And to give a perspective, what happened in 2020 is that in 2020, there was a lawsuit. And after the judgment, USCIS went and rescinded a couple of old memos. So these old memos talked about client letters, contracts, and a couple of other things. So USCIS, based on that lawsuit, based on the final outcome, these old memos were rescinded. And starting from 2020 June, what has happened is client letters were not mandatory, and contracts were not mandatory, and a few things were changed based on what has happened in 2020. So for the last 4 years, things were happening in one way. And because of the lawsuit, because what really happened in that lawsuit was USCIS failed in that lawsuit because they did not follow a proper procedure. So they have to follow procedures under Administrative Procedure Act, APA. And if they do it, the rule will be valid. And because these old memos did not follow those rules, they lost that lawsuit. So over the last couple of years, they went through the process. This time they did it properly. So they went through the APA process. They published the draft version of the final rule. They gave some time for public commenting. They went through all those comments, and then they published the final rule. So this time, so basically whatever happened in 2020 with that lawsuit, I think they used all that experience to finalize this rule. And going forward, because a lot of things are codified, USCIS is required to follow these rules. And because of this, we can expect a lot of new RFEs. The reason is in the last 4 years, we did not see RFEs for contracts. We did not see RFEs for employer-employee relationship and client letters. Now, these kind of things will change. Now, again, contracts are mandatory. USCIS codified the definition of specialty occupation. They changed the definition of specialty occupation. They also codified some rules around site visits. Previously, site visits were done differently. Now, site visits are going to be done differently. So, all these rule changes are what are going to come into effect starting tomorrow, which is January 17th. USCIS is also publishing a new I-129 starting tomorrow. So, starting tomorrow, a new I-129 has to be used, and this incorporates a couple of these final rule changes. And because of these new rule changes, USCIS can start looking at things differently, and based on that, they can start issuing new RFEs if the documentation does not conform to what is required as a part of this new regulations.
Right, right. So thank you so much for that overview, on what we can expect, especially that there are changes coming in starting tomorrow. And with those new changes, we are going to have new H1B RFEs as well and different site visits as well. So thank you so much, Chand. And moving on, let's just hop in directly to our questions. So I have this first one with regard to specialty occupation. It's a new rules which are effective and the changes of getting an RFE, for H1B applications, and what can employers do to get ready for all of that?
Sure. So, in terms of specialty occupation, so the rules have changed a little bit. So now what they're saying is it doesn't have to be a single degree. Multiple degrees that are related can be used. So, for example, if you say a job requires a computer background, for example, so a computer science degree might be the right field. Maybe software engineering also might be the right field. So, what USCIS is currently saying is yes, you can have multiple degrees required, but each of those degrees should somehow correlate with the job duties. So the job duties are going to be very, very important. And we probably will see increased number of RFEs for specialty occupation. The reason is now USCIS is emphasizing that a job must require a bachelor's degree. And not only that, that degree must be related to the job duties. So basically, what it means is the jobs, sometimes the jobs are a little bit broad, and the job duties are what is going to determine whether you require a bachelor's degree or not. And if the employer requires, say, a little bit wide degrees, for example, computer science, IT, and software engineering or software engineering. So USS is now not going to come back and say you are requiring multiple degrees. It doesn't have to be a specific specialty. It can be different specialties, but all of the specialties that the employer requires has to have a correlation with the job duties. So what that means is USCIS will look more closely whether the degree requirements are actually essential for performing the job duties. So they're going to look at the job duties, they're going to look at the requirements. And what it could mean is sometimes it could result probably in more RFEs. And so what employer has to do is you have to demonstrate that there is a direct connection between the job duties and the degree of the employee. So if all of those don't match, you might probably see more RFEs. We also probably will require more documentation because the employer will claim a particular degree is required, will claim that the job is complex, will claim that these are the normal industry standards. But based on the new rules, that is probably not enough. And one of the things that the new rules are saying is the client requirements, the end client requirements. Sometimes when there is a third party worksite kind of an arrangement, the end client requirements also determine what whether the job is specialized or not, specialty occupation or not. So more than likely, we might require client letters where the client actually talks about the job requirements. So USCIS will also ask for documentation that the client, the degree that the client requires. So tomorrow, if there is a third party worksite kind of an arrangement, if there is no documentation from the client on whether a bachelor's degree in a specific field is required or not, tomorrow we might see risk of more RFAs, probably more denials. And not only that, some occupations I think will see more RFEs, and occupations like marketing, for example, marketing analyst, and also probably certain IT roles where the job zone. So every occupation, normally what we do is we go and check in ONIT, Occupational Outlook Handbook. We see what is the degree requirement. And some of the jobs, like for example, computer systems engineer or web developer, if you go and look in ONIT, the job zone, it is a zone 3 occupation, not a zone 4. Zone 4 is basically the normal requirement is a bachelor's degree. So more and more USS is going to look at the ONET requirements, and if a job is not in job zone or higher, more than likely we might see issues. And what that means is certain IT roles more than likely will start having issues. And the immediate thing I can think of is definitely computer systems engineers, web developers, and there are a couple of occupations. So all we have to do is go and look in Own It and see what the job zone is. And if the job zone is 3 or anything below it, more than likely you'll have a problem. 4 or above, more than likely you at least meet the initial test. So all of these things, what it means is employers can expect to see more and more specialty occupation RFEs because we had a way of USCIS doing things all along. And into the future, the new rules talk a lot about specialty occupation. They have made a lot of changes about specialty occupation. They talk about end client requirements superseding the actual employer's requirements. So all of these things mean we'll see more RFEs on specialty occupation that we have not been seeing in the last 4 years. And employers have to be ready. And what that means is ensure your job descriptions are very detailed. So when you're filing a H1B, if the employer does not give a proper job description, a very, very detailed and very, very elaborate job description, you will definitely see RFEs. So definitely try to give elaborate job descriptions. And in my opinion, if you're not giving at least a whole page of job description, a detailed job description, USCIS more than likely will come back at you. The reason is when you're filing a H1B, you're filing a H1B for 3 years. So you really have to tell USCIS what your employee is doing for the next 3 years. And if it is like a very, very small, short summary, USCIS probably will not be happy. So try to keep your job descriptions as detailed as possible. And not only that, you upfront you have to show clear evidence of job's complexity. So employers should be prepared to submit documentation demonstrating that the role is indeed a complex occupation. They can probably include expert opinions or industry standard documents upfront. Basically, the Own It, the Occupation Outlook Handbook, those documents should be part of the file upfront. And the petition should upfront establish that the job cannot be performed by somebody that at least does not have a bachelor's degree or above. So this is very important. And going forwards after Jan 17th, you also have to focus more on employees' qualifications. So if an employee does not have a degree in the right field, so if the employee has a civil engineering degree or a mechanical engineering degree or a commerce degree or a business degree, and employer is filing for a job in IT field, more than likely you'll see more and more RFEs, more and more denials going into the future. So documenting employees' qualifications, maybe their experience letters, maybe their prior experience, if their job is not in the relevant field, putting evaluations upfront. These are probably very, very important. If not, you'll see bad RFEs starting from Jan 17. And that being said, I think the rules are going into effect starting from tomorrow. So more than likely in about a month or so, we will have more data because we will see more RFAs based on the new regulations. And as regulations evolve, employers need to stay up for further clarifications or guidance from USCIS. More than likely, what I think will happen is down the line, USCIS probably will issue a memo or some kind of a guidance that will summarize how they will process cases based on these new regulations, and being proactive, being up to date with the guidances from USCIS, detailed job descriptions. That is the only way to reduce the likelihood of specialty occupation RFAs, because the new rule changes make a lot of changes for specialty occupation.
Well, thank you, Chand, for the detailed explanation and for highlighting the many changes that are coming up, and they're all going to come into effect from tomorrow itself. So, folks, just be ready, and especially employers out there, it's important that you take note of the points that Chand has clearly highlighted, and see that you follow, especially the detailed description for any job. And Chand, we also have viewers who have joined us with their questions. So I think I'll just say hi to K. Vishwanathan, Kavita, and I think we should also take up K's question quickly, just so we can move ahead.
Sure.
Yes. So blanket L1 petition being filed tomorrow. Can you confirm the timeline to get approval, and when can I get my visa interview and passport stamped?
Sure. The good thing is for L1s, no rules are changing from tomorrow. So the rules, whatever rules we have today, will stay even tomorrow. It's only the H1B majorly that the rules are changing starting from tomorrow. So for L1, I mean, the company is going to file the case. The company has to wait for an approval. And for L1 cases, company can do it in premium. So if a case is urgent, normally the companies do it in premium. And the minute you get an approval for the case, the company gets the L1 approval, and you can, at that point of time is when you actually look for going up for stamping. And stamping, if you keep monitoring the dates, typically within a month, more than likely you will get dates. Even though it looks like you might not get a date, you have to keep on checking the website. So once the case is approved, probably within a month, more than likely you can go for stamping. And at least L1 at this point of time, we're not seeing any proposals to change the rules. So at least we don't think anything is going to change for L1s, and the rules that are currently there probably are going to stay at least for the next couple of months.
Okay, thank you so much, Chan, for updating us. And I hope, Kay, that you got your answer to this. And if you have more questions, please feel free to keep commenting. And I think we would love you to join us on call. Anybody out there watching us, if you have any questions for Chan directly, you can join him and me here on call by dialing this number on the screen that is available. So the number is 425-436-6335, and the access code is 988888. So please feel free to join, and yes, we will be hearing from you. And Kavita, please stay with us. We are going to take up your question very soon. But Chand, my next question to you is, what do you think will USCIS check during site visits, under the new rules, and how can employers follow the new rules to avoid having their applications denied or cancelled?
Sure. So one of the things that majorly changed and was codified as a part of the new rules starting tomorrow is the site visits. So we had the site visits since almost 2010. The site visits are conducted by the FDNS officers, and as a part of the site visit, normally what they do is they come unannounced. They come to the employer, they come to the work site, sometimes they come to the home and start asking questions. And the rules that we had so far, all along till today, end of today, January 16th, is that the FDNS site visits, when the officer comes, participation in an FDNS site visit is voluntary. So what that means is we do recommend the employers to participate. We do recommend employers to give as much information as possible. That being said, if an employer does not participate in an FDNS site visit, if in the current rules, if the employer or the employee say that they don't want to participate in the site visit, normally what happens is the site visit ends. And if USCIS is not satisfied with the answers, they normally issue a notice. And as a part of the notice, they ask for answers, but at least they don't revoke the cases, they don't deny the cases. Uh, if employer or an employee say that they don't want to participate in a site visit, and that was the rule all along. Site visit participation in site visits is voluntary. Starting tomorrow, Jan 17th, what has changed is, as a part of the new rules that were published in December last month, that will be in effect from tomorrow. Site visit participation in site visits is now compulsory. It has been codified as a part of the new rules. It has been codified. So what that means is, if there is non-compliance, if they don't cooperate with the officers, if they don't participate in the site visits, the cases might be denied. The cases might be revoked. How exactly USCIS will do that? We don't know yet, but they now have that authority. Based on these new regulations, they can do it. And we think that that is what will happen. Now, the things like what USCIS will check during site visits. So typically what happens is, they verify the employment and the job duties. So the USCIS officer, they will come to the company or to wherever the employee is working. Maybe it's a client location. Sometimes they come to the client locations. Sometimes they come to their home. They go to their apartments. They go to their homes. So this is something what has been happening, and starting from tomorrow, it is actually codified. And what they want to check is, so typically what officers want to check is the employee actually working at that location? Is the employee actually working on the job duties that align with those described in the petition? They will check whether the employee's role matches the description of a specialty occupation, and if the required skills and educational qualifications are actually being applied to the job. This is something what they check. They also look at employer-employee relationship. They want to make sure the company is paying the employees. They want to make sure employees being paid the right wage. They want to make sure the employees' work schedule, the work conditions, everything is appropriate. And uh, they also look at the work location. One of the things they want to make sure is the officers, they want to make sure the LCA is being complied with. And what that means is the work location. They should work as per the terms of the LCA, in the right occupation, right work location, right salary. So all of these things are something what USAS wants to verify. And that is what they will do as a part of these site visits. How they do it? They simply come, they show up unannounced, they make sure the employee is actually working at that location, the employee is actually uh, available at that work site, the employee is actually getting paid. They ask for pay statements, they ask for various documents, and they actually make sure the company is actually operating. I mean, if a company is just filing a case and not really operating at that location, they have a problem. So these are the kind of things that they will do. And why this could be a problem is sometimes employees are working at the client location. The clients may or may not be happy with the USCIS officer coming for a site visit. So now the employer and the employee, they're also dependent on the client actually letting the officer verify the information. If the client says, no, we will not let you come into our work site, tomorrow the H1B, it could be revoked, it could run into an issue. So these are the kind of things that could be an issue, because in the past, if the end client said, no, we don't want to participate, we don't want you in our office, at least we didn't see direct denials, direct revocations. Now, probably more than likely, we might see issues. And how do employers do things in the future? So in the past, some employers, because it was voluntary, they simply said they don't want to participate. In the future, there is no choice. So what that means is employers have to keep accurate and consistent documentation. So employers should be readily have that information available. What is the job description? What is the job that is being assigned to the employee on a daily basis? What is the work location? What are the terms of employment, as in salary and so on? They need to maintain accurate records, because USS officer might ask for pay statements, and USS officer is not going to be giving them a lot of time. So always employers should have a process in place to give this information to the USCIS officer. And employers should constantly look and see if the duties are changing, because sometimes assignments change one project to another project. At every stage, they have to make sure job duties match. If there is a change, a material change in job duties, employers must file a new case, a new amendment case. So this is very important. And not only that, employees also, every employee should have a copy of their LCA. And if an employer is not giving a copy of the LCA, that is illegal. Every employer, they don't have a choice. They have to give the copy of the LCA to the employees. So every employee should have that LCA in their hand. They should look at the data in the LCA, the salary, the work location, the occupation. And if employer is making them do something or not paying them on time, make sure you point it out to the employer. Make sure you document it. Maybe send an email, or you call them. Make sure you document how you're contacting your employer to notify them of any violations in LCA. This is very important, because when you have a site visit, you have to make sure your LCA is completely 100% complied with. If not, tomorrow your H1B is jeopardized. and make sure your employer is retaining control over you. They're paying you, they're in contact with you, they're helping you with any employment problems. If not, there is not proper employer-employee relationship. Make sure that is being done. And complying with the wage requirements, that is the number one thing for any company filing H1B. If a company is filing H1B, they better pay the employees as required. If not, the employer is going to have definitely have a problem. And sometimes we see employees being penalized because employees are not getting paid. They try to do a transfer because the employer is not a good employer. And now when the transfer is being done, unfortunately, USCIS is punishing the employees. Even if the employer is not paying, employees are getting punished. So it is highly important that if an employee is not getting paid, keep documentation, keep proofs, contact your employer, let them know in writing that you're not getting paid. And if an employer is benching you, benching is illegal. Benching is illegal, not paying you on time is illegal. So this is very important. And if you're working with an employer that is doing these kind of things, immediately move away from those employers, because tomorrow your H1B will be jeopardized. Because we had cases where we had a case and employer is not paying somebody. We notify USCIS, we show proof that employer is not paying. And then in spite of that, employer is having an issue because USCIS will come and argue employee is not maintaining status even if the employer is not paying the employee on time. So be very, very careful. Don't work for with any employers who are benching you or not paying you on time. And number one thing is everybody should be prepared for a site visit, because going into the future, the new regulations give a lot of power to site visits. And what that means is every employer that is filing a case, you should be prepared for a site visit. If you feel you cannot handle a site visit, do not file the H1B. So, and from an employee perspective, be prepared that you will have a site visit. And what that means is be prepared, because if you don't have a site visit, it is good. But if you have a site visit, at least you as an employee should be confident that everything is legit. Because if something is going wrong and the employer is not doing things properly, you should not stay with that employer. Look for another employer. Okay. So always do an internal audit. The employers should do an internal audit, and even the employees, you as an employee should always look at things, look at your LCA, demand the LCA from the employers. If the employer is not giving it to you, they have to give it to you. And if not, you always have that you should always be able to complain to USCIS. You should be able to tell USCIS if an employer is not giving you a copy of the LCA. LCA cannot be hidden from you. You should know what the LCA says. Okay, so that is very, very important. And everybody, the employer and the employee, make sure you're complying with the terms of LCA. And if not, you'll have a problem with the site visit. At the time of site visit, if you're getting paid like you're supposed to, if you're working from the location you're supposed to, don't worry about anything. Nothing is going to happen. Okay. So all that needs to happen is if you're working as per the terms of the LCA, you're getting paid as per the terms of the LCA. Site visits are not problematic at all. Site visits are problematic only if you're not getting paid and if you're not working as per the terms of the LCA. So the bottom line is, your LCA, look at your LCA, you're working, you're getting paid as per the terms of the LCA, the site visits will not impact you at all. It's only if you're being benched, that's when the site visits will cause a problem. So the summary is there should not be benching. If there is benching, try not to stay with that employer.
Thank you so much, Chand. I think those were great things to keep in mind. And thank you so much, really, for the detailed explanation. Now let's head on to my next question, which is about the I-129. So there are changes that are happening to it too, and the effects of the chances of getting an RFE. What common mistakes should employers and workers avoid? Just in short, if you could just name a few.
Okay. So the old I-129. Today is the last day for USCIS to receive the old I-129. Starting tomorrow, that I-129 is not even published yet. It's going to be published tomorrow. It will be available in USCIS website tomorrow. And starting tomorrow, USCIS will only accept the new I-129, the new edition I-129 that will be made available very soon. And in this new I-129, they made a couple of changes. And the reason they made a couple of changes is because the new regulations, the final rules starting from January 17th, they are looking at some changes, looking at some new things. And to correspond and to confirm to the new final rules, what USCIS has done is they've changed the I-129. They published a preview version, and in the preview version, they made some changes. And the major change that we see USCIS has made is now in every I-129, they're very, very clearly asking about the third party work site. So if somebody is assigned to a client, upfront in I-129, they've added some data points where they're collecting information about the worksite. They're specifically asking if it is a third-party worksite. And if it is a third-party worksite, they're upfront asking who's the entity that is maintaining or managing that worksite. So what that means is tomorrow when USCIS officers are looking at the I-129s, upfront on the I-129, they will look at cases where somebody has a third-party worksite, and they will look at cases where there is no third-party worksite because the rules are different. And what to me that means is third party worksite kind of cases probably will have more scrutiny, will have more burden. And the reason for that is the new rules, they clearly talk about client requirements. So the officers, I think, they need to analyze cases differently. So whenever there is a third party worksite kind of a case, an end client, vendor, these kind of cases, they have to look at who the end client is, what are the requirements of an end client, and then based on that, they have to process the I-129s. So from a USCIS perspective, things have become a little bit more complex because now they have to look at all these things. But because of the new rules, that is what they will be doing. And from an adjudication perspective, from an employer perspective, from an employee perspective, you have to be ready, and you have to be ready with client letters. You have to be ready with vendor letters because USCIS is going to demand those documents because they need to know what the client requirements are. They need to know that it's indeed that client. So bottom line is there will be more scrutiny on the I-129 because of these changes that are happening to the form I-129 starting from tomorrow, because of these additional questions about the third party worksite, third party client name, etc. on the I-129 going forwards. So definitely, if you don't have client letters, your cases probably more than likely will have increased scrutiny. You'll have challenges. So for every case that has a third party worksite, somebody's working for an end client, we have been recommending starting from tomorrow, you have to go back to your end clients. You have to ask them for documentation about confirming the job assignment, confirming the educational requirements, and so on. And if not, you will see more challenges. And from an operational perspective, you need to provide more supporting documents. Documents we didn't have to provide in the last 4 years are now having to be provided. So H1B filings probably for third party work site now will take a little bit more longer because now you have to wait until you get all the documents to file a H1B. If you file without these documents, more than likely you'll get an RFE. And what we are suggesting is until you have these documents, do not file the case. Even if it takes time, it takes time. But you rather provide all these documents thoroughly upfront and file the case rather than you get a very, very big RFE and then realize that you cannot solve the RFE. So things regarding the end client assignments, I think, are what needs to be attached. And for those employees who are working for full-time companies, more than likely this is not a challenge because you don't have a third-party work site. Anybody with full-time employment on the I-129 form, we don't see a lot of changes. It is only with third-party work site kind of cases that is the additional information that got added in the new form I-129. And some mistakes to avoid on form I-129. This is more for the employer because employer is the one that is doing I-129. The main thing is employer should make sure they provide everything that is required on the form I-129. Do not accidentally miss any information. Things like wage details, employee qualifications. Make sure everything is accurate, and demonstrate specialty occupation upfront. Demonstrate specialty occupation, okay? Because there is a way the burden of proof has to be proven. Make sure it is done as per the new regulations, and also complete documentation of work locations. So the new form adds multiple work locations in the form itself. So every employer should make sure the complete documentation of work locations is done on the I-129 form itself. And what that means is some people are working from client side, from their home, and so on. They have multiple locations. So all of this has to be a part of your I-129 upfront. Any incomplete or unclear information about all the work locations will be an RFE. So if you have multiple work locations, make sure everything is put upfront in the I-129 itself. So not properly putting the worksite information, the multiple worksite information as a part of your I-129 is not only going to be a problem with the initial filing, but even when there is a site visit, if it is not listed on the I-129 and you're working from home, it could be an issue. So always make sure the I-129 is thorough with the worksite information. If you're working from multiple locations, make sure it is documented. And so doing these things, making sure the form is thorough, I think things will be easier. That being said, third party worksite kind of cases, they have to ensure that the new I-129 form, the new changes are appropriately filled out, and the supporting documentation is not only accurate, consistent in it, and it should also be complete. And doing so, I think, will avoid the new kind of RFEs.
Well, thank you so much, Chand. And yes, so the I-129 form is also going to be a new one starting tomorrow. So, do you think that it's going to affect people who have already filed their I-129 up till today? Will they also have to?
Up till today, they're fine. Yeah, up till today, they're fine. So any H1B application that USCIS gets until today, it's still going with the old form. And those petitions, they should not run into an issue with the new rules. The new rules will be in effect from tomorrow. So any filings being done from tomorrow, where USCIS receives the file starting from tomorrow, those are the ones that have to make sure all these new rules are confirmed with, and make sure all the supporting documentation is appropriately attached. Until today, it's still the old rules, so still the old forms. So as long as the burden of proof as per the old rules are met, they should be fine.
Okay, that is awesome. Because, we've had so many viewers who've been asking if theirs is going to be affected. I mean, these new rules are going to affect them or not. So, thank you so much for the confirmation. And, we have Kay again with some more questions. I think we should quickly just address to them. So, hi back again at UK.
Sure.
So, we have L2 processing is after I get my L1, he says. Will L2 qualify for Dropbox, but they never been to a face to face? If no, when can they visit an interview in the next 3 to 6 months, as would not like them to get rejected? L1, I have team.
So anytime after
Okay.
yeah. So L2 is basically the dependent of L1. So whenever the principal L1 employee gets the visa processing done, immediately after that, at any point of time while the L1 is still valid, the L2 dependents can go for stamping. So L2 dependents, whenever they're ready, they can go for stamping once the L1, the primary employee, gets his visa stamping done. And they will have to go for an interview because looks like it is the first time they're going for stamping. And based on the current rules, they will not have an interview waiver. They just have to fill up the DS 160, book an appointment, and then go for an in-person interview.
Okay. And he was also saying L1 have team at NJ, New Jersey, but while I manage that team, I have too much of travel to meet clients. Can I still live? I'm in central US for ease of traveling. What has social media IDs impact in DS 160 and interview?
Yeah. So in terms of the work locations and traveling and so on, so as a part of the L1 filing, the employer will document what is the nature of the work, what kind of work is being done, what kind of travel is being done, uh, what are the work locations, and so on. So from an employee perspective, he has to make sure that he coordinates with his employer and works as per the terms of the I-129. So for L1, we don't have an I-129. So as per the terms of I-129 in general, they have to make sure they're complying with the regulations. And in terms of what is the other question other than travel? So traveling is
Social
probably what
media.
he has to coordinate with his employer. I think there was another question
Yes, he
after
was asking about
traveling.
social media. What has social media's IDs?
Oh, social media.
Yes.
Yeah, yeah. Yeah. So in DS 160, for everybody, they ask for social media. And what is happening is the computer systems that Department of State uses, USCIS uses, they're very, very powerful. And what they do is they do a lot of data mining. They check for a lot of stuff because it is in the interest of national security. So they do want to make sure the social media sometimes is checked. And the reason they do that for all DS 160 applications is because they want to make sure for all the people that are trying to get a visa, whatever their intent is really their intent. And sometimes they use social media, sometimes they go and check to make sure that's the right intent, because they want to make sure somebody is not coming into US saying they want to come to US for something on DS 160, but their intention is different. So for that reason, they ask for social media, and they definitely do check. I don't know how deep they check for each and everybody, but based on some red flags, they do keep checking it.
Okay, Chand, thank you so much. And I think, Kay, you've gotten your answer. So thank you so much for participating. Please join us on call. We would love you to join. You can call us on this number 425-436-6335, and the access code is 988-888. So once you're in, just speak with us and we will be able to hear you. And this goes out to Kavita and also to we also have Namrata. So please join us on call. It would be really nice to have you. All right, folks. So we will quickly take a short break, but before that, I also want to tell you that you can even contact Attorney Chand Parvathaneni, and you can do so by calling him up, or you can even email him, and even visit his website, that is spblawfirm.com. And to call him up, you can call him on his number, and the details are on the screen, please. His phone number is 817-523-8247, and you can email Chand about yourself, your case, especially Kay, since you have been asking a lot of questions. I'm sure your case is going to be very different. You can even email Attorney Chand Pravathaneni at his email address is law@spblawfirm.com. And definitely don't forget to visit www.spblawfirm.com to get to know more about Attorney Chand Pravathaneni and Sin. Yes, and SPB law firm. So yes, thank you so much. We'll take a short break and going to be right back. So stay tuned on Immigration and Jobs Talk Show. Welcome back, everyone, to Immigration and Jobs Talk Show. And today we are having none other than the special guest, Attorney Chand Parvathaneni from SPB Law Firm, Dallas, Texas. And we have been discussing about the new RFEs that are going to come up and site visits, especially starting with the new rules, which is starting tomorrow, 17th of January, 2025. So, Chand, before this, we were speaking about so many things, the new updates, of course, and we even took up K. Vishwanathan's questions, and I do hope that K has gotten his answers. And we will be taking up the rest of the questions also, folks out there. Please stay with us. But my next question to you, Chand, is also about remote working, since it is the trend now. And you were speaking about, the systems in US being so strong that they're able to locate where their employers are working. So, for H1B workers doing remote jobs or working in different locations, what extra paperwork will be needed to stay compliant with the new rules?
So remote work is completely legitimate. And when somebody is working remotely, either from their home or from their apartment, it's completely legitimate. And normally, the kind of cases that we see are 100% remote, where somebody is working completely from their home, or remote, where sometimes they have to go to their client location, sometimes to their employer location, sometimes at their home, a mix and match of locations. So, from a regulation standpoint, both are allowed. The only thing is, it has to be done properly. And the way it has to be done is in the LCA. So, whenever a company is filing for an LCA, they have to make sure they put all these work locations, multiple work locations, in the LCA. And they have to determine the salary at each location and use that LCA for H1B filing. And when the H1B is filed in the I-129, so if the employee is working remotely and also from the client location, for example, two locations, they put it. If the employee is working 100% remotely from their home, they put it. But the bottom line is it has to be filed in the LCA, and then it is allowed.
Okay. Okay, so it's very important to be filed in the LCA. And thank you so much, Chand, for the detailed explanation again. And Yes, we do have more questions, so I will quickly take up this next one. This is also about site inspections, the site visits. So, how will the increased site inspections or site visits affect the third party work sites and even the staffing companies? So, what can they do now to prepare for all these lately, I mean, the new rules that have come up and the extra site visits or inspections that are going to happen?
The site visits for third party work sites, that is going to be challenging, and that is what I think might impact a lot of people. The reason is some clients, they don't have any problem. They will work with the USS officers, they will verify things and move ahead. They will let them come into the work site. And the reason is the contractor, who's the H1B employee, they're not the third party company employees. So that is why sometimes they do let the officers come in. Sometimes they say, no, we will not let you in because so and so is not our employee. And in the current rules, if the client is not cooperating with the USCIS, they're not validating the information, there is a possibility that that H1B could run into an issue. So, so how do you prepare? So, in order to prepare, I think every employee who's working at a client location, they should at least let their client know that as a part of the H1B process, a site visit could happen, and be prepared. And if possible, try to get a contact in case there's a site visit. Who do you contact at the client location? So if the employer tomorrow finds out that there is a site visit or USCIS is trying to do a site visit, because USCIS will definitely notify the employer at that point of time, they, at least if there is a contact with the client that they could work with, at least they can immediately let that client contact know, so that client contact could coordinate with USCIS on answering their questions. So the site visits could happen at the client location, and the companies have to be prepared for that. And part of it is convincing the client that, hey, this is a part of the process, please do cooperate with them, because if they don't cooperate, it could jeopardize your H1. And some clients don't have a problem, some clients could have a problem. And if it looks like it's a client that you could have a problem, probably you have to look long term in finding another project, because if a client for sure is not going to cooperate with USCIS and will not validate anything, tomorrow we don't know what USCIS will do. Maybe in the next couple of months we'll have more data, but in the current rules, the current rules that came out last month, if somebody is not cooperating, somebody is not participating in a site visit, and that includes the third party client locations, it could jeopardize the H1B.
All right, Chand, and thank you so much again for those updates. So, this is what we heard after. I think these things came up right after the elections, right? These new rules are going to set in. So, but then Trump is only coming to the office on the 20th of January. So, you mean there was no real connection with Trump? I mean, these new changes, with or without Trump hitting, or whoever would have hit the office, these changes were supposed to happen, right?
So all these changes are actually by Biden
Mhm.
administration, and the way the rules were put in, it's not really like a quick process, because the Biden's administration was working for almost a year and a half, 2 years on these things, because a long time back, these rules were actually published in the draft mode. So this was happening for a long time. And actually, the new rules, some rules are actually very good. Some rules are bad, but some rules are very good. So it's a mix and match. It's a mix of good news, mix of bad news for H1Bs. So it's again not something that the Trump administration or the Trump team has done. It is what Biden's administration has done, and they've done it after following the proper procedure. So they're actually working on this whole changes for the last, I would say, 2 years at least, because the step number one was publishing the draft. So these rule changes, they published the draft almost 2 years back, a year and a half back, and they took comments. And the only reason I think they published it in December is, if they publish the rules and they get active, which is effective before President Trump takes his office. So President Trump is taking his office on January 20th, and if a rule becomes active before January 20th, the new administration cannot immediately change it. It is not easy for the new administration to immediately scrap the rules like in one day. It is going to take them a lot of time. So Biden's administration, I think, probably strategically finalized the rule last month, so it will get into effect before President Trump takes his office. So tomorrow, if the rule is getting active, the new administration, they cannot change the rule that quickly. They can definitely change it, but they have to follow a big process, a big APA process. So if they really want to change something, it is definitely going to take a little bit of time.
Okay.
So for those reasons, it's not the Trump administration at all. It is Biden's administration that finalized these rules,
Okay.
and they are the ones that are making sure these rules are active starting tomorrow.
Okay, okay. Thank you so much, Chant, for taking that up. And we also hear that the updated cap gap rule for F1 students, which is who are moving to H1B status, match with the new compliance rules. Do you think these new rules are going to reduce the RFEs for these students?
So the cap gap rules, so that is like one of the good things that happened in the new rule. So the cap gap, it's not going to reduce any RFEs, but what's going to happen is, so this is what cap gap says. If somebody gets picked up in a lottery and they're about to have their EAD card expire, so say they got picked up in the lottery in March, and in June their EAD card is expiring. So what cap gap used to previously say is, if somebody files a H1B for you, even if your EAD card expires, even if your work authorization expires, you can still continue to work until October 1st, September 30th. That is what the old rule said. So pretty much for a few months, even without an EAD card, they were able to get a automatic EAD card extension till September 30th. That was what the old rule said. So the new rule, which is a better rule, what now it says is, if you have a H1B filed by a company and your EAD card expires after filing the H1B, you don't have to stop working. You can continue to work even after October 1st, all the way until April 1st. So it's like another 6 months of additional time. And this is very good news because sometimes USCIS does not adjudicate the cases by October 1st. So a lot of people, because cap gap was a good thing, but it expired starting from October 1st, they had to stop employment. So in the new rules, because they got a little bit more time on cap gap, a lot of people on OPT whose EAD cards are expiring after H1B is filed, they can continue to work even if the H1B is still pending even after October 1st. So all it is doing is it is helping people who are students whose EAD card is expiring to continue to work even after October 1st if their H1B is still in process. So this is one of those things that is really going to help a lot of students
Yes.
starting from this year.
Yes, yes. One good news. Yes. Thank you so much, Chand, for highlighting. And Chand, we also have a couple more questions, even from Facebook groups that we would like to take up. So without further ado, I think we should take them up. So, Control, if you can display them, please. This first one is: Hi, all. Is it worth doing day one CPT if H1B is not picked in all three attempts?
So I think rather than say, is it worth, first of all, we have to look at the legality. So is it legal? CPT is legal, for example. So if H1B is not selected in the lottery and their OPT is expiring, so there are two choices. Either somebody leaves the country or change their status to change their status or do something that will maintain their status in US. So what people do is, if their OPT card is expiring and their H1B is not selected in the lottery, they have to change to a different status or maintain their F1. So if somebody is married, maybe they can look at H4 option or some other status option. If not, what they can do is they can continue their studies because somebody has F1 and before their F1 status expires, because they're not selected in the lottery, they can continue their F1. So what that means is they have to maintain status, they have to enroll in a college, and they have to strictly follow the rules of F1. And the rules of F1 require them to go to college, attend classes full time, pay the tuition, and progress towards getting a degree. So they can't fail classes. They have to progress getting a degree. So that is what they're supposed to do. And as a part of it, if that school requires CPT, because CPT has its own very, very strict rules. So as a part of it, if the school requires CPT, definitely they can do CPT. But make sure the CPT regulations are all met. So there is nothing wrong in doing a legitimate CPT, but the bottom line is they have to maintain F1 status, which means they have to do everything that is required as a part of F1, which is attending classes, successfully trying to progress towards your degree, and so on. Now the question is it worth it? F1 is a very expensive program because again they have to pay tuition, they have to go to college, they have to do a lot of things. And in their career plan, if getting that second degree is worth it, yes, I would say it is not a problem. Continue to do your F1 program. Make sure you attend classes, and as a part of it, if your school requires CPT, it is valid. Document everything that you're doing because tomorrow if USCIS asks, you have everything to show that you're maintaining status in a legitimate way.
All right. Thank you so much, Chand, for taking that up. Now, Control, if you can display the next question, please. So this is also on Facebook. Let's. Hello, all. I need your guidance regarding my travel plans. I'm planning to visit India in February, and I'll need to go for my H1B visa stamping during this trip. Considering the new administration transition, could it be advisable to travel during this period? And if yes, what steps should I take to ensure everything goes smoothly? I would greatly appreciate your insights and suggestions. Thank you.
Sure. So during last Trump's administration, President Trump's administration in 2017, when he just took office, what happened was immediately in a few days there was a travel ban, and this travel ban was limited to a few countries. So I think the whole reason, like a lot of people are confused, is there going to be another travel ban? I don't think there'll be another travel ban on H1B in the next few months. So I definitely don't think that is going to happen. But because there is this rumor that there could be a travel ban, because last time there was a travel ban, I think people are worried. I don't think there'll be a travel ban. But again, you have enough time because it's February and President Trump is going to be in office next week. So if there is really some kind of a ban, you'll know about it. But I definitely don't think there is any kind of a travel ban, and at some point of time you do have to travel. So I don't think that you should change your plans. Just monitor what's happening in the next 10-15 days, and just take your decision. And I would not worry about it, because as long as you have a legitimate job and your company is supporting you because they want you to work for them, go for stamping. I don't think you'll have any problem. And more than likely, because you're going from US to India, you already had a US visa in the past, which means you actually get Dropbox. You don't have to go for an interview. So more than likely, your process will be a little bit more faster and smoother. So I don't think you should worry about traveling to India in February, unless there is some kind of a travel ban in the next few days, which I don't think is going to happen. I don't think there'll be any kind of a travel ban for H1B employees.
Okay. Thank you so much, Chant, for that. And we also had Kay with another question, but Kay, I really suggest you to join us on call. So yes, you could ask the question yourself to Attorney Chance Pravathaneni. And once again, I can repeat the number 425-436-6335 since you're in NJ, or sorry, in Texas, but you can call us, and the access code is 988-888. Please feel free to join us. And Chand, we still have, maybe we can take up one more before we go. So if you can display that, please, Control. Hello, immediately attention is required, it says, and I'm traveling to India on January 31st for my H1B visa stamping, another travel. I submitted my DS 160 form in July 2024, but I recently realized I mistakenly updated my employment information in that section. To provide some content, I graduated in December 22. My first job started in February 23 and lasted for 1 month. After that, I got research work at my university until the end of May. Afterwards, I started another job in June 23 and still work here. I just updated the current employment section. Do I need to update my work? Additionally, could you advise me on how to change my DS 160?
So if the DS 160 is already submitted, more than likely they cannot make any edits. But what they can do at that point of time is email the support and let them know so it is documented. And I think if it is not submitted yet, they can make an edit. But if it is not letting you edit, just email the support line.
Okay. Thank you so much, Chand, for taking this up as well. And I think, yeah, we should take up Kay's question since I was really waiting for you to join us, Kay. I mean, but yeah, let's just take it up. So he says, hey, thank you. I love Chan's respond and attitude than the other podcasts I had in the past 4 months on your channel. Well, thank you so much, Kay. That really means a lot. And thank you for the compliments for Chand as well. And thank you for taking it up. I appreciate. And sorry, he says, but he has one last question. And he's saying, Under L1A managerial expertise, I am employed in NJ, but can I stay in Texas and get caught in W2 or IRS?
I mean, again, in terms of the pay statements and IRS reporting, always make sure that your pay statements reflect wherever you're working from, because the taxes will be different. If you're working in Texas, for example, you don't have to pay state taxes. If you're working in New Jersey, you have to pay New Jersey taxes. So, so if your payroll is not reflecting the actual place you're working from, tomorrow you're probably not paying the right taxes. So tomorrow IRS can come back and claim that there is some tax fraud happening. So to avoid it, always make sure your employer, they report to USCIS where exactly you're working from, and on your side too, from your perspective too, wherever you're working from, your payroll should reflect that, because tomorrow you don't want IRS down the line to come back and say you didn't pay these taxes properly, because the state you live in will determine your state taxes. So sometimes the taxes will be different. How much money you owe the state governments will be different. So for this reason, your payroll should accurately reflect wherever you're actually physically working from, and doing so, you should not have a problem. And your company can always make sure they notify USCIS appropriately by doing the right I-129 filing. So that way they report wherever you're supposed to be at, and then they pay you wherever you are at. So that way there is no problem with USCIS nor with IRS down the line. Because you are under L1A, more than likely you will qualify for a green card very soon. So you'll have to file for I-485 also very soon. Because the typical transition is L1A, they do I-140 filing under EB1 category, and you probably will be able to get a green card soon. But what that also means is you're doing an I-485 filing. So you don't want any of these steps to be jeopardized, because when you do your I-485 filing, you'll be submitting your tax returns and a whole bunch of other documents. So just make sure everything is aligned. If not, at this point of time, the company can fix it, make sure the I-129 filing is appropriate. But definitely the good thing is you are coming under L1A, which means as soon as you come, the company should be able to pursue the I-140 under EB1C category, and you should be eligible for a green card in a lot faster way than the other EB categories.
Well, thank you so much. And I think with that, we took up all the questions from Kay. And we're really happy that, Chand, you covered so much on this topic we had the discussion on today. And that is not, I mean, with the new rules that are starting tomorrow, January 17th, what new RFEs can we have, and about these different site visits as well. So thank you so much. And maybe last but not the least, if you can wrap up with anything more or a few more points to keep in mind, just to highlight to all our audience out there, it would be great, Chand.
Sure. I think the big thing is, I think in H1B world, there are two things. One, a full-time job where you work for the same company, there's no end client. And the other model where you're working for one employer, but there is actually an end client. So the full-time guys, I think all of you make sure that you have the right LCA. Make sure you compare your LCA to whatever you're supposed to do at your job. And for the third-party client worksite kind of folks, make sure you have the LCA and you're complying with the LCA. And not only that, make sure you get the client letters, because you will need your client letters for your extensions, for your visa stampings, and so on. And that is very important. Not only that, let your client know. I mean, you need to have a client contact in case there's a site visit. Be prepared for a site visit. If there is a site visit, you need to have a proper protocol in place. So you're not like running around at that point of time. Site visits are not bad. All they want to check is you're getting paid. It's actually going to protect employees, because they want to make sure employees are getting paid. Employees are not being exploited. So in a way, site visits are not bad. Only thing is you need to have a protocol where you're not worried at that last minute. Be prepared. All they're going to ask you is your pay stubs, your job duties, and confirm that you're actually working at that location. So it's nothing huge. It's just that you confirming that everything is right and you're getting paid the right amounts. So doing so, I think you will be prepared for site visits, and we will have more data in the next couple of months. But again, as long as you're working and getting paid, the companies are paying you, nobody should have any issue at all.
That is great news. So all we have to do is follow the law and do everything correctly, have all the documents right, all the information right in proper details. And I think, yes, nothing is going to um, be too bad for us, right, Chand? So with that, I think that is a wrap
That is
for,
correct. That is correct.
yeah, for
Yeah.
today's episode. But folks, thank you so much for joining, and you can call attorney Chand and his number as well to contact him further on your case. His number is 817-523-8247. And you can email Chand at law@spblawfirm.com and go visit www.spblawfirm.com to get to know more about Attorney Chand Pravathaneni. And thank you so much, Chance, once again. It was a real insightful session. You have a great day ahead.
Thank you so much,
And
Nipasa.
folks, if you still have questions, keep commenting because we will make sure to address to them and even take it to our attorneys who can give you proper answers to each of your questions. So please feel free to keep commenting even after the stream has ended. And you can even email me or contact me. And my phone number is 408-335-6444. You can even WhatsApp me in the same number. And my email address is nipa@staffingme.com. So thank you so much. All out there, have a great day ahead. And don't go anywhere. Stay tuned on Immigration and Jobs Talk Show because we have another webinar lined up with host Sam and our guest attorney Uma Mantravadi. So stay tuned. Bye bye for now. Hello, everyone, and welcome back to Immigration and Jobs Talk Show. I'm your host, Nipasa, and I'm really happy that you have joined us. Before we start off with today's webinar, I have this very important disclaimer, and that is by watching our videos, you agree and understand that the information provided by experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. So, folks, thank you so much for joining us. We are streaming live right now on YouTube, LinkedIn, Facebook, and also on X. So, please feel free to join the discussion by commenting. And absolutely, today we are going to discuss on what can H1B applicants expect in 2025. A lot of things are on our mind, and it's a very, very interesting topic and essential as well because I am sure employers and professionals are very much concerned about what to expect this year. So, if you are preparing for the H1B process or are curious about the trends, shaping the US immigration policies, I don't think you would want to miss this session. So, please stay with us. And yes, you can also join us by dialing this number on the screen. And the number is 425-436-6335. And the access code is 988-888. It's a very good opportunity for you because we are going to be joined by our very, very important guest today, and she's none other than Attorney Prashanthi Reddy. So it's really great to have you, Prashanthi. Thank you so much for joining us today. How are you doing?
Hi, Nipasa. Good to be back after the break. And we have a lot more exciting news for this year. So, yeah, it's great to be back.
For sure, for sure. I hope you had a great vacation time, holiday time, and here's wishing that this year, 2025, is going to be a great one for you and your team.
Thank you. Thank you very much. And a happy new year to you and to everyone that is online as well.
Yes, I think this is our first webinar this year, so let's go with it. What can people out there who have joined us expect from today's session?
I guess we're discussing about what to expect. What is the future of really of H1Bs under the Trump administration? The reason we chose this topic is because there's a lot of news
Yeah,
on the GOP, and it seems to be an important. It has become suddenly an important point of discussion internally among the GOP, with two warring sides, Elon Musk on one side talking about H1Bs, Trump saying something, and then on the other side, the more conservative think tank of Trump talking about restricting H1Bs. So it's been in the news a lot. So it would, we thought it'll be a great point for discussion.
Absolutely, Prashanti, especially with so many updates, policy changes, and administration change. Everything is going to affect this, and we already had a session earlier before we ended the year about the new updates that are coming up this year. So I think this is going to be a great one. So thank you so much for joining, and I already see Rag has joined us. Rag, a very happy New Year to you too. I hope this year will be great for you. And yes, please feel free to comment more if you have any questions on the topic. So let's go right in. I have this first question, Prashanti, and it is what does the shift to a merit-based H1B process really mean for applicants? And is it going to get harder from people, especially from the non-tech fields, to get selected under H1B?
Yeah, I think so, because basically the H1B merit based is based on, it's based on merit. So they're not going to be talking about the traditional H1B process whereby everyone is invited as long as they, fulfill the requirements of the H1, which is basically you have to have a job in a specialty occupation. So if they are going to be removing that criteria and removing the H1 completely and putting a merit-based criteria, or changing the definition of who qualifies for a H1 and making it more merit-based by modifying it somewhat. I think either way, it'll be a challenge to change it drastically, but let's presume they do. What does that mean? So the key aspects of a merit-based system would be that there'd be a point-based criteria. So merit-based system may prioritize applicants based on factors like education, skill, work experience, salary, maybe advanced degrees or specialized skills. So I think salary would definitely be a higher factor. So if you're getting a higher salary, you're more likely to get an approval under that system. Or it could be that only people who have a level 3 or level 4 wage salary would get an approval under H1 based system, and not the level 1 and level 2 would be removed completely. And we've seen that in the past where the Trump administration has tried to change the prevailing wage to make it higher to match level 3 and level 4. So employers offering higher wages may receive priority for their applications, and this could be a definite disadvantage for entry-level positions or lower-paying industries. So it would be more demand-driven in the sense that preference might be given to applicants in high-demand fields like tech, healthcare, STEM-related role, based on what the labor market needs are at that time. This could obviously impact non-technical fields, reducing opportunities for fields in education, in the arts and social sciences, humanities, and these fields also have a lower salary and fewer specialized skills. So they wouldn't be prioritized as much as maybe the tech industry and the health industry. But within the tech industry also, you will see that there will be a focus on higher paying jobs. So unless there's specific provisions that balance out across all the industries, I think non-tech may find it harder to compete, but let's wait and see. We're just talking about purely speculative. If
Yeah,
it would be based completely on merit based, then what would happen? As I said,
exactly.
emphasis, on STEM fields. Historically, also tech roles dominate the H1B program. Most of the H1B numbers are taken up by, in the tech people are working in the tech field. So a merit-based approach could amplify this, further, marginalizing the non-STEM applicants. Also, as I said, recent graduates, applicants with less experience might face more competition, especially in fields without a clear pathway to high salaries or advanced qualifications. So it depends on what the final outcome is and what it looks like. If they're going towards a merit-based system, how will they do this? How will they equalize non-tech and tech fields? Will they even bother to do that? Will they only
Yes.
go based on high salaries and not based on industry? We don't know. So all these uh, are open for speculation. Uh, but I think in general, non-tech applicants will find it maybe higher because their salaries are lower than tech industries salaries. So let's see. Any the tips for people who might get marginalized under this merit-based system? I would say they should focus on advanced degrees, um, showcase their niche skills if they have any, um, partner with employers, I guess, seek out employers who will be under that high demand industry. Uh, so these are a few things that can be done. Pursuing an advanced degree, so let's hope that it doesn't come to that. And even if they have some kind of a merit-based system, that it's a common sense based system and it does not marginalize anyone. So let's hope for the best. And
Yes.
only time will tell.
So true, Prashanti. And I mean, it's almost 30 years that you have been practicing immigration law, and imagine like no more lottery system for H1B. It's going to be so different, and I can only imagine. So we'll just have to wait and watch. But folks
Right.
out there, be prepared, and why not? I mean, you should always showcase your best side, and now the competition is not just the world, but also you, to be the best at what you are doing, so that you could be selected. So I think that's a good thing also, right, Prashanti?
Yeah, we should also keep in mind that all this is speculation and it's harder done than said, right?
Yes.
So, in order for him to make these drastic changes, I don't think he'll be able to do it just through regulation because that regulation will be then challenged in court because that's not what the Immigration and Nationality Act says, and he has to follow the law. So he might have to go through some kind of get congressional approval to make drastic changes, but he can definitely make changes through regulation, and that itself can have a big impact on the H1B process without him having to, do more drastic changes such as, changing it completely to a merit-based system. But he can implement some elements of the merit-based system and put it into the H1B program by just increasing the prevailing wage. Basically, what he's saying is only high salaried people are welcomed on the H1B program and not entry level. And that itself is kind of tuning towards a merit based system. And he can do that very easily. But of course, that also can be challenged in court. But let's wait and watch.
Yes, let's do that. Well, K. Vishwanathan is saying hello to both of us and hope we can post questions later. Yes, you can. Please do post. And you can also join us to ask your question, by dialing the number on the screen. And the access code is also given. So just join in, even through a call. Rag, it's been a real long time, that you've been commenting. And why not join us on call today? So yes, we would love to know you. Let's go on to our next. The Prashanti, that I mean, there's a talk about stricter checks on employers who sponsor H1B visas. So, what should both employers and employees do to stay safe? Play a safe game out there.
Right. Even as per the present, the H1B regulations that are going to take effect very soon, even as per those new H1B regulations, they've made compliance into a big issue, and they're saying now FDNS visits. FDNS visits are basically audits done by FDNS officers after the approval of the H1 to make sure that the person is, the employer and the employee are following the H1B rules or the LCA, what was said on the LCA. And they've made that compulsory. Before it was FDNS visits, you could allow the officer into your office or you could refuse to allow them. Of course, that could lead to a denial, but now they've made it mandatory. So if you do not allow the FDNS officer to do his job via an audit, then they can deny your case simply based on the fact of non-compliance. So they've done that. They've also, um, you know, kind of streamlined the H1B process, defined specialty occupation in a better way so that there's no room for ambiguity. They could still be, but they've tried to kind of define things more and make them streamlined. So in order to ensure that you can pass any audit or you can pass the stricter checks on employers sponsoring the H1B, if you're an employer, then you should make sure you maintain your accurate records, keep detailed documentation of the job, the salary, the qualifications. Make sure you maintain your public access file with all that information in there. Comply with the wage laws, ensure that your wage meets or exceeds the prevailing wage. In case there's an audit, that will be questioned as well. Of course, at any point of time, no matter which administration is in power, you have to avoid misrepresentation. Be transparent about the nature of the job and avoid inflating the job title or massaging the job responsibilities to make them, more attuned to H1B. Sometimes you may not be in a specialty occupation and you put in responsibilities that don't actually belong to the beneficiary in order to make it look more like a specialty occupation. Avoid doing that. But you can certainly explain your job more to explain how complex it is or why you think a H1 bachelor's degree in a specific field is required, as long as you don't make up stuff. So that's avoiding misrepresentation. Regularly conduct internal audits. Proactively review your compliance and visa requirements. Get in touch with your immigration attorney. They can help you with doing auditing your company as well for DOL compliance as well as USCIS compliance, making sure your public access files are in place, making sure everyone is being paid the prevailing wage, is working at the LCA location as per the LCA location. Your HR can easily do this as well. Make sure you're aware of what a public access file is, because a lot of you'll be surprised, but a lot of H1B employers don't know what that is. And that's the first thing that an officer would look at in an audit. Also ensure that you're paying your employees on time and you're not delaying payments more than is allowed by your state, by the DOL. So these are some of the things that you can do to make sure that you're always in compliance.
Well, thank you so much. Thank you so much, Prashanti, for taking that up and for the detailed explanation. And yes, we do have so many folks out there who have joined us. Please stay with us. We are going to take up your questions. K. Vishwanathan, Rajesh, Vikas, thank you so much for commenting. Rag as well. We are going to take your questions very, very soon. Rag says, wee hours here. Well, chat works better than calls. All right. Thank you so much. No worries, Rag. We are just looking forward. All right. So, moving on, Prashanti, we hear new definition about specialty occupation. So, especially starting this year, do you think that some of these jobs will not qualify as specialty jobs, or maybe they will not even fall under H1B anymore?
It's possible, though. I mean, I understand that they have redefined, or in a certain extent, redefined what is a specialty occupation. But the definition, I don't think. I mean, it depends on how you interpret it. But I don't think the definition is in any way more restrictive. At least that's not what it's meant to be. They have in fact said, with reference to redefining specialty occupation, they've said basically that what they've said is that a bachelor's degree in many fields can be required as proof that it's a specialty occupation. It does not have to be one field. But they've said also that the fields have to be well defined and they have to be related to the job. So if you're asking for a bachelor's degree in computer science, electronic engineering, math, physics, and that's the industry standard for your particular job. In the past, maybe USCIS would say that since it's various fields and they just would presume that it's disparate and different to various fields and they're not related and they would deny it. So now USCIS is saying, as per the new regulations, that it's fine if various fields are required, are common for your job, but you have to show how those different fields are related to your job. For example, if you're saying for a systems analyst that a bachelor's degree in math is required, you have to show how that math degree is related to the position of a systems analyst, and you have to go into the transcripts and see what is related in the math program that you did in the transcripts to your actual job. So that's what they're saying. They're asking you to be more specific, but they're allowing, they seem to be allowing different fields as long as the fields are related. So, but of course, under the Trump administration, we have to wait and see how that affects, under the Trump administration. It's very possible that even though the intent was something under the present administration, the Trump administration can interpret that specialty occupation field much more narrowly and restrict H1Bs further, and just based on decisions say that, oh, okay, we've got this explanation from you, but we don't agree with it, so we're denying the case. We don't think physics is anyway or math is anyway related to position of a systems analyst. So it's all dependent on intent. What does the present administration intend to do? And they can make use of the regulations, and there's enough scope there to interpret them in many ways to further their intent. So if they want to narrow the H1Bs in general, they can narrow it by giving decisions that have a more narrow definition of what is a specialty occupation.
Right, and they have. I think there are so many updates and new jobs coming up, especially with AI ruling over the world. I think there will be so much more additions as well. Apart from subtractions. So I think yes, Prashanti, you can.
Yeah, I mean, also Nipasa, based on his previous stance on H1Bs, previously the Trump administration has often emphasized reducing what it views as misuse of the H1B program. Of course, this is
Right.
in their world, they think that the H1B program is being misused, and so they're trying to clamp down on it. So they've introduced policies that make the eligibility criteria stricter, and so they narrow the definition of specialty occupation, as I said. And based on his previous executive order, Buy America, Hire America, aimed at prioritizing U.S. workers as opposed to non-immigrants, he has increased restrictions, made stricter whatever jobs that they perceive as non-critical. They've made it difficult to get H1s through those jobs, enhanced audits. We talked already about the higher wage requirements. He's done that. Again, redefining specialty occupation. So he's done a lot of things in the past, which shows that he is strict on H1B. But we have to see whether he will balance out that and look at what is the demand for skilled workers in the tech and the AI industries and in robotics, and try to loosen up the requirements in those areas. If he's influenced more by Elon Musk, he might do that. So let's see. We have to just wait and watch what happens.
Yes, there's still say about a dozen more days, and Trump is going to hit the office. I'm sure folks are all looking out for the 20th of January. So yes, and also we hear that the per country cap for green cards has been a hot topic, and they're going to remove the per country cap. So if this happens, how do you think it's going to impact the backlog, especially for Indian applicants out there?
Well, it hasn't been in the news as much as the H1B program has been in the news. Per country caps, yes, Elon Musk has talked about it. Uh, and some other people in his administration have talked about it as well. Um, and he has said, in some meetings that, he wants to make sure that students, don't have to leave, etc., etc.
Yeah.
So we don't know what will happen. We have to wait and see again. Per country caps for green cards. It'll be great if it's removed. What is the impact? I mean, a lot more people will get green cards, right? People who've been here for 20 years and been struggling to maintain their status on a H1B visa will get the benefit of it by getting a green card, and they will have more flexibility in their job. They will not be stuck with one employer. They will be able to open up their own businesses because a lot of these people are highly skilled and they have, gained those skills by working in the US for so many years. So to let go of that kind of talent would be just foolishness, I think, because these are potential entrepreneurs, potential leaders, people who will create jobs for sure. Because companies, even if they're working as employees, companies who hire such people will again hire more people because their business will expand. And also, these people could be entrepreneurs themselves and open up businesses just like Elon Musk did. He was on a H1B program. And if he had these restrictions, then we wouldn't have had Tesla and SpaceX, right?
Yes.
So that is the potential that we're talking about with reference to the green card numbers, opening up the green card numbers.
Right, right. Yes, Prashanti, thank you so much. And you already spoke about, Trump's past stance, on H1B. And of course, we all hear that he's going to make immigration policies even stricter and tougher. So, yes, I think there is a need for skilled workers also. So maybe if you could tell us what do you think on this also, even though industries like tech and AI are in need of skilled workers.
Are you saying what is the impact for skilled workers?
Yes, I mean, looking at Trump's previous stance, when he was on rule, and now Trump 2.0 coming in, do you think that his policies are going to get stricter and tougher?
Yeah, on the whole, I think passed on based on his previous government, what they did. um just going through that, there was a focus on Buy America, Hire America, and based on that focus, the number of denials went up by 30%. Now it's point something percent. The number of RFEs went up by 60%. Now it's some 3% or 4%. Um, and there were increased restrictions, audits, visas were getting denied. He, in fact, completely stopped any visas based, he said based on COVID, but he stopped people from coming into the country completely using, some old archaic rules, laws that were in place. So, Title 42. So we don't know if he intends to do that again. There was a Muslim ban. People from 7 Muslim countries were completely stopped from entering into the US. All these affected the H1B program. He wanted to introduce higher wage thresholds, and the DOL, in fact, published a regulation for those higher wages, but luckily it didn't go through. But as per that higher wage law, which was struck down by the court for some technical reasons, if they do it right this time, the wages, the minimum wages, say for a software professional, would be 200K plus, and that would pretty much wipe out 70% of the people that are eligible to file, or more, 80% maybe, to file for a H1, because there are not many people receive a wage of 200K plus uh, in the technical, in the IT space. So that can, severely curtail the H1B program. I don't know whether he intends to do that again or not. That's we have to wait and see, because they are, as I said, different thoughts right now. There is one group that is for a limited H1B program and one group that is completely against the H1B program. But even Elon Musk is for uh, encouraging higher wage people and not so much entry level. So I think on the whole, IT consulting companies are going to be
Safe.
facing trouble. IT consulting companies are going to be in trouble because no one seems to be advocating for them. Um, so let's wait and see what happens.
All right. All right.
Again, a lot of it, um, even though they want to do it, they may not be able to. They can do it to a certain extent, but they may not be able to do a whole lot. It can be what happened in the previous administration, so we can expect that. That may be what they can do, because more than that, then they will have the courts will get involved. Then they might have to pass new laws, in which case they might need. um majority in both the House and the Senate, which they have right now, but they might be not all Republicans may approve of those changes. So we have to wait and see. Everything is kind of, up in the air.
So true, so true. So much is being said than really happening right now. I think we just have to wait and watch. But Prashanti, I think now we should address some of our questions from the viewers. Let's not make them wait too long. So let's take up this first one from K. Vishwanathan. It's not about H1B. Let's see if you would like to take it. It's about L1 visa blanket. So he says, mine is still at a petition stage and working to close before the 17th of January as he chats now. His attorney has asked for additional cost if it gets filed after the 17th. Yes. What are the challenges and changes? He's asking.
In general, L1 blanket, if you're L1 blanket, I'm not sure why you're working with USCIS with an attorney, or maybe the L1 blanket is being filed at the consulate by the attorney. But either way, L1 blankets are usually easier to get approved than individual L1 applications. If you've submitted your documentation and you're likely to file, submit your case by January or earlier the better. You might not be affected too much by the changes because it takes time for these changes to happen. I don't think it'll happen on day one. But having said that, we are already seeing certain inquiries at the consulate level, certain denials that were not there before. We're seeing certain RFEs being sent by USCIS, which were not sent before. So even before Trump comes in, we are seeing USCIS is gearing to a more Trump-like USCIS already, because the change of administration is a few days away. So that we see that they're already becoming more restrictive, but definitely makes sense to file sooner rather than later.
Thank you so much for taking this up. K. Vishwanathan, I hope you're here. We're sorry for keeping you waiting too long, but I hope that you got your answer. And let's move on to our next one. This is from Indu. Hello, ma'am. My petition is still showing actively reviewing. When can I expect the result?
I'm actually not seeing any of the comments on the side panel for some reason, but if we can have that, that'll be great, so I can read it. But so what is the question, Tipasa? And I'm not seeing any questions scrolling on the screen either.
You don't see it saying, hello, ma'am. My petition is still showing actively reviewing. When can I expect the result?
And now the video has frozen. Can you see me or?
Yes, we can see you.
Okay, well, let's just go with it then, because my video is frozen from my side for some reason.
Okay, but then we are perfectly very clear. I mean, there is no lag,
Okay,
nothing.
okay,
So,
okay. So let's just go with it then. So what is your question? Because I don't see the scrolling.
he says his petition is still showing actively reviewing. So he's asking when can he expect the result? This should be about his H1B status, I guess. Petition.
Actively reviewing,
I
again, it depends on whether it's premium processing or whether it's regular processing. Premium processing, usually you'll get it very soon, in a week or so. If it's regular processing, it can take 3 to 4 months. So I suggest that you convert to premium processing if you haven't done so. I know it's expensive, $2,000+. But it's regular processing is taking about 3 to 4 months.
Okay. So, Indu, I hope you got your answer. And let's go on to our next question. This is from Rag. Rag has a question again about L2 and H4. Bundling with L1 and H1 is going away on the 18th of January. What does this mean for the first time L2 H4 applicants?
We don't know that the bundling of H4 is going away completely. Yes, it is set to, as per the court decision, it is set to lapse, but it is possible that the present administration or the future administration could renew it. So again, that is up in the air. But if they don't, then we will look at again delayed processing times for H4 and H4 EAD. It could take, if they are processing it alone, even now we are seeing that it's taking 8 to 10 months to process. During the Trump administration, we saw that the H4 and H4 EAD, though they could not or did not make any changes with reference to removing them, they delayed the processing time to such an extent that it became, the benefit was completely nullified, because it was taking 18 months or so for people to just get the H4 or H4 EAD, and nobody, especially if they're working, if it takes so long to get an EAD, then it nullifies the purpose, and then they cannot remain in their jobs. But now with EAD automatic extensions, that should help, even if there's a delay in processing, unless the Trump administration removes that EAD automatic extensions, then of course, then it would affect you negatively, and then you may not be able to remain on a H4 EAD because your job will not, nobody will keep the job open until you get the extension.
So true, so true. Thank you so much for taking this up, Prashanti, for Rag. And folks out there, you can join us on call. I mean, this goes to everyone, Indu, RK, Rag, the Silence Files. You can join us on this number 425-436-6335, and the access code is 988-888. And once you're in, just speak. We will be able to hear you. This goes out to also K. Vishwanathan and everyone else who have joined us today. So my next one, let's take this one. Train me, saying, "Hi, this is Kiran. I am an H1B holder. My I-94 is expiring on 12th of January due to my passport expiration. I have applied for my passport renewal, but I do not have a new passport yet. What should I do?"
So they're saying that the I-94 is expiring because if the I-94 is expiring, they can apply for an extension, right? But she's saying that the passport is expiring.
Yes, the I-94 is expiring on 12th Jan because of the passport expiration.
So what is the question?
So the question is, I have applied for my passport renewal, but I do not have a new passport yet. What should Kiran do?
So if you can file an extension of, I don't know on what status she is or he is, but they can file for renewal of their I-94. They have to before it expires. If they don't, then they have to leave the country, and they should be able to file without a passport, and then there will be an RFE, and then it's possible maybe to submit the passport upon receiving the RFE, and then hopefully USCIS will adjudicate your case. Though USCIS might say that you don't meet the requirements as of the date of filing. If they follow that strict interpretation, then you're in trouble. But if they don't and accept your passport, then it should be okay. So I would file for an extension either way, or leave the country and not allow your I-94 to lapse, whether you get your passport or not.
Okay. Thank you so much for taking this up, and I hope, Kiran, you got your answer. Now, well, the silence files, I think we should take the question up. He was saying, can you please pick my question? Yes, we can. So this is on your channel, Prashanti. So asking, I got 221G. Should I wait or look for transfer of H1B approved petition to new employer? And how to find new employer?
I can't help you with how to find new employer, but with reference to should I wait or not, that's up to you. But it really depends on what is the strength of the present H1B petition that you have. And it also depends on what they're asking for in the 221G, and whether the employer is able and willing to submit those documentation. If it is a legitimate case, and if they're able to submit the documentation, whatever is asked for, then I think there's no harm in waiting. But if you have, that they are asking for something which your employer is not able to provide, or will not be able to provide in a satisfactory manner, then you should definitely look for a new case. So it's important to evaluate your case and then decide. But even if it's a good case, you should know that it will take some time maybe to process it. Once it goes into 221G, it could take 6 months, 1 year. So you have to be patient and willing to wait. And it's worth it. The wait is worth it if you think you have a good case. Otherwise, you might just be better off filing another H1B cap exempt petition, since you certainly qualify for that, at least based on the present rules.
Okay. Thank you so much for your question, the silence files, and I hope you're happy to get your answer. Thank you, Prashanti. Well, K. Vishwanathan is back, just asking one question: is L2 work permit also being withheld?
No, an L2 is something that is automatic with an L1. You don't even have to file a work permit as per the new regulations. So unless they change the regulations and make you file a L2 application, that's what it is. And there is no talk about taking away the L2. There never has been. It's always been about H4 EAD, because L2 has always has been there for many years. And no one has talked about removing it.
Okay. Thank you, Prashanti, for taking this up, and I hope you've got
And
your
I
answer.
think
Yeah.
L2 is also part of the regulation, part of the L1 regulation. So it'll be more difficult to take that away. But whereas the H4 EAD was done as an executive order, so therefore people talk about removing that because it's easier to do it.
Okay. Well, thank you. Thank you. He says he's listening and learning. Thank you so much for joining us, K. Vishwanathan. And stay with us. Maybe you could just stay up, learn more till the end. And also, now let's take up RK's question. How would the new requirements of the bona fide job offer work when filing a new H1B base of the new regulations? Also, what would be the impact on third party placement?
Right. So this is the bona fide job offer is part of the regulations. We were expecting this. This has always been something USCIS has asked for in the recent past, at least in the past 10 years. And only recently in 2020, because of the IT Serve versus Cessna decision, USCIS reserved the right to ask for bona fide employment, but did not really ask for in-client letters and purchase orders, etc. But now they have put it as part of they were waiting to put it as part of the regulation. Now that they have included it in the regulation, which can certainly be challenged in court, even though it's a regulation, but more difficult to challenge it. The bona fide job offer means that, especially in the scenario, like you said, third-party placements, that is an IT consulting company scenario, it plays a big role because in order to show that you have a job, you have to provide then the contracts and work orders that you have with your end client, because that's how third-party placement works. That's how consulting companies work. They don't hire people directly, but they place them at third-party sites. So they're asking for contracts, work orders, vendor letters, end client letters. They can ask for contracts between all the layers if there are 2 or 3 layers. So they can start asking for all that. And they can certainly restrict the duration of the H1 if they see that the contracts are not there for 3 years, or you're not able to show a bona fide job offer for 3 years. But they have said kind of in the regulation that they don't intend to do that, to restrict the H1B term to coincide with what's in the purchase order. But with the new administration coming in, they might do that as well. So you're looking at, you cannot file H1 speculatively anymore. If you're an employer, you have to actually have a job available in order to file, which is challenging, especially for cap cases, for new cases, because you file the H1B cap cases 6 months in advance generally. And when you file that, you might have a job offer in place, but no client generally will wait for 6 months for you to get the person into the US because, jobs usually fill up faster, and usually the requirement is immediate. So if they might close out the requirement if they don't get anyone, and maybe have someone offshore work for them, have their offshore company hire someone. And that's what we're talking about, right? By restricting the H1Bs, you are taking all the revenues offshore. So Costa Rica, Mexico, India, these countries definitely benefit, but the United States doesn't.
Yes, so true. Thank you so much, Prashanti. And RK, thank you for your question. I hope you've got your answer. And now let's go on to Esther's question. Esther's saying, I got selected in the H1B lottery 2024, filed my petition around May, got a response in August, but it was an RFE on my qualification. Basically, what they were saying in the RFE was that the job that she was applying for doesn't relate with her qualifications. And my attorney advised I add an expert opinion letter to the new petition and some other documents. What do you think are my chances? She even said that she filed the RFE in October 2024, but she did not get a response yet. So what should she do, and what should she expect?
What are your chances? That really depends on what your qualifications were and whether they were related or not, whether you were able to make up a case, make a case that your qualifications are related. Maybe you put an experience, maybe you get an expert opinion letter for a work experience evaluation, or maybe you showed that the degree was related by itself by comparing your subjects that you took with the job, like a table comparing the two, the job duties versus the subjects that you took. That's generally what is done in order to show that there's a relationship between the job and the degree. So it really depends on how strong your case was. If it was a strong case, then you can expect an approval. But of course, there are anomalies always. Sometimes even when you do the right thing, and you show that you're qualified, USCIS can deny those cases. In which case, it might be a good case for appeal. But I would say just you have to wait and see, because I don't know what are the details of your case. And even if I did know, I don't know if the USCIS officer will follow the general norm of who qualifies and who doesn't, because nowadays strange things are happening. So I guess you have to wait and watch. If you are, if you want to get a response faster, I would suggest you convert to premium processing, so that you'll get a response within a week. Remember, even if it gets denied, you have 30 days to file an appeal. And once you file the appeal, it is possible to then file for a change of status to a different status, or file a transfer or whatever, to a different status if your I-94 is expired. If your I-94 is not expired, then you're fine. You can just, if it gets denied, then status quo is maintained, your present status is maintained, and then you can figure out what you want to do, maybe file another H1B petition under the cap, but you certainly will be subject to the cap again because your H1 was not approved.
Right, right. She says thanks, and she was also saying, do the USCIS also request for tax return from the employer?
They could, but depends on the circumstances. Usually they don't.
Okay. Okay. Thank you, Esther, for joining us with your questions, and I hope you've got your answer. We also have the silence files coming back with another
I
question.
like the name.
So, yeah, what's the name? I wonder. Yes, please tell us your real name. I mean, this problem
Or
just to
what
use the
it
name.
means, what silence files means, what
The
is signal
silence file
files?
sounds so
Yeah,
mysterious, right?
very
But
mysterious.
yeah. So saying, my employer has not received any email till now from the consulate, and that is a small employer with an in-house project only. The interview
Hmm.
was on the 3rd of January this year, I think. Yeah.
So that is not, I mean, hold your horses, be patient. January 3rd is not that long ago, right?
It's just
You're
5 days
expect
back.
you're expecting, like, something, a response for 221G in 5 days. You have to be patient. But having said that, since it's a small employer, like you said, in-house, it doesn't seem to be a very strong case. But I wouldn't say that you have waited enough time to know that or not.
All right. Patience is virtue, and all the best. Just wait a little longer. I'm sure they will get back to you. And Muhammad Ali says, nice to see you here again. Nice to see you too. Thank you so much for joining us. We have some more questions from our end. I think we should take them up. Control, if you could display them, please. Uh, they'll be great. But before that, maybe we can also take Rajesh's question. Meanwhile, saying, I've heard a lot about potential changes to the H1B lottery system. If the rules change again in 2025, like focusing on higher wages or prioritizing certain industries, how will they impact someone like me who is applying from a mid level tech job?
So if you get into level 3, maybe you should be okay. But if not, there might be an issue. You have to wait and see. If you are level 3, maybe you're okay. We don't know. Again, because nothing has been defined as yet, there's no clear understanding. We just have examples of what was given last time. The way the wages were structured, they said that even anyone below 200,000, again, it depends on which state you're in, but which county you're in, but they said that 200,000 was the average salary based on the new DOL prevailing wage calculations. So then you would know whether you're in or not based on the previous wage rule. We don't know whether it'll be the same wage rule that comes in. Even if it comes in, whether it'll be upheld by the courts or not. Previously some decisions by Trump were upheld, others were not. The Supreme Court upheld the Muslim ban, right? Though the lower courts uh, said it was unconstitutional, but many other Trump rules were not upheld by the court, such as the wage law, the H4 EAD law. So we have to wait and see what happens, really. Hard to say,
Okay,
but looks like you might be affected if it comes to the wage rule based on, what the previous rule was.
Okay, okay. Thank you so much, Prashanti, for taking this up for Rajesh. Um, say,
Um,
K. Vishwanath is
can
back.
you just give
Yeah.
me, I just need to plug in my computer. Can you give me a minute?
All right, sure.
Sure.
Sure thing. And meanwhile, folks out there, you can join us, on call as well. You can dial this number 425-436-6335, and the access code is 988-888. And once you're in, you will be able to speak with us. I mean, it's so great that you have joined us by commenting, but it'll be great to even hear you. So you might as well join us. And meanwhile,
I'm back.
folks, you can also contact our attorney, and you can have a call with her. You can even email her. Her number is 212-354-1010, and her email address is prashanti@reddyesq.com. And also go visit www.reddyesq.com to get to know more about Prashanti. And good to have you back, Prashanti. Well, let's take up some questions from our Facebook and YouTube, if since we still have about a couple of minutes. So, Control, if you could display, please.
By the way,
So this,
just to let you know, I
yeah.
can't see anything, so you'll have to read it out.
Okay, sure, Prashanti. Saying, hi everyone. I've been job hunting for a few months, and with my visa nearing its end, I'm considering returning to India temporarily. I'd like to get your thoughts on the current hiring trends. I am on H1B visa with 3 years remaining. So I wouldn't need to go through the lottery process again. However, I'm curious, do employers tend to prefer local candidates over someone outside the US, even if the sponsorship process is relatively straightforward? And how easy or difficult is it to come back to the US if I leave without a job? He or she would like some perspectives.
Right. I mean, it's a good question, and everybody's asking that question, especially with the number of layoffs in the tech industry recently. I get people at least one call a day uh, in the same subject. Um, so it's hard to say when you'll get your next job, right? But it is true that a lot of companies don't want to sponsor for a H1 because they're just not comfortable with the process. It is a process that may be straightforward, but involves paperwork and is a learning curve. So if you've never filed a H1 before for that employer, it seems like a lot of work. Uh, and there is also compliance issues. You have to pay the prevailing wage, you might get audited. So employers don't want to deal with all that. So employers who are used to it and who have done it might be willing to, but people who have not done it before might hesitate to. But the thing that you have in your favor maybe is that they may not find a US citizen or a person with a VEAD or a permanent resident uh, to fill that job. If they're not able to, then they are forced to then file a H1, which is the case in most instances where people, are first-time H1B filers, employers are first-time H1B filers. It's because they can't find anyone who's a US citizen, or it could be that they don't find a candidate that's good enough as you, that's as good as you, right? So they are willing to go through the process no matter what, because you're the best candidate that they have. So that's a possibility. And what was the second part of the question?
The second part of the question was, how easy or difficult is it to come back to the US if he
Yeah,
leaves without a job?
right. Then you have to find a job while you're outside the country, which is maybe difficult because most employers require you to go through an interview if
Right.
and maybe they're not comfortable with video interviews. If they are, then that's certainly a possibility, but they might want to do an in-person interview, in which case you're at a disadvantage. You could get a job with a consulting company because they don't care, but in order to get an end client or to be picked by an end client, again, they're looking for maybe in-person interviews. So if they're willing to do video interviews, again, they want you to be in the US. They don't want you to be taking the video call from India. That's also a restriction. with some employers. So it depends really. Definitely your chances are less if you're outside the country versus if you're in the country. So you might want to consider filing a change of status to student status or visitor's visa status. That will give you some time to recoup, maybe find another job, improve your skills, etc., etc.
Thank you, Prashanti, for taking that up. Let's go on to our next quickly. I mean, if you still got a little time, some more time, Prashanti.
Sure, maybe one or two more questions.
This one is saying, "Hi all, I'm switching from my current employer to new employer. Please let me know if it's odd mandatory to take the I-140 approval document from the current employer. It's a consultancy, so I'm not sure if they will give."
Yes, you would need a copy of your I-140 approval. You don't need the original. You need the copy so that you can file for your H1 beyond 6 years, because you have to, if you pass the 6 years period, because you need to submit a copy of your H1B, your I-140 approval when you're filing your H1 beyond 6 years. So definitely need a copy. You don't need the original.
Okay.
And you also need a copy of the I-140 to port your priority date in case you are leaving and another employer is filing your green card. Then you should port the priority date from your previous I-140, and for that also you need a copy.
All right.
It is,
Thank you. Thank you.
having said that, it is sorry, it is possible to get, if your employer is not giving you a copy, it's possible to get uh, part of the I-140, not the exact copy approval, but enough for you to file. When you do a FOIA case, Freedom of Information Act, under the Freedom of Information Act, they do send you a stamped I-140 petition, which can act as an approval.
Well, that's very interesting. Thank you so much, Prashanti. And maybe let's take up one last before we leave. And if you could tell us, please tell the possible outcome for scenario like a mechanical engineering graduate with 10 plus years of experience in software development.
I think you qualify because you just need to get a work experience evaluation done. Since you have 10 plus years experience in the IT field, you have good experience letters. Get the evaluation done before you file the H1, but you should be good.
All right. Thank you so much, Prashanti. I know there's so much more to talk about, but Shushant has joined us on YouTube asking, what about for EB3, all other countries? Well, I think we will touch up on EB3 in another episode, Shushant. But thank you so much for joining us. We have been discussing today about H1B and how does 2025 look ahead, for H1B applicants. So I'm sure there's so much more to speak about, right, Prashanti? And we would like to come back maybe with this topic or more new topics on what to expect this year, since it's the beginning of the year. So, Prashanti, maybe before we leave, if you have any notes or tips for the audience out there who are really anxious to know, what's going to happen with their H1B this year.
Yeah, definitely it is. I understand why you're anxious, and we are all anxious as well for you. And the good thing is that you have the support that you need. Make sure you keep in touch with your attorney to so that you can get updates on what is happening, or if there is any situation that goes south, you can take their advice on how to proceed. So always keep abreast of the news, stay in touch with your attorney, make sure you get the proper advice. It may not affect a lot of people, but it'll affect some people. um, and we have to just wait and watch. We can't react before we know what the process is or what is going to happen. There's no point in being anxious about what we don't know. The only thing we can do is be prepared rather than being anxious. So be prepared for whatever there is to come. Have alternatives in place. Always have alternatives. So if one thing is not working out, you should be able to have an alternative that you can switch to, maybe an F1, maybe a H4 EAD. Um, you know, Maybe you go to Canada because it's not worth staying in the US anymore. uh, so, there are alternatives always. So keep alternatives in mind. Don't be anxious, just be prepared.
Thank you so much. I think that's a great tip, to be more prepared than just being anxious. And here's wishing that 2025 is going to be great for all of us, employers, employees, professionals, and even attorneys. So thank you so much, folks, for joining us. And K. Vishwanathan says, thank you for answering with ease, Prashanti. And my wife seems more comfortable to quit here if we succeed in this visa dream. Well, that's that's a good one, I think. So thank you so much for joining all of us, and just wishing all of you a wonderful day ahead. Thank you so much, Prashanti, once again. And folks out there, you can also consult with attorney Prashanti. Her number is 212-354-1010, and her email address is prashanti@readyesq.com, because that's where she will be able to get in touch with you better, know your case better. So yes, do get in touch with her. Thank you for joining once again, and have a great day ahead, everyone.
Thank you.
All right. So,
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into the topic, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your own risk. All right, so folks, once again, welcome back to Immigration and Jobs Talk Show. I'm Sam, your host. And today we have got again a very timely and crucial topic. That is the new H1B rule. What employers and workers need to know and why it's a game changer. Well, it's actually a game changer because the new H1B rule has modernized the visa process. But how, what are the key changes, then how does it impact both workers and employers, and what you need to do to stay ahead? To answer all these questions in detail, we have a very special guest with us who has joined us for the fourth time. That is attorney Poonam Gupta. And she has over 25 years of experience in immigration law, plus a solid background in intellectual property and litigation. So, welcome, Poonam. It's always a pleasure and lovely having you with us on our immigration show. And it feels so great to have a show with you and so much to learn from you as well. So, thank you so much for joining us.
My pleasure, Sam. It's great to be back, and I'm excited to bring the key topics and key learnings from this new H1B rule that's finally come to fruition. It was first proposed in October of 2023, and it has now just been released and will become effective January of 2025. So, super excited to delve in, and I
yeah.
hope people have lots of questions. If not, I have lots of things to share because a lot is there to pack and unpack.
Absolutely, that is, and but before diving into our today's topic, Poonam, I would like to know it's just 5 days to go Christmas. So, how is your Christmas preparation going on? Are you excited?
I am super excited because I'm going to take some time off and unwind and relax with family and friends. And so, super excited about that. And I hope everyone else does the same.
Absolutely. I think all our viewers are also very much excited because it's Christmas time, right? It's super exciting time, and holiday days also are just coming after a few days. So,
Sure.
yeah, I think with that also, folks out there, let me tell you that we are also live on YouTube, LinkedIn, Facebook, and on X as well. So, watch this session and put all your questions, your queries, whatsoever you would like to know from Attorney Poonam Gupta, and we would be more than happy to have them. All right, so let's begin with this very first question of mine. That is, Poonam, what is, or can you please explain the main changes that has been introduced by the new H1B final rule?
Sure. So there are lots of changes in this new rule.
Mhm.
As I mentioned previously, the first iteration of this rule was proposed back in October of 2023. Partial implementation of the rule happened last December, and those rules went into effect in January of 2024. The remaining portion from that 2023 rulemaking proposed rule has now been issued this week, and this will go in effect on January 17th, 2025, just days before the new president takes office. What is the purpose of this rule? The purpose of this rule is to codify USCIS practices and introduce some new provisions. So, some
Mhm.
of the new provisions that were introduced include an expanded and more robust definition of specialty occupation, which is the hallmark of H1B. And to qualify for H1B, the second is the elimination of the itinerary requirement, which is if someone is placed at any at a location, then previously employers were required to identify when they will be working and where, for how
Mhm.
long, and so on, and that requirement has now been removed. And one of the most exciting pieces of the rule is the expansion of the definition of not for profit and what it means to be uh, cap exempt and how to secure cap exempt H1B. The expanded definition makes it a lot easier for organizations to qualify as cap exempt and thus hire more workers. And it actually requires people to not directly work at those organizations, but even if they're working uh, with that organization and working towards that essential function of that organization, they could still qualify for this cap exemption. The next exciting part that's been introduced in this, which was much awaited by entrepreneurs across US, for a long time, is the option for startup owners to sponsor themselves for H1B as long as they have an entity, a company set up. And even if they own the majority stake and they have the majority ownership, they're still able to sponsor themselves. In addition, there is the codification for that there has to be a bona fide job offer, um, amended petitions, that when an amended petition is required, deference policy was codified, as well as the evidence of maintenance of status that is required for each petition for change or extension of status. The one key piece that has been in USCIS practice, but has now been codified, is USCIS has expanded its authority to conduct site visits to ensure compliance with H1B requirements, including for third party placements, and non cooperation with the site visits could result in a denial or revocation of the H1B. So, in short, I know it's a lot that I packed in, but in short, that is what is a quick summary of what's happened in this new H1B rule.
All right, all right. Thank you so much, Poonam, for letting us know about what are the main changes that has been introduced by the new H1B final rule. Also, Poonam, do you think that the new H1B rule is going to benefit workers and employers? And if yes, then how?
So there is definitely benefit that will come through for everyone. The
Mhm.
biggest benefit will be the clarity that comes through. There is clarity on what is specialty occupation, what is required, the government clarifies in their proposed rule in their rulemaking document, the notice in the Federal Register, and address the various scenarios, and they go in great depth on what is it that is required for each. When is it considered specialty occupation? When is it not? When is a general degree okay? When is it require a specialized degree? In most instances, a general degree may not work and may not qualify someone for an H1B because it will not be considered specialty occupation and so on. So there's definitely clarity around that, and removal of the itinerary requirement is a huge benefit, especially for IT staffing companies. That really helps. That should help. What may not be as beneficial may be the increased site visits, the increased access, or sorry, the streamline. I mean, there is streamlined processes, but there's also additional requirements on what is an employer required to present when it comes to qualifying for an H1B. The government has the authority to request contracts, whether it is with end clients or third party clients, or they may be intervening agencies before the H1B employees placed at an end party client, and the government has expanded its authority to request any contracts or master services agreements or the like. So that may add more burden on the employers, but by and large, I think all in all, yeah, this rule is a positive, is a good thing. There are a lot of good things about this.
All right, that's great. Also, Poonam, there's some mentioning about a specialty occupation. So, I would like to know that how does the new rule change the definition of a specialty occupation for H1B visa, and what does directly related mean for the required degree too?
So USCIS has gone and spent considerable time in explaining that they are not actually changing the definition drastically. All they are doing is codifying what USCIS practice currently is with regards to specialty occupation. So the current practice is that the government requires a nexus between the degree that the individual, the beneficiary, or the employee has, and the position. So there has to be a direct connection, a direct nexus between the two. If a company cannot show that there is a connection between what the degree required for the position is and what the person has, then there may be problems. But to the extent that a company can show that there is a nexus and there is a connection, then then there should not be any problem. It's more clear compared to before, if that makes sense. I can give an example. So one of the examples that the government lists in the rulemaking is an engineering degree for a software developer role, and they say not any engineering degree can surely qualify unless the government shows that there are specific courses within any engineering degree that would help in that software developer role. So, for instance, a chemical engineer or a mechanical engineer, by definition, at least on the title, and the government has spent considerable time explaining that just the title of the degree is not material. It is what the substance and what courses are taught in that degree. And because titles vary from university to university, program to program, the titles are not as positive. It is what is the actual coursework and how that relates to the role that matters. So that is what directly related means, that there has to be a direct nexus, direct connection between the coursework and the position.
All right. But also, Poonam, I have this question in my mind that now we can see another way of specialty occupation definition. So now it shouldn't be much specific about the work that the workers are going to opt for. So do you think it's going to be beneficial for the company? Because if specifically not that employer is looking for that specific degree, that overall degree can be applicable. So do you think it's going to benefit, or that employer or that worker needs to be highly qualified in that specific work, then only it's going to beneficial for the company?
So there are several pieces to this, Sam, right? One piece is when the person has, so the position can require one degree or it can require multiple degrees, right? And the government has always held this position. And what they've done with this new rule is codified that position, is that if an employer requires multiple degrees, it has to show how each degree is relevant to the role. So,
Yeah.
for instance, if a position requires finance, economics, statistics, all related, then it has to show what part of the finance degree is directly related to the role, what part of the economics degree is directly related to the role, what part of the statistics degree is directly related to the role, and so on. So that is the directly related part. In terms of, does it exclude individuals that have experience? No. The government is still going to look at, as it currently does. It's not a change, nothing's changed in that perspective. It's only clarified and codified what USCIS currently does. That if someone has an Indian degree, an Indian bachelor's degree, which is a 3-year degree, and a few years experience, then there is a possibility that the combining the degree and the experience, the person could qualify for a US H1, an H1B role based on a degree equivalency, which is based on just the 3-year degree plus a few years experience, which would equate to a US bachelor's degree, which, as you may know, is required for an H1B. So the government looks at the totality of what the situation is, and not just the title of the degree, not just
Right.
the experience or whatever. So it's everything combined together.
Absolutely. And also, Poonam, we have one of our viewer here, and here's Chetali here, and she's watching us from LinkedIn. So Chetali has another question that does codifying help H1B holders? Will it protect them from the next administration from, uh, I think,
Making any drastic changes to the H1B. So
yeah,
yes, thanks Chetali for joining us. The question is a good question. Codifying helps both the employers and the employees, because it provides clarity to the to everyone. What is the standard? What is required? In terms of, will it protect someone from drastic change? There is codification of the deference, as in the deference policy, which means that if an employee is continues to work for the same employer and applies for an extension of the H1B status, then unless there is a drastic deviation from the previous application, the government will give deference to that same application, that extension application. So, to that extent, there is a limited protection under the previous Trump administration. We saw individuals who had held H1B status for an extended period, in 10, 12, 14 years, their H's were denied on extensions because the Trump administration revoke the deference policy, as in every case would be reviewed afresh as if it was a brand new filing. By codifying the deference within this new rule, the government is providing a limited amount of protection, not a blanket protection. They've refrained from expanding the deference, but there is some limited deference.
All right. And thank you so much, Adali, for your question. As this was my about to question because I was about to ask this question only. But that's okay. I think, Poonam, you have explained it. And Chitali, if you still have any follow up question or would like to know any other topic or any other question that you have in your mind, then please feel free to post them in the comment section. And for an hour, we are here. So please go ahead and utilize this opportunity. We will definitely take your question up. And here's another question from Anisha. And Anisha is asking that does the rule address dependent visa like H4 or their work authorization?
No, Anisha, thank you again for joining us. Unfortunately or fortunately, we don't know, we'll see. But the rule is focused purely on H1B and does not address any dependents or the H4 work authorization. There were some comments in the rulemaking about immigrant visas, and the government said that is the outside the scope of this rulemaking. But there were no comments about, or at least I didn't see any comments about dependents. But there are definitely no rules or no impact or changes to the dependents or their work authorization in this new rule.
All right. So thank you so much, Poonam, and thank you so much, Anisha, also for your question. And Chitali is saying thank you. This was really helpful. Thank you so much, Chitali, also. And let's move ahead with another question, Poonam, that I have for you. That is, how does this rule impact the eligibility of workers with degrees in business administration or other fields that were previously considered general?
Right. So this is where this may be slightly problematic, right? Individuals that had a general business degree, and the government clarifies that it is only the bachelor's of business administration that may be problematic without a specific major or a minor. When there is a major in that, even in that business administration degree, it is considered specialized. It is when there is no major that that is a problematic issue. If there is a major, no issue. If it is a master's in business administration, again, no issue. They are considered specialized by virtue of being master's degree. But it's only the bachelor's in business administration, which did not have a specialization, that may run into trouble under this new codification. Everyone else should be okay.
All right. Okay. So here we have also Anisha, and who says, "Okay, thank you, thank you so much, Anisha." And to you also, if you have any question or follow up, then please go ahead and post them on the comment section. We will take them up. And thank you so much, Poonam, for detailing that up and answering all the questions very patiently. Here's another question that I would like to know from you about the site visits. So, what role do site visits play in the new rule, and what should employers be prepared for?
So previously, site visits were always part of USCIS Arsenal, the FENS arm of USCIS, which is the fraud detection unit, always was involved in investigating any situations where they thought there was fraud in the USCIS, in the H1B applications. But with this new rule, they've codified their authority and said we can conduct site visits to see what is happening and to request information from the employer as well as the employee. And these site visits are unannounced, but if there are attorneys that are representing those employers, they can ask the site visit to be rescheduled so that the attorney can be present. The attorney can join by phone as well, but it is possible that they can reschedule it uh, to allow the attorney to be present. But they are very, very clear that if the employer or the employee do not cooperate or provide the requested information, it can result in the denial or revocation of the H1B. So it is absolutely critical that employers are prepared for any site visits. They are prepared with having all their documentation absolutely in order so that they are well ahead of the curve. In addition to the site visits, I anticipate that under the Trump administration, the site visits will definitely increase given the focus on enforcement. In addition, I imagine the I-9 audits will increase under the Trump administration as well. So those two, while separate, are all part of the immigration compliance, which every employer, if they are not thinking about, should think very, very seriously about. These are not things to take lightly. There are severe consequences
Yeah.
of not being prepared, including revocation of petitions, including fines and criminal penalties in some situations in an I-9 situation. So there's a lot to be prepared. And I urge all employers to talk to their immigration counsel, talk to their attorneys, and get ahead and be prepared for what's coming very soon.
Absolutely. I think everyone should be very much aware about this, and they shouldn't be taking this thing lightly because some or the other it's going to harm them. But also, Poonam, as you said, that we can see in Trump's administration the site visits going to be more stricter. But
Correct.
till now, we have heard this from most of the people that most of the people are against site visit. They don't like this concept, and Trump is completely in favor of this. So, what's your take on this? Do you think that site visits can be beneficiary, or is it going to some on the other? There are some other challenges that people they might not know about it.
So, site visits are a double-edged sword, right?
Mm-hmm.
Um, for employers that are fully compliant,
Mm-hmm.
site visits help establish their credibility with the government. They help cement um, the perception that the government may have
Mm-hmm.
for how a company and the amount of scrutiny that the company may receive from the government going forward after a site visit. But for employers that are playing fast and loose with the rules or, you know, on the edge of compliance and not really focused on compliance,
Mm-hmm.
this may be problematic. So it is important to focus on the compliance piece more than ever under the upcoming administration.
Right. I think very well explained. And meanwhile, we also have another viewer, Zishan. So, Zishan is here with another question that can you please talk about opening up the company or startup?
Sure. So, Zishan, welcome and great question. A lot of students, a lot of individuals want to start their own companies as a student on OPT or so on. And up until now, being you could start a business on OPT, but when it came to STEM OPT, you couldn't, or you could, but they could. I mean, there were ways around it, and there still are ways around opening your own and working on your startup while you're on OPT or STEM OPT. But then what about after you're done with OPT and STEM OPT? What was the path forward? Up until these regulations, there was no path forward. Now there is a path forward. Individuals who or have a majority ownership in their companies not them individually. So the government has made this distinction. It is not individuals, not entrepreneurs who are looking to sponsor themselves that will be able to benefit from this rule. It will be individuals who set up a formal entity, a company, of which they may own the majority share, majority ownership, but that company is able to sponsor the owner for H1B as long as the individual is working in a role or performing duties that are majority specialized in nature, that are aligned with their degrees, that have a direct connection to their degrees, and for the majority of the time, they're performing that role. The government does not expect 100% of the time to be on those specialized duties, but only a majority. They've given and acknowledged that a company owner needs to do other things, whether it's making copies or making calls or seeking investors or pitching to business or pitching for funding or anything else, as long as that running of the business does not overtake the individual's role, they can qualify for H1B. One of the guardrails that they have put in place to prevent fraud and abuse of the system is that the petition will be only valid, that H1B initial petition by an entrepreneur for their sponsored by their own company for themselves will only be valid for 18 months, and then it can be extended for another 18 months, during which time they will have to show the government what percentage of time they've been spending on what duty. And once, if the government is satisfied, they will extend that initial H1B for an entrepreneur by another 18 months. And then after that, they can get a full 3 years. So they will be able to get a full 6 years with their own company without relying on any other employer, which is groundbreaking by any stretch, which is monumental and a welcome relief for entrepreneurs.
Wow, that's so good. Okay, so Zishan, I hope you got your answer. And still, if you have any follow up question, then please go ahead and post them on the comment section. And we have another question from Chetali as well. But here's a request, Chetali, please wait for some time. We have another questions also. So let me take from YouTube user also. That's Kunal. So, I own a small tech consulting firm and rely on H1B workers for critical projects. With this new rule prioritizing higher wages, does it mean I'll be forced to pay top tier salaries just to stay competitive? What options do small businesses like mine have?
Kunal, welcome and thank you for that question. I want to clarify one thing. There is no requirement under this new rule that forces employers to pay higher salaries. The employers are required to comply with the LCA requirements. An LCA is a labor condition application, which is a prerequisite for an H1B.
Mhm.
An LCA mandates that an employer pay an H1B employee a prevailing wage. That is mandatory. That does not change. And nothing about that LCA or the prevailing wage is changing under this new rule. So if you were competitive under the previous version of the H1B rule, you will remain competitive under this new rule as well. Nothing's changing from that perspective. The only thing I would urge you to do is to make sure that you're following, um, taking steps to ensure all your immigration compliance pieces are aligned. For LCAs, your public access files are available because there will be more and more Department of Labor audits that I anticipate under the new administration. There could be site visits for smaller employers. If you're placing employees at third-party sites, then what is the difference between whether those employees being placed are the employees being placed on a small project, which is a discrete short-term project, Or is it a long-term assignment where that employee becomes a part of that company's hierarchy and organizational structure, and you are providing additional talent to that company? So the requirements have changed in those two scenarios, but by and large, from a wage perspective, nothing has changed. So I don't think you have anything to worry from a wage perspective, but there are other things that you need to be mindful of.
Absolutely. Thank you so much, Poonam, for your answer. And Kunal, also, I hope you got your answer. But still, if you have any other question or still you're navigating any tricky legal issue or want to have guidance, then you can also contact Attorney Poonam Gupta. And you can email her on info@summit-legal.com. And you can also visit her website, that is www.summit-legal.com. So this is for all our lovely viewers who all are watching us right now. You can also contact Attorney Poonam Gupta, and I'm sure she is going to give you a brilliant advice and definitely going to navigate all your legal issues smoothly. All right, so let's move ahead with Chetali's comment. That is, what about employees working remote? Is there a requirement for the employer and employee to be present at the company site?
Great question, Chaitali. There is, the government has refrained from imposing limitations on remote or in person or any of that. All they've said in this new rule about this requirement is whatever the employer's preference is, the only thing they need to be mindful of is that they're complying with the LCA requirements. If an employee is going to work 100% remote, and there are plenty of companies that are fully remote that don't have any employees on site, then as long as they are mindful of where their employees are and that the employees are only working from the location for which they have an approved LCA, they should be fine. If the employees move to a different location, please note it is now codified. It was always, has been required for a few years since the decision in matter of Simeo, but now it's codified under these new regulations as well in this new H1B rule, is that anytime a new LCA is required, an amended petition needs to be filed. The employee can start working as soon as the petition is filed, but there is no grace period for that amended petition to be filed. If there is a change, the petition must be filed before the change takes effect. It is absolutely critical to note that there is no grace period from any changes, material changes to the H1B. And that includes change in location, outside of the certified LCA. If person moves to a new area, then a new LCA is required and a new H1B petition, an amended petition is required. And for that, as long as the employers are complying with that and mindful that the employees are following those rules and staying put, then there should not be an issue. There's no requirement that USCIS is not micromanaging where an employer and employee need to be. All they're saying is that employers should comply with the DOL and regulations pertaining to LCA.
All right. So, Poonam, we have another questions too from our Facebook people as well. But I would like to ask one more question from you. That how will the new rule is going to impact the companies that place H1B workers at third-party client locations?
So third party, I believe I talked about this when in response to Kunal's question, but third party placement, the one benefit is that there is no requirement to include an itinerary with the petition. But what is required, and the government will inquire, is they can ask for contracts. They've codified that. They said we will ask for contracts, any relevant information that helps us understand what the relationship is. And then the nature of inquiry that they have is twofold. One, what is the nature of that placement? Is that placement a short-term discrete project placement? And the employee, the staffing company, for instance, is are they placing them for a project that is discrete and not adding to the headcount or supplementing the company's headcount? Or is it an additional talent that the staffing company or the company is providing to the end client such that that placement becomes part of that headcount or that organizational structure and a critical piece of that function within that company. In the latter situation, where the employee is placed as part of a bigger team within the end client, then the big change now is under these new rules is that the requirements, the education and degree requirements for the role that is being filled at the end client control. It is not the H1B employers, the that requirements that control. It is the end client's requirements that control. So if the end client requires X number of years and degree in a specific area, then the employee has to be able to meet those requirements, and the government will ask for those specific requirements. So please be prepared to ask for those requirements from your end clients and be very clear that that is something that may be required. So that may be something employers will be asked to share their MSAs and contracts and statements of work and so on. But please be mindful that the government can also come back and ask for requirements, the degree and the position requirements for the position that's being filled at the end client.
Absolutely. They have to be very mindful with this. And thank you so much, Poonam, for taking these questions up and explaining all them in detail. And we also have a few questions that I would like to take. That is of Roshni's. Wait, this one. Yeah. So Roshni is saying that I work in a non-tech field, specifically healthcare. Seems like this rule is designed around tech jobs with high salaries. So do you think that workers in fields like mine will be at disadvantage under the new system?
Roshni, thank you for joining and a great question. So while there is a lot of discussion around IT companies and staffing agencies and so on, there's actually a huge advantage to companies, potentially in the healthcare industry, if they are affiliated with a hospital or a university that is a nonprofit. There is, as I mentioned very briefly in the beginning, there is an expansion of the definition of cap exempt. Currently, hospitals and universities are allowed and do benefit from not being subject to the H1B cap. And with the expansion of this cap exemption, um, my sense is that the healthcare field will benefit even more and not less. So there is actually a bigger advantage to the healthcare industry, in my view.
All right. So thank you so much, Roshni, for your answer and sorry for your comment. And let's take one more that is of LinkedIn user that we got right now. And it's saying that does the end client, in case of third party, need to provide a job description?
Correct. And thank you for joining. Yes, the end client, again, USCIS could ask not only for a job description, but also for the position requirements in terms of education and experience that is required for that role to determine whether or not whether that individual who's being filled in that role qualifies for that role. So yes, job description can definitely be required in addition to the requirements.
Okay. So I think from control, we got to know the user is Jigger G. So, welcome, Jigarji, and thank you so much for your question. And it would be lovely if you could also ask another question that you would like to know, and we will definitely take them up. Meanwhile, I would also like to take Ashwarya's question. And she's saying that if my employer decides to sponsor me for an H1B but can't afford to pay the top wage levels, will I still have a fair chance in the lottery, or is it now all about money?
Ishwarya, thank you for joining, and that's a great question. So, the one thing is very clear and has always been clear that the H1B program is designed to protect not only US workers but also foreign workers. Every employer is required to pay a prevailing wage as they attest to on the labor condition application included with the H1B. An employer cannot bench an H1B employee without paying them. There is no benching time that's permitted under H1B. So if an employer cannot pay the prevailing wage, then there is a problem. But it doesn't have to be top wage levels. The wage level is determined by the job description and the requirements for the role, and as well as the location for the role. So if your role, like some of the situations, and a legal way to get around the wage level issue in some situations is to move away from areas where the wage levels may be higher and move to locations where the same role can be performed for a lower wage. So if the role, for instance, is a remote role, then it is perfectly legal for the company to mandate that the employee work out of a certain area that is not as high in their salary. And if the employees do not conform to being restricted in that area, then the employees are exposing the employers to compliance issues and violation of H1B. So it's in both the employer and employee's interest to manage and make sure that they comply with the LCA requirements. And as I said, it is not about paying the top wage levels, it is about whether or not it complies with the law. And in terms of fair chance in the lottery is not determined by what wage level you're at, where you're located. It is simply now, since 2024, the H1B lottery is beneficiary centric, as in each individual gets a fair chance in the lottery, regardless of how many employers may sponsor them, or regardless of which country or which occupation or what level they're coming in at. H1B lottery is agnostic to all these factors. The only information the lottery requires is the individual's name, the individual's date of birth, and their passport information, purely for identification purposes and to prevent fraud. It has nothing to do with money, it has nothing to do with anything else. The lottery is completely separate. And then, if you're selected in the lottery, then the employer is required to comply with the H1B requirements, including the LCA. I hope that helps you, and good luck.
Well, that wonderfully explained, Poonam. And this was also a very eye-catching comment that I also wanted to take that out. And I have some other questions from Facebook group as well, but we have lots of viewers that has been worried on today's topic. So I think firstly I'll take their questions. So let's take Aman's question. That is, hi, this is Aman. I heard that the new H1B rules have eased restrictions, allowing entrepreneurs to establish their own companies. I'm wondering, can I continue working for my current employer while simultaneously filing for an H1B through a company I create? Is that possible?
Welcome, Aman, and thank you for joining. And a great question. While I did address the piece about employer and entrepreneurs being able to sponsor themselves, this is a nuance. The question that you raised is a nuance that is also addressed in these new rules, and that is an individual, in addition to an individual setting up their own company and being sponsored by their own company, they're also able to file for a concurrent H1B where they can work for multiple H1B employers as long as they have a valid H1B approved for each employer, whether it is one employer or multiple employers. And in the scenario that you list out, you could work for if I'm understanding you correctly, you're planning to work for two employers. One is your current employer, and the second would be your company where you are the owner and your company would be your employer. And yes, that is possible. Concurrent employment is possible. And one of the nuances that may benefit someone else, if not you, Aman, would be that the individual, if they are able to find or they're working at a cap exempt H1B employment, they could work for their own company simultaneously without going through the lottery ever, as long as they continue to work for that cap exempt H1B. I hope that helps and good luck.
All right. So I think, Aman, you had a great question, and we would like you to ask more questions. It would be so great to answer your comments and your questions. And next, we also have another question from Jigger, I guess. And he's asking that my LCA is filed for another state at client side. Client has allowed me initial 2 months to work remote to prepare for relocation. Do I need to change anything in the petition?
So if your LCA is filed for a state another than where you are currently, the client does not have. I'm not sure I fully understand what you say. The client has allowed you 2 months to prepare for relocation. Does that mean that your LCA has your current location as well as the client site, or only the client site? If the LCA only has the client site, then you are not permitted to work from any location other than the client site. If the LCA lists your current location as well as the client site, then that flexibility makes sense where the client is saying you can work where you are for 2 months, and then once in 2 months you need to relocate to where the client site is. So this is the only piece that I would request that you check. If it is both locations, then you're fine. Nothing needs to change. Yes, thank you for confirming that it has both, because that is critical. So if it has both, you're fine. The client has given you the flexibility and the comfort of taking 2 months to relocate, but you need to move to the client side within the 2 months as they have requested.
All right. So I think, Jigar, you got your answer. And still, if you have any questions, then please feel free to comment them. And right now, I think, Poonam, I would also like to take some of the questions, that we got from our last episode. So, Control, I would like to share the screen and also want to know, Poonam, that, from our last episode, we got some questions. So, I would like to take them up as well.
Sure.
So,
Um,
yeah.
and
Mhm.
also, I believe there is a question from Sudhir in the chat that we should address as well that we didn't get to. But happy to answer this J1 while we look up that Sudhir's question. Could you please put up the J1 question from
Okay,
last?
okay. Okay, Poonam, so let's take the Sudhir's question first.
Oh, sure.
I
Whatever.
think I think now we are getting confused, but that's okay. Let's take Sudhir's question first. So, yeah. So here's a question that Sudhir is asking, that I have heard there's more scrutiny on the employer-employee relationship under this rule. I frequently place H1B workers at client sites. So what does this mean for my business, and how can I prove compliance to avoid trouble?
Great. Thanks, Sudhir, for joining, and thank you for that question. As I have been harping on incessantly on this topic today, immigration compliance is critical. you need to have documentation to prove that to prove the employer-employee relationship per se. All you need to do is to show that you control the employee's work and you are managing their work at the client site. In terms of how to avoid scrutiny, as long as you are compliant and have all the paperwork that shows the agreement that you have with the end client, what work the H1B employee will do at the end client, what are the requirements for the end client, and the distinctions that I made between whether it is a discrete project for an end client versus whether it is a headcount increase for the end client. As long as you have clarity on that, if it is the latter, you should get the job description and the requirements for the role and ensure that the employees that you place at before you place the employees at their role, so that you can confirm that those employees will qualify for H1B. Um, as long as you have all your documents, I don't anticipate that you need to do anything extra on top of it. But you do need to maintain your corporate documentation and your contracts fairly carefully and more diligently and much more organized, so that if you're ever questioned about it, you have them handy. And it may be worth discussing this change with your end clients to say, so that they are prepared for providing that information. There are plenty of clients that we've heard where the end clients are hesitant and reluctant, and sometimes outright deny any requests for cooperation for H1B for employees placed on their site, on client side. And it's worth proactively bringing this up with your end clients so that you can avoid any compliance issues or any scrutiny down the road. But if you are compliant and if your end clients are cooperative, then it should not be an issue whatsoever.
All right. So here we have another question from Amit too, and Amit is saying that I run a staffing agency and place H1B workers at different client locations. So does this rule mean I'll have to provide more paperwork or evidence of work relationships? If so, then what kind of documents are we talking about?
Great. Thanks, Amit, for joining, and thank you for that question. You are correct. There is a possibility that you may need to provide more paperwork and more evidence of the relationships. Um, it's up to the government what information they want, but proactively, when you're filing these H1Bs going forward, I would suggest, at least for the petitions that you file after January 17th, to include proof of any end party placement. If you are placing them at a third party, then proactively provide your contract with that third party, the statement of work, the scope of work. And again, if it is a discrete project, then you don't need to provide anything else. But if it is a headcount increase, or where the employee will become part of the organizational structure of the end client, then you should proactively ask for the job description and the job requirements for that role and provide them with the H1B filing to and prove that the employee has the necessary skills and the specialized knowledge to qualify for that H1B. So yes, there are more documents, but they are common sense documents. But agreed, it is more burdensome. There is a higher burden in that sense on the employers, but the goal is to ultimately prevent fraud and abuse, which ultimately benefits everyone. So in short term, yes, it is problematic and more burdensome, but long term, I think it only helps all of us if we proactively provide all the information upfront without the government asking for it.
Absolutely, wonderfully explained, Poonam. And I think our viewers are also loving your insightful conversation that you are sharing with us today. And also, we have RK. So let's take RK's comments as well. So RK is saying that why so must employers concern about site visits With more site visits, it can help with the improving the views that there is a lot of fraud in the H1B program.
Right. So, why should the employers be concerned about site visits? Up until now, the site visits were, it was optional to cooperate with the site visit, if you will, but now it's mandatory. With under this new rule, employers and employees are mandated and required to cooperate with the government. If they do not, then the H1B petition could be revoked or denied, depending on where they are in that state. If the H1B petition is pending and then the site visit happens, then if the employer does not allow the officer, FDNS officer, access to the site to whatever documents they want and confirm whatever information they want, then there is the potential for denial of that H1B. If the site visit is after the H1B is approved, then, and if the company does not cooperate or does not provide all the documents, then there is the potential for revocation and more site visits. So it is in the best interest of the employers to comply with the site visit requests and help um, address any concerns for abuse. And I have to tell you, these site visits are random and common. We've had situations where employers, like the same employer, had 3, 4 site visits in a span of 1 month. And it all worked out. The questions were not crazy, intrusive, or in any way something that were not anticipated. And there were no questions that we did not have easy access to. I would also highly recommend, whenever you get notified of a site visit, or if an officer just shows up at the door, which most of the time they will, then you should call up your attorney. And if the attorney cannot join by phone, or if the attorney wants to join in person at the time of the site visit, to request the officer to reschedule the site visit at a time when your attorney can be present. You, I would not recommend any employer to go through the site visit without their attorney, just because it gives the attorneys able to address those questions and address anything that the officer may be asking that they should not be asking right at that point, and push back if needed. But most of the time, in my experience, it's a fairly straightforward request, and just providing that information helps not only that employer but everyone else.
Absolutely. And I think, Poonam, site visit are being a very hot topic nowadays. People are very much concerned about it. And I think we have another follow up question or follow up comment from RK, that is, with more sites, this will allow the government to publish data to show X amount of companies and compliant. This concern about this provision may wrongfully imply that there is a lot of fraud.
Thanks, RK, for that. I'm not sure exactly what you're trying to say, but what I can discern is that the government occasionally does publish the site visit data, or other data, not necessarily how many site visits they've conducted, but they do provide some data about the workings of the FDNS. And there is a there is some fraud in the H1B program. There are some unscrupulous employers that want to take advantage of the H1B program, that exploit workers and do not pay them as they should, or do not comply with the LCA requirements. And that is the goal of the site visit, to identify such unscrupulous players, such unscrupulous employers, and take them out and shut down their programs so that it doesn't impact the integrity of the broader H1B program and everyone can stay compliant.
Absolutely, and I think that's how, anyone. I mean, I don't think that there should be anything that people should be scared of site visit, because if you have proper documents and if you are fully aware with all the updates, then I think it will be safe and there's nothing to be worried about. And sooner or later, it's very important, friends, to stay updated. So, yeah, that's what I would like to share. And here's another question, that is, does the new rules regarding end client documents also apply for assignments started and petition approved before 17 January as well, or only for new petitions?
Thank you for asking that question. It's a great question. And yes, these new rules go into effect on January 17th and will only apply to any petitions that are filed on or after this date. So if anything is initiated or approved before this date, these new rules will not apply. But to be very clear, these are just codifications, and some of this USCIS is already doing and already requesting proactively. And all the new rules do is codify and request that an employer is mandated to provide these. Up until now, the government would issue a request for evidence asking for this information if they felt that the employer did not provide sufficient information.
All right. Also, Poonam, as we have crossed 1 hour, so I would just like to know it from you. Is it okay if we could extend for 5 more minutes our session?
Sure,
Oh,
we can.
that's
I know there's a lot of questions, and there will be a lot of questions if people become aware of this. And
absolutely.
happy to answer as many questions. So please keep those questions coming. We have posts on LinkedIn and all the other platforms. Please continue commenting. We will continue to address those questions even after this event is over, and if needed, maybe come back another time. But for now, please continue to comment and post your questions.
Absolutely. That's so sweet of you, Poonam. And also to our viewers, as Poonam said, that please go on commenting and posting your questions. And even after the show, even after the event ends, we will definitely take them up in our upcoming shows as well. So here's another, here's a comment that we received. Thanks a lot, team. This is really insightful to be prepared proactively. Thank you so much, Jigger. I hope I'm pronouncing your name correct. If not, then please write your name properly so that I can greet you well with your name. But also, Poonam, I would like to ask another question regarding the topic, that are there any potential challenges or drawbacks, that employers and workers might face under this new H1B rule, despite its pro-immigration and tech-friendly aspects?
Um, the challenges, the biggest challenge may be the compliance piece, and for as you've seen, the questions that have been coming from staffing agencies and companies that face employees that and clients, the biggest concern is the additional documentation. That I think will be the biggest burden under these new rules. Other than that, it's just codification. The benefit will be far more than the drawback. I think the only drawback will be additional documentation.
All right. Okay, so I think we can see very less challenges here, and more pro-immigration and tech-friendly aspects in this new rule, and that's absolutely perfect, and that's lovely to know about it. Also, I would like to now come back to the comments that we received from our last episode, because that is also very important to cover. So, Control, I would like to let us know about the comments that we got to know from our last episode. That is, I am currently on J1 visa and my visa expires in 2025. My spouse, who is a J2, his company is offering him L1 from India to the company here in US. I am not on government funded program as I am directly working for public school. Will he be able to transfer from J2 to L1 with recent changes to the skill list?
I'm assuming this person is from India, Sam. Assuming this person is from India,
Right.
then yes, they will be able to transfer because India was removed from the skills list and there is no 2-year home residency requirement applicable for this individual. To be 100% sure, my recommendation would be that they request an advisory opinion from the Department of State to avoid any surprises, because while the J1 skills list has been updated, the officer's knowledge and comprehension of those rules may take some time to catch up. So, to that end, I would urge everyone that is in a situation where they think they will not be subject to the 2 year home residency requirement to please request an advisory opinion from the Department of State to benefit and to get clarity, have something to show when you go for that counselor appointment or when you apply to USCIS to support your not being subject to the 2 year home residency.
Absolutely. And here we have another comment too. That is, hello, I'm an Indian citizen. I was in J1 visa during the year 2021 as an exchange student. My program was self funded and I was subjected to 212E clause. I'm currently in US in my F1 visa. I didn't complete my 2 year in India. I'm in the process of preparing for applying to get my waiver. Based on the new updates, do I still need to apply for the waiver?
Great. Thanks, Sam, for bringing that up. So, 212E clause, to clarify, is the regulation or the that requires the 2 year home residency requirement. So when this person says, I was subjected to the 212E clause, it means that they were subject to the 2 year home residency requirement. And that's what they say, that they haven't completed it and were applying for a waiver. As an Indian, they are no longer required to apply for a waiver. They say their program was self-funded, so I think it is fairly clear that they do not need to apply for a waiver. They are not subject to that. Again, if they have any doubt and to avoid any confusion on any agency's part, it may be worth requesting an advisory opinion to have a government document that confirms your understanding. So that is the best way to confirm and to avoid any doubt for anyone at any point.
All right. So yeah, I think these two comments were from that we received from our last episode, and I think Poonam, we have covered all the comments, all the viewers' question that we have received regarding our today's episode. So I think yeah, that's lovely, and we also have come across 1 hour, and we didn't even realize, and it's been more than an hour because it's obviously a very new topic. And thanks to you, Poonam, for letting us know, for suggesting this topic. It's really amazing, and it was so insightful. I enjoyed a lot this session, and I hope you too. But meanwhile, also, Poonam, any last tip or any last message that you would like to share with our so many viewers today?
Sure. One of the things that everyone is concerned about, that we didn't get to talk about, is whether this new rule can be um, turned upside down or retracted when the Trump administration comes into office. The new rule goes into effect January 17th. The new administration comes into play on January 20th. What can they do to retract this new rule? So there are a few ways that things can change. One is obviously they can go to court and prevent something from going into effect or any of that. If that happens, obviously we will keep you posted. But barring that, all the other pieces, all the other actions that they could take are not immediate. If they want to modify the rule or change the rule drastically, they have to go through the notice and comment period that this rule went through. So, as I mentioned, this proposed rule was first issued in October of 2023. Comments were open until December of 2023, or November, 60 days. And then after that, the government issued a limited portion of that rule to implement the changes to the H1B lottery. And again, it's taken them almost a year to address all the other comments that were raised with regards to this new rule, and they've issued this rule to go into effect. So any changes to this rule will have to go through the whole notice and comment period again, which will require some time. And even the best case scenario, it is at least a few months, potentially longer, before any changes can be implemented on a regulatory side. The Congress can always enact a new law, which, knowing what we know, I mean, with the government, I don't know, I haven't looked at the news this morning, but as of late last night, the government was going to shut down because the Congress couldn't come to an agreement on the budget. So, how well and how quickly that will pass is anyone's guess. So, to the extent that gives anyone any comfort, this rule is here to stay, at least in the near term. There are plenty of enforcement provisions within this that align with the incoming administration. So I'm hoping that, given the enforcement bent of this new rule will be left alone, and the new incoming administration also has different priorities, and this may not be as high on their priority list to tackle as other things, and mass deportation seem to be the top matter, and this is far from it. So I think we may be okay, but only time will tell.
Absolutely. And with Trump's administration, it's so unpredictable. We can't even predict what's going to happen. But
But we'll deal
let's,
with it.
yeah, absolutely. Let's see and what happens. And I would say, with that, Poonam, we have successfully done with our today's episode. And friends, we talk about the new H1B rule, where we covered everything about like how is it a game changer, what are the key changes, and how is it impacting both the workers and the employers, and also what you need to do to stay ahead. So I think these were some of the very important topics that we talked about. And also, I would like to say, Poonam, that your expertise and your clarity on this topic, made everything so much easier to understand. And I'm sure, that our audience learned a lot from you. They loved your insights, and it's been a really pleasure having you on the show. And we are super excited to have more shows with you.
Likewise. Thank you, Sam, for having me. And it's great to be able to address the questions and, calm some of the people. The immigrants get riled and get upset and anxious very quickly for good reason. And I'm happy to do my part to help whatever I can to help the immigrants in their journey. So good luck to everyone and happy to be here.
Wow. That's lovely and that's amazing. And thanks to our viewers also for joining us and participating in today's episode. I hope you found this session helpful. In case if you have any doubt, then go ahead and post them in the comment section. And also, if anyone is navigating the intricacies of visa applications or facing legal challenges or simply need guidance on immigration policies, then please feel free to contact Attorney Poonam Gupta on the given contact details. You can email her on info@summit-legal.com, and you can also visit her website, that is www.summit-legal.com. So this is the contact detail that has been displayed on the screen. You can go ahead and mail her, or you can also visit her website. All right. So thank you so much to everyone, to our attorney, to our viewers for joining us and making this session a great one. As always, stay informed, friends, by liking, sharing, and subscribing to the Immigration and Jobs Talk Show for more updates. I'm Sam, signing off for now. Bye bye and take care.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this very, very important disclaimer, welcome back, everyone. I am your host, Rajni Bharara, and today we have the privilege of hosting attorney Ruby L. Powers, a distinguished leader in immigration law and the founder of the acclaimed Powers Law Group, PC, based in Houston, Texas. Ruby is a board certified immigration attorney with nearly 20 years of extensive experience in navigating the complexities of immigration matters, including family and employment based cases, asylum, and deportation defense. Well, Ruby's commitment to her clients is unparalleled. She combines her professional expertise with personal insights as a child of an immigrant. Her compassionate approach has earned her recognition as a respected author and speaker, with her insights featured in major publications such as the Washington Post and the New York Times. She has been honored with prestigious awards like the AILA Advocacy Award and has been listed in the best lawyers in America and super lawyers. In today's episode, we will delve into recent immigration updates, what's next for DACA recipients in 2025, and Ruby will share her insights on evolving landscape of immigration policy and what it means for DACA recipients moving forward. So join us for an enlightening discussion that promises to empower and also to inform. And now, without any further ado, let me very quickly give a warm welcome to Ruby because it's her first time on Immigration and Jobs Talk Show. Hi, Ruby. Welcome to Immigration and Jobs Talk Show. How are you?
Good. Thank you so much for having me. I really appreciate it.
Of course, it's a pleasure having you. Um, I mean, it doesn't happen every day that we get a chance to actually do a show with you. So thank you so much for being here, Ruby. And well, and now, guys, I would also like to tell you that Ruby will be sharing a presentation on recent immigration updates, what's next for DACA recipients in 2024. So without any further ado, let's get into that presentation. Let's listen what all Ruby has to say about the future for DACA recipients and what's going to happen in 2025. And Ruby, the stage is yours. Please go ahead.
Thank you, Rashi. I appreciate it. So this is a hot topic, and we also are going to take other questions. I'll just briefly go over this for those who this could be of interest. We don't know the future, but we can take a lot from the past and make some suggestions on what we think might happen. And so I wanted to share this, and you did a great bio intro of me. So thank you. Board certified law firm, 15 years old, Powers Law Group in Houston. I'll go ahead and keep going. So for DACA, the Deferred Action for Childhood Arrivals, it was announced in mid-June 2012. I remember that moment. And it came live only 2 months later in August 2012. And it really gave a hope and for many people who were brought to the U.S. Many of them didn't even know they were not U.S. citizens. I remember having many consults with those, finding out for the first time when this program came out. And it was a way for those to get work authorization, a status, and be able to be in the U.S. for 2 years at a time. And it's been a great program for these last 12 plus years. But the thing is that we've seen a lot of different litigation. In September 2017, under the Trump administration, he was challenging the legality of it, which, the long story short, is it went all the way up to the Supreme Court. And the Supreme Court said the reason why you're trying to get rid of it is not valid. But it didn't it didn't say you couldn't get rid of it. It just said the way you're saying the reason why is not good. And so then it was continuously challenged. And so basically from 2017 to now, it's been in litigation of some sort. And what that really means is that the people who were eligible to apply new DACA have not been able to since around that September 2017. And the thing is that you had to be a certain age to apply. and meet certain requirements. And so many of those people who were just not old enough to apply before September 2017 have not been able to take advantage of the program because it's been in litigation, and it continues to be in. And so in 2023, a federal judge in Texas ruled DACA illegal, and then it went up to the Fifth Circuit, which listened to oral arguments not too long ago. And honestly, it hasn't given a decision. The Biden administration, which really only has about 1 month left, does support DACA, but they haven't been able to get a DREAM Act, which would make it more solidified. See, DACA is part of executive action from the presidential power, from executive order. And so that is the thing, is that we really haven't had immigration new laws in such a long time. And so that's really where basically what happens is that sometimes the presidents are making opportunities based off of their executive power, and then it later gets challenged in other administrations. But ultimately, we've been waiting for Congress to actually act and make laws that apply to immigration, but we haven't seen that in many years. And so as we've seen it, if the Fifth Circuit were to rule against DACA, we know it definitely would go up to the Supreme Court. But we have seen the circuit be more favorable to, anti-DACA and more favorable to Trump mentality. And we've also seen the Supreme Court rule not in favor of DACA necessarily. And so we think that what could possibly happen is that Fifth Circuit will probably say it's illegal, move it up to the Supreme Court. Supreme Court will either take it to be heard or not. But ultimately, the fact that right now all you can do is renew and advance parole is what you can do. You cannot apply new DACA. And if you look at the numbers, you can see that a lot of people are not in. The numbers have dwindled since originally. It's because a lot of people have been able to move on to something else like legal permanent residency. And so we're a little confused as to what's going to happen, because there was a lot of talk, maybe even just a few weeks ago, with Trump, President-elect Trump, saying that he was not so favorable about DACA, let's say, especially in the campaign trail. But then just recently, it sounds as if he's more favorable. So that's really where the confusion lies, is that we don't know what to expect. So the DACA recipients are primarily from California, Texas, are living primarily in California, Texas, and New York. And there's about 500,000 right now. The oldest DACA recipients is about 43 and a half years old. Many of them are married with children in school. Some could even be a grandparent by now. And they've been educated in the U.S. by virtue of being eligible for it. And so we see a lot of, unfortunately, it's like they're having to, build their lives on their home on the sand, because they don't know what's going to happen. And many of them are have American spouses, American children, and have been living in limbo. So this is that contradictory approach. We're honestly confused. We don't know what to listen to, because we've also seen this quote from Donald Trump: "We have to do something about the dreamers. The people were brought here at a very young age." I've also heard about when I did a lot of advocacy in DC. I once heard in an office, they said that if we were to give a pathway to citizenship for DACA recipients, then it's a way. One sort of approach is that it's a way of rewarding the parents for bringing in children illegally, and because one day those children who could get a pathway to citizenship could petition for their parents. And so I think that's been one argument from the Republican side as to why they weren't pro DREAM Act. But I haven't heard that out in the world very much in the news, but that did give me a way to think about different perspectives. So it's confusing because what do you listen to? Is he pro DACA? Is he against it? What's going to happen? I mean, I think very likely it'll go to Supreme Court. Whether Supreme Court will take the arguments, I mean, listen to it and cert. I don't know, and I think that's where a lot of uncertainty is. But one thing that could happen, because they have the White House and narrow numbers, but in the House and the Senate, is they could try to put a DREAM Act through. And I don't know why they wouldn't if they finally could move it forward. So we'll see. I wish I had more certainty, but I think that's one of the things we're going to see a lot in this on this times is that we don't know. What was said on the trail is the campaign trail is going to be done. What's not going to be done. I think one thing just to be in a precautionary mode is to go ahead and renew DACA maybe early. You're supposed to do like 150 days. Some people are applying even earlier just to make sure that they get it because they don't know what will happen. Getting your documents in order, having a consultation, evaluating what your options are. And so that's really what we're seeing a lot of people wanting to renew early. And we're also seeing a lot of people wanting to do the advanced parole because one aspect is being able to apply brand new, and that you cannot do that right now. You cannot apply brand new DACA. And if you don't apply on time, if you have more than a year lapse between your DACA expiring and it's considered a new DACA if it's been more than a year, and you wouldn't be eligible for it because there's no new DACA. It's just renewals. And so that's the reason why it's so important to be timely filing. And the advanced parole is an option that gives people a legal entry, if you will. And the biggest thing to note is that you would have to have enough time on your DACA. You would have to have a valid passport that has enough time on that. And then you would have to have either humanitarian, educational, or employment reason. And then by doing that, you would have to have the proper information, evidence to establish that. Now, one of the things to note is that it's been taking about 3 months to get the advanced parole. And we only have a month left of this administration. So when the election results came out, some attorneys were saying, like, should we even offer this? Should we not? I think that as long as people understand the risk and consequences, then people should feel free to apply. But we don't know what will happen. We don't know if January 20th, he says no advanced parole or something. But then again, the other thing I will say is it's important to note, where is the source of power? Is executive action, order? Is there a rule? Is it a law? Is it a policy interpretation? And honestly, this is huge, especially under the Trump administration, because then it gives you clarity as to how long and how it could be changed. Could it be changed with just the stroke of a pen by the president, or would it require a lot more action by multiple people or Congress? And so these are all the things to consider. And I think that's just a good takeaway in general as we analyze the future of so many things, including H1B, other visas, interpretations. So much of immigration is not necessarily because of a law necessarily. It's about interpretations and policies and different executive actions and orders. So this was just an example of the documents that would be needed. We're still filing for folks, but we are letting them know that we might not get approved in time. And under the new administration, we don't know what will happen. The advanced parole, so if a person hasn't already gone advanced parole, traveled and come back, then you're really on borrowed time right now because we don't know what to expect. But if a person entered illegally, let's say one time, and then later got DACA, if they did have the advanced parole entry, then and they're married to a U.S. citizen, then all things being equal, no other complications, we should be able to adjust. Them inside the United States, and so that's why that legal entry is so critical. And hopefully, people have already gotten it. It also can be helpful for traveling if we're going to do like a perm process and trying to do consular processing with DACA, which gets more complicated. I think one thing to note is that finding alternatives. So like there used to be almost 1 million or so DACA recipients, and now we're down to 500,000. And I don't think that many it's because they had a DWI and they got disqualified. I think it's more because they were married to U.S. citizens. They were able to do the provisional waiver or the advanced parole, DACA, belly, what we call, and were able to find a way to a pathway to legal permanent residency. The other thing would be is if they were the recipient or a beneficiary or a derivative of an I-130 or labor certification from April 30th, 2001. This is under the 245I provision. It's old. It would probably be because if their parent was a beneficiary and they were underneath it, potentially they didn't even have to be alive at the time. That could act as a legal entry. That gets more complicated, so I'd rather explain that in a consultation. Provisional waiver is still an option. The provisional waiver right now, but they were taking online. They're saying they're 4.5 years. The most recent waivers we got approved for 2.5 years. Just recently, we've seen a lot of approvals. Asylum could be an option as well, but the biggest issue is if you don't apply within 1 year of entry, you need to have an exception, changed circumstances, exceptional circumstances, and being in DACA up until it goes away potentially, and then applying could be considered exceptional circumstances, but that would be something I'd say look at the moment. The other potential thing would be like military parole in place. If your spouse or child is in the military or was in the military or a ready reserve or a vet, that could be an option. We also, during the Trump 1.0, I'm just going to call it that, the first administration, there was a lot of concern that the military parole in place would go away, but it never did. But I think I'm still going to bring that up because we don't know. There's also the U visa, which is a victim of a crime, but it has to be a specific a qualifying crime, and you have to get the certification. One of the things, a couple of things to note is that under Trump 1 is that he had said that judges could still deport someone even if the U visa is pending, which really gives pause because under Biden, they said, no, you can't be deported while it's pending. There's discretion, but that's not going to be their policy. The other thing is that, what do you mean pending? Well, it's because there's only 10,000 visas a year. And there's a lot of demand since this program came out around 2008. And so it's taking about 10 or 15 years to get a U visa right now. And those are the estimates with the application rate plus the visa availability. T visas are not met as much, so it's a bit faster. Like within a year or two, you can get them, more like a year and a half. But what those are sort of more of a unique thing. I think a lot of attorneys are screening better for those. You could be a victim of trafficking through labor or sexual. Doesn't have to be just one, but the labor could be like withholding payment, coercion, holding documents, and things like that. Cancellation of removal is when you've been here 10 years or more, good moral character, and extreme unusual hardship to U.S. citizen, spouse, parent, or child. That means it's more defensive. You have to be in court for you to proceed in that way. There's also special immigrant juvenile status, and that one is really more for younger folks and things like that. So it's a two-part aspect of family law, order, and then USCIS. I think just in general, what I'm telling a lot of people is that be prepared. We don't know step one, good, you're listening to this, good, you're looking into it. It's know your rights, know your information, know what your options are. Having a consultation with an experienced immigration attorney, I think, is so critical because I think a lot of times people just go with whatever they hear in the news, and sometimes that can be very sensational. And it's not specific to their situation. One of the best things that came out of DACA back, 12 years ago was that it got people going and having consultations. And I kid you not, some people were already eligible for things, but they didn't know because they didn't go to an attorney to evaluate, or they were given bad advice. And so that's why I would say is check the reviews, make sure that it's a reputable person, attorney. Make sure that they've had cases similar to yours, that they've had experience, and and if anything, go get a second opinion as well. It doesn't mean you don't trust them. It's this is your life and this is important, and you want to make sure that you have the right information that you're making that decision. And then write down what is being said, so that way, if some key facts were to change later, or laws or interpretations, it could mean that you might be eligible for something later that you didn't know about. So it's important for everyone to know what their rights are. And I mean, for those who are in the U.S. and don't have a status, it's important to have children or spouses, having guardianship arrangements, having wills, having documents in order. I think having the taxes and civil documents scanned in one place, so that someone could quickly email that to an attorney if they're hired, if the person's detained or held. Having the key numbers ready so that someone else can jump in action, such as maybe calling a lawyer that's been like pre-screened, and that maybe they're not hired, but at least the lawyer knows about the case and has document. For example, all my consultations, we keep notes and we have an intake. And so if someone were to call later, which, the firm's 15 years old, we can quickly pull that information, start from there. And that helps us to be able to move forward, especially if there was something we had to act quickly. And what I mean quickly is that if a person is detained, if, for example, they have a prior deportation order, like even just in the news, there was a woman with a deportation order and 2 U.S.-born twin children. They're only a few months old, and she was deported. And so, there could be options with stay of deportation, having ways to do prosecutorial discretion, but that's what we know now. But in the future, a lot of those things are going to change and be a little bit harsher from what we're hearing in the news and from Trump's campaign policies and promises. So we'll see what happens. And I think having a few trusted sources that you can always go to and stay up to date. For example, we team up with a lot of the consulates and nonprofits, so that we're finding out about things maybe before some things are out there in the news, and that can help us give that information to our clients. But also, we put out a lot of content in on our Facebook, our X. We're also on Blue Sky as well, Instagram and TikTok. We regularly have a lot of content, and we also have a newsletter in English and Spanish that is out there, and we just summarize the key points from those 2 weeks at a time, so that way it's sort of a digest, if you will, of what the key things to know are. So as there's information about how to reach us, our rubypowerslaw.com and our number. But for the most part, that's more about what's going on in the DACA. And it looks like we got a lot of questions too. So, and we can talk about non-DACA things as well. But if anyone has any questions, I'll do the best I can.
Thank you so much for that amazing presentation, Ruby. It really helped a lot to understand each and everything about DACA. So guys, if you have any questions from Ruby that you would like to know, that you would like to get an answer of, so please make sure to comment down, make sure to post your comments in the comment section, and we'll be taking your question. Also, you can give us a call on the number 425-436-6335. And you can put the access code, which is 988888. Yes, make sure to dial this number and put this access code, and we'll put you through. Thank you so much. And Ruby, I would like to come back to you, and I would like to ask you a really controversial question related to DACA, because
Okay.
some people who don't side with DACA and who don't favor DACA call it a way to support illegal immigration, right? So, but what do you have to say, and what do you think? Does DACA encourage more illegal immigration, or does it provide like a humane solution for integrated young people?
That's a good question. So I see both sides, having even mentioned that what I had heard when I was at a Republican senator's office about why there's some pushback to having a pathway, because what they were saying is if we were to give green cards and citizenship to DACA or Dreamers, that there's no restriction on petitioning for their parents. Like with the special immigrant juvenile, you sever parental the relationship, so therefore you can't petition for the one that is the one you sever from. But with this scenario, you couldn't put a pause. I think the way I look at it, I mean, there's a way I look at it, there's way different, there's a whole spectrum, right? Is
Right.
that the children were brought here with no control over anything. In fact, like I said, some of them thought they were US citizens because their parents didn't tell them otherwise. And then to wake up one day and find out that they don't have a status, like this was, just a wonderful gift that helped quasi remedy the dilemma. Because when I say quasi, because it's still in limbo and it's been pending 12 years. And unfortunately, the people who were too young to take advantage of it by the time Trump, paused it in September 2017 haven't been able to take advantage of it. And they are still very much dreamers outside in the world. I think it's a humanitarian quasi solution for something that we should have given more of a permanent solution. I think when you do things like this to fix problems, it can appear from like one perspective that you're encouraging illegal entry or unlawful presence in the US. But the reality is that they were so stringent on the requirements. Like you had to be here by this date. It was like 5 years before the eligibility, and you had to be this age and you had to go to this school or do this program, In fact, a lot of people, when I still talk to people, I'm like, why don't you have DACA? And they're like, oh, I didn't do this school, or oh, I didn't have enough evidence, or oh, I came 2 weeks or 3 weeks too late or something. And there's still a lot, what we still call dreamers, the people in theory, the large group, and then the DACA recipients are more of a smaller section. Anyway, I'm more of the pro-immigrant side, and that I really think the U.S. should have done something, should still do something more. But
I mean, as
I'm
you
glad
should,
that
and I think as everyone should, because America is the nation, US is the nation built by immigrants, right? So
right.
people should be pro-immigrants. But then, how do we? Is there a way to, Ruby, also balance national security concerns with humanitarian considerations for undocumented youth?
Yeah, there is, but let's just go on DACA, for example. If you get a DWI, one DWI, you're out of it. You're out. You're out of the running. I mean, TPS is easier than DACA. DACA, you had to have, if you had more than a few misdemeanors, you get kicked out of TPS, but they didn't specify DWI. I mean, one DWI. I mean, I'm not saying that you should have that, but that's an example of something that could put people in danger. You get one, you're dead, you're gone, on the DACA, for example. So it is really stringent. And the fact that a lot of them have been in the US for so long, I mean, the DACA recipients that I know, they're stellar, community members. Yeah, there's always the concern about, security. I used to work for the Committee on Homeland Security many years ago in DC. That's always a concern. But I think that the dreamers are really a subsection of those who are, quasi-American citizens in a way, because they've been here so long, and in the culture. And I think that's what makes it so much easier for them, to marry U.S. citizens. And it's almost like they're already citizens, but they just don't have the document to prove it. And I'm not saying DACA recipients are U.S. citizens, but because we don't want to say a false claim. But I'm just saying culturally and educated and things. But yeah, there's always the concerns. But I think that they're not the ones that are the most prone to the issues that we would be concerned about.
Right. I mean, also they don't know any other way, right? Because they have been there since the time they have been on this planet. So, well, there are still so many controversies and so many things surrounding DACA, but hopefully it's going to be better for the DACA, recipients. But also with that, and for the dreamers, of course. But Ruby, I would also like to know from you that people are really waiting until the court gives its decision, right? And it's going to happen in 2025. And now that the new administration has taken power or has come into power, not many people are I mean, people are a lot more stressed about what's actually going to happen now, right? Because though they say that they are favoring that, but nobody actually knows what might happen. So I would also like to know from you that what role does the public opinion play in shaping the chances of, things coming in favor or things going against it?
I think it's huge, and I think that's where we need to consolidate our power in that. I'll give you an example: family separation, the zero tolerance policy of like the summer of 2018, when it was happening even a couple of months before, but it really wasn't. People weren't piecing it together. People didn't know what was going on, and it wasn't until about mid-June when the reports were starting to get to the reporters, and they were piecing together what was happening. I went down to the border Port Isabel detention facility, and there weren't a lot of attorneys that were there initially because they didn't know the pro bono attorneys. It took a little while to get there, but they were there soon after. I did like 5 or 6 interviews. I don't know, it was a ton of media, and that day, after meeting with all those parents who had been separated and had no idea where their kids were, completely traumatized. And within like a day or two, Trump reversed the zero tolerance policy, and ACLU had the lawsuits that forced the government to put the kids and the parents back together again. And they had a deadline to get them all together within a couple of weeks. But for the public outcry, that wouldn't have happened. And that's really what taught me the importance of maybe you don't have the House, and maybe you don't have the Senate, maybe you don't have the White House, but you do have public opinion. And that's where we need to rally together if something is completely egregious. And I mean, we've even just seen recently, I think the last day or two, like tech companies are trying to rally Elon Musk and Trump to have more help in the H1B or the skilled worker visas, because they know that there's such a shortage and they need help to fill those needs. So they're using media, they're using their connections to try to get that attention. So, those are just a couple of examples. And I think we need to band together. And that's really, as an immigrant advocate, having to use media is to get out there, the stories out there is so critical.
Right. And it's only because of the public opinion and public views why the new administration came in power, right? I mean, very well put. Thank you so much, Ruby, for your answer. And now also because, nobody's really sure that what might happen in the next year, what decision might come. So if it is negative, do you think that the DACA recipients should consider like alternate visa options or pathways to permanent residency?
Yeah, so that's the reason why I put that in and I see a couple of really good questions. I think we're sort of on topic right with what we're seeing right now. That's the reason why I put the alternatives there, is because, like I mentioned, there used to be about 1 million, now there's about 500,000, but a lot of them it's because they got the advanced parole, they were married to U.S. citizens, or they got the provisional waiver and they're going that route, something along those lines. So I think the best scenario, or some of them have perm cases pending, and are trying to do the D3 waiver. And so what I would just say is that, yes, try to have a backup plan, be working towards that if possible for legal permanent residency. One of the questions was, how quickly could, when the new administration takes office, which is January 20th, how quickly could DACA protections be reversed or strengthened?
Yeah.
Should we expect immediate changes? Well, again, Fifth Circuit still hasn't made a decision. Then we've got the Supreme Court may or may not take up the question at all. They might just not even take it up. Supreme Court also sort of has their own schedule. So usually their decisions come out in mid-June, depending on what happens with the timing there, but what we have heard is that Trump is planning to have hundreds, I don't know how many, like a lot of executive actions and orders on day one. So I think that goes back to what I said, where does the power lie of the thing that we care about? Is it in a rule? Is it executive action? Is it order? I mean, we really can look to the prior Supreme Court decision as well and what was done since then. There's also talk about would there be, if they were to get rid of DACA at some point, and again, we're still waiting for the circuit, potentially Supreme Court, right? So you can't just completely get rid of it. They still have to go through the process. But what would there in the future, let's say it does go away, would there be like everything goes away this day, like the day your card expires, or would it be like a generous, phase out period of, I don't know, a year or something like that? All of those questions have been sort of circulated amongst the, immigration attorney community, and we're not sure what the answer is going to be. So, but I think it helps at least to think about those possibilities. But bottom line, if you have DACA, be thinking about what your backup plan could be if you could move to something else. And we also don't know what new things will come up. But what I will say is that Trump 1.0 got rid of about 50% of the legal options for immigrants. And so what I think what will happen is that a lot of the paroles that came out, a lot of the discretion that came out under Biden, I think a lot of that's going to go away. And I wouldn't be surprised if advanced parole were to go away for DACA as well. So there's another question, like, I want to travel to see my family, but I'm scared it could affect my DACA.
Yeah.
I think that you should, if you want to apply for it, if you have your enough DACA time, enough passport time, enough, and get that advanced parole out, see what happens. I know it's like, I'm telling you, see what happens, but I mean, the thing is you don't know until you try. And I know it does take resources, filing fees and money and things like that. But who knows, maybe you could get it really quickly. Maybe there's no harm to it in the future. There was, I think Cornell University sent out, this was like about a month or so ago, a note to all their students, and they said, if you're going to travel, come back by January 20th.
Yeah.
And so I think when we heard that, we're like, oh, okay, we should tell everybody the same thing. I mean, honestly, remember when Trump went into office, there was the Muslim ban like that first week. And I remember trying to calls from friends and clients saying, my husband's mid-flight. What do I do? So that's why we're saying try to get your travel done by January 20th, because then we'll all sort of like hold down and figure out what's going to happen after that. I don't know. There's what we know and what we don't know. I can just tell you from experience and having gone through Trump 1.0, and then you have to make a decision for yourself.
Right. I mean, everybody's really stressed out and people are really worried what might happen, because the 1.0, everybody saw what all happened in the 1.0, and now they are really scared because he and his administration has gone out there and said each and everything what they are going to do. So now people are really worried. So, but we'll have to see what might actually happen, what might actually take place, and but I don't think so. But Ruby, before I take our other viewers' question, I would also like to know from you that people are really into this chaos mode and have gone very chaotic. So to help them, understand things, what would you like to tell them, that how should they ease it? And I mean, and be like not go into that chaotic mode and like be a little calm down.
Well, I think the best thing would be to, because see, fear is a paralysis. And that's what I really became so evident when I was at the detention facilities during the family separation era. And that was what it was done intentionally. It was done to cause chaos and fear to the parents as a weapon of emotional and distress. And unfortunately, that's a lot of Trump's modus operandi. He says a lot of different things, and then you don't know which one is he going to do and which ones he's not going to do. So I think there's a little solace in the fact that we've gone through one administration, so we have a little bit of an idea of his playbook. But I think he's had 4 years to get more organized, and he has got Stephen Miller in a higher position. And I think we're going to see a little bit more laser focus on whatever their intentions are. So I guess what I would say is know that they're not going to do everything. Some of it is hot air and a fear tactic. Having a consultation, second opinion, having your documents in order, trying to find good self-care coping mechanisms where you don't let this consume you.
Yeah.
And know that in theory, this should only be about a 4-year situation. Again, the judges he puts in place, the policies he put in place can last longer than 4 years. But when there's still a room for litigation. And in some cases, that litigation can stall for years as well on different fronts. So I think that's another thing to give you a little bit more pause and to know. It's just that the uncertainty. I mean, I've had a lot of clients tell me, I can't eat, I can't sleep, I'm losing weight, I'm doing this, I'm doing that. And I'm like, I'm trying to just give them as much positive. Let's look at whatever positives, and that, listing off what you're grateful for, the gratitude, I think exercise, I think that's really a lot of what we have to do in this next administration. Yeah.
Thank you for that positive answer, Ruby. And let me quickly take Girish's question. Okay, Rahul is here. He says, thank you, Ruby, for your answer. And then Girish wants to know that any changes expected to U visa under Trump administration, any chance of removal of bona fide determination review process? What do you have to say?
I think, I don't know if I should say this out loud, but I think, okay, if you were just to think, how can you make lives worse for immigrants? And that would be one. It would be get rid of the bona fide determination. I don't know. Will he do it? Will he not? I mean, that was a great program that came out a few years ago, letting people have that work authorization while they're waiting that 10 or 15 years. I hope he doesn't get rid of it. I don't know what he's going to do. But if he were to say, how I want to make things worse for immigrants who are especially U visa applicants, that would be something that would probably be under his playbook. The other one I mentioned before is, saying that just because you have a U pending doesn't keep you safe from deportation. I think that is an easy thing he can tell judges, and then they would have to not use it as as a form of relief that could keep them here. So I don't know. I hope he doesn't get rid of that, but it's probably fair game as a possibility.
Okay. Well, Girish, I hope you have got your answer. Thank you for your question. If you have a follow-up, please continue posting the question. Meanwhile, let me take this other question. This is not related to DACA, but still I would like to take this. This is actually about H1B. So ZQ says, is there a possibility that the H1B visa program will be scrapped? I think I saw something about it here in another show.
Well, I don't think so, but I think he might make it more stringent. So let's go back a little bit. One thing that Trump did for H1B, I mean, he did a lot of stuff with H1B and employment based, but one thing he did was he created that registration process where the company just puts like a little form, it's not that difficult, and says, hey, I want to put my hat in the ring for this applicant. And so then, then it was like a lottery, right? Chosen. And then only if you were chosen, then you would put the whole packet together. In reality, that made it a lot more cost effective for the companies, I guess applicants, and it was a lot less work for attorneys, because before we had to submit it for every single person, and then they would take the lottery from all the packets. So actually that was one thing that was more efficient. And then there was a lot more streamlining over the last couple of years as well. I don't think he'll get rid of the whole program. I think, and actually just like 2 days ago, there was DHS was strengthening the H1B program. That's announced a final rule that'll go into effect January 17th, conveniently, 3 days before the new administration goes into effect. I don't think he'll get rid of the entire program. I think he'll get a lot of pushback from business. But I think he could make changes that make it a little bit more difficult to try to, I don't know, in his mind, protect certain U.S. workers. But I think there's a way to have a win-win where you're protecting U.S. workers, you're protecting the U.S. economy by allowing us to bring in skilled labor, and you're still allowing the H1B program to flourish. So that's my answer.
Well, ZQ, I hope, I think that's a great answer. And ZQ, I hope you have got your answer. In case you have a follow-up, please continue posting it. Meanwhile, let me take the question from Vikas. We already have taken Anusha. So Anusha says the Biden administration announced new rules in 2024 that affect DACA recipients. Eligible DACA recipients can get healthcare insurance through the Affordable Care Act starting November 2024. A new policy on D3 waivers will help DACA recipients who have earned a degree in the US and have a job offer in the field of study to get work visas faster. What, according to you, will change in these rules?
So the have a job offer. I don't know. Some of these rules. I mean, there's a lot of new things. I think right now Biden is trying to get some things out like right now because we're like a month away. But what I've also seen is that a new administration can come in and find ways to try to reverse some of that activity. So I think it goes back to where's the source of power or where's this and how quickly could something be reversed. And so I think that's more of that's probably my answer. So we're just going to have to do a little bit of a wait and see right now. But one thing I will say is that when you do get a new administration, a lot of times it takes some things can be almost immediate. And then for the most part, it took almost 3 to 9 months to change a lot, for Biden to change a lot of the Trump policies. It's almost like, turning around a cruise ship or something. Like you've got a lot of, bureaucracy, you've got a lot of operations, you've got a lot of training, and you've got to like move things, around if you are going to do that, like about face. And so, and it's also about prioritization. What is really his priority? You hear a lot of talk about mass deportation. That seems to be a thing that was in the news a lot. I think now that we're getting closer to H1B season, we're getting some of these rules from the Biden administration, where I think, and also the tech market is trying to advocate for more H1B, skilled labor visas. I think that we're starting to hear that, but we don't really know what to believe that he's going to prioritize and what he isn't going to.
Yeah, only time will tell. But still, thank you so much for your question, Anusha. I hope you've got the answer. If you have follow-ups, continue posting them. Even after the show is over, we'll still try to give you an answer. We'll share the questions with Ruby, and we'll try to get an answer from her so that we can, reply to the comment. And now RK is also here. RK says, could we see more regulation to restrict immigration, such as removing H4EAD, removing DACA, wage-based H1B, remove the CBP1 app, etc.?
Yeah, I think a lot of that's fair game. I don't want to cause, fear, but like, the H4EAD was a huge win, right? It's huge. But it took forever to get that. And I think that would be a way, if you were in the playbook of how can I make immigrants' lives worse, that would be one. Getting rid of DACA, that would be another. So a lot of, it's like a death by 1,000 cuts. Like, how can I find a whole bunch of ways to mess it up? I think that's fair game. I think there's like a list. I'm sure they have. Steve Miller, somebody has a list. And they're like, okay, which ones can we do day one? Which ones are going to take a little more effort? Which ones should we focus on? So I believe that as we get closer to January 20th, we've got to sort of filter through the media and the news of what Holman and Steve Miller or Trump are saying, as to sort of try to get in the mind of what they're going to do. But That's sort of the way I'm approaching it. And then in the way, like if you anticipate, it's just like trying to mitigate risk. If you say, like for example, there's hurricanes in Houston. What do? What's your hurricane plan? What's your flooding plan? Or there's a freeze. If you think about how are you going to mitigate the risk or minimize the amount of damage, then that's the best way to look at it. It's almost like we're in defensive mode, right? Like I think under Biden, we were really, proactive, offensive mode. We could do stuff. There was more options. And now we're going to get back to defensive mode. And we need to be ready to think through what would we do if that were to happen. And then if you think through what the worst case scenario, then it gives you that power because you've had time to think through and you can start visualizing how you can try to find a backup plan for that.
Right. But Ruby, I mean, is there a possibility or are there any steps that Biden administration can take to mitigate the impact of an unfavorable favorable ruling?
On which thing? On the DACA or which thing?
Yeah, the DACA. Yeah.
Well, like we mentioned, Trump's been very inconsistent, and just recently he sounds like he's a little more pro DACA this last week or two. Like I mean, I've literally been shocked. Even I've talked to people, non-attorneys about it, non-immigrants about it, and they were shocked too. I think in the wild scenarios that could happen, what if they were to actually pass the DREAM Act? It might not look like the DREAM Acts that the Democrats were proposing. But I mean, if they have the House, the Senate, and the White House, I mean, what's to keep them from doing that? I mean, it might be more restrictive, might be more limited. But I think you got on one hand, Fifth Circuit says no, Supreme Court says either no or doesn't listen to it, and Trump says let's get rid of this. Depending on the arguments, though, is there any more room for litigation? I think that's the other question: would there still be room for litigation? That could tell you whether or not there's room for more delay or not. The other scenario could be, maybe it's wishful thinking, but let's go there, is they pass a DREAM Act, and then woohoo. But it could be more limited so that it doesn't encompass all the DACA people. And that's one thing that we have to remember, because under the Democratic DREAM Act, it encompassed more than just the DACA recipients. And that was what was nice, because it was a bigger pool, because there's so many dreamers who haven't been able to take advantage of DACA.
Right. This takes me to this question from the viewer, Nidhi Sinha. She says, I have been a DACA recipient for years now, and I keep hearing about challenges and potential reforms. Should I be worried about losing my status in 2024? Or is there any hope for permanent protections this year?
Well, I think it's related to a lot of what we've mentioned already. Find a backup plan. We don't know what's going to happen to the Circuit Supreme Court. And there could be a hard stop, or there could be a phase out period. Could be stalled with litigation. And, like we said, Trump seems to be more pro DACA right now, but we don't know if that's going to be the long haul. So, and I think one thing to ZQ's question up here about is new government going to be very unpredictable. I think we got to know that there's checks and balances, right? There's the House, the Senate, the White House. There's a lot of lifelong bureaucrats who've been doing a lot of work, government workers in this space, and there's and the Supreme Court, and public opinion and voters, and just because a president's in for 4 years at a time, there's the House, which is in 2 years, and so that's where people really voice their opinion as well. And so I think the government is stable. It's just the unpredictable part, I think, is really on on Trump's policies, is more of some of the quasi unpredictability. But we do have a little bit more of a good playbook because of how we've seen him be the president before. So.
Right. I mean, well, talking about Trump, he has always been unpredictable. And so we can't, ZQ, to answer your question, I mean, Ruby has already answered it, but thank you so much for your question. Let me quickly take Nidhi's question because we don't have much time. Nidhi says, moreover, what can DACA recipients do if they believe they have suffered discrimination in the workplace due to their immigration status? What do you have to say?
Well, I think this is a employment law matter that's not in my purview. I would say have a consultation with an employment lawyer and explain and go from there and see what happened. There was a deferred action for labor violations under Biden that came out a couple years ago, but I think you're better off exploring the employment lawyer first and then seeing if that other option is still going to be available. But that one is to help give people a status if they don't have one while they're waiting for possible investigation and litigation. So, yeah, so I guess what we have maybe one or two questions, or we're almost at the top of the hour. I don't know if we
right.
missed something.
But yeah, I would also like to know from you, Ruby, that are there any, because, I'm sure a lot of people, and especially the DACA recipients, they want to know what legal resources are available for them. So if you can please mention, are there any specific legal resources or organization that DACA recipients should connect with for support?
Well, I think, let's see, there's I'd say, you can always look to the American Immigration Lawyers Association, AILA, for information, reliable resources. They also have a directory for attorneys. There's a lot of different groups that support dreamers. I don't have like one specifically. Sometimes some of them are more regional as well. I would say that it is good to frequent the ACLU website and for like know your rights and seeing what they're up to in terms of like litigation, the American Civil Liberties Union. And then one thing I think is going to happen under Trump 2.0 is that the advocacy groups are going to do more of a divide and conquer approach for litigation, like federal litigation. So that we're not spread thin all over, but we're more of like a targeted. So different groups are going to take different litigation and to be able to divide and conquer. So AILA is a great resource, ACLU is a great resource, and then having having a good consultation with an experienced immigration attorney and a second opinion, I think are all really good advice.
Okay, thank you so much for answering that question. Ruby, one last question before I let you go. So, because I know we have already talked about it, but any last suggestion or advice for the DACA recipients? What strategies should they consider to protect their legal status, given the ongoing litigation?
For all statuses, I think, or for DACA,
particularly for DACA.
Renew early if you can, probably. That would be smart. I've already gotten your advanced parole, hopefully, if you didn't enter legally, and have a consultation to evaluate what your backup plans could be, whether it's through if you're if you're married to a U.S. citizen, if you have a 21-year-old American child, if maybe your company wants to sponsor you. Could you maybe switch to some other visa? It's really important to know how much unlawful presence you've had and your entries and exits. So it's all connected. I would just say consultation, find a backup plan, evaluate, know what your rights are, and continue to monitor the news. But I think of all the communities, DACA recipients and dreamers really do have a place in a lot of Americans' hearts, and I think that they will. I'm hoping that it will continue to prevail in some respect, and that if not, maybe in this administration, in the future. But I mean, it does give me hope that probably 500,000 of the DACA recipients found another way. I think many of them did to a pathway, and so I think by having had this status, being able to have the advanced parole, more time here in the U.S., I think it's allowed them to have more options. And so I think that's just that having backup plans, knowing your rights, and continuing to stay abreast of the news and reliable sources, and making sure that you're not getting into that, that sensationalism that sometimes can happen. So making sure you're level-headed, trustworthy resources. And I mean, I'll just say, like, we do have TikTok, Facebook, Instagram. Like, we're putting out a lot of content out there all the time of just I don't know if I could show that screen real fast, but like we want to be a resource for the community, even if you don't become a client, because we know that the information is power.
Right. Thank you so much again, Ruby, for all that information. It was so great having you. And guys, if you want to get in touch with, I think Ruby wants to share her screen, and also show you the platforms they share the content in. So Facebook, Twitter, and then Instagram, TikTok. So make sure that you follow all these platforms, Blue Sky. So make sure that you follow all these platforms, and yes, get yourself updated with everything that is going on in the immigration world. And with that, you can also, of course, subscribe to Immigration and Jobs Talk Show, because we come up with these shows and we make sure that you are updated with everything that goes around in the world in the immigration field. So thank you so much, Ruby, for being here. And guys, if you want to get in touch with Ruby Powers, you can dial the number 713-589-2085. I repeat the number 713-589-2085. You can also email her. Her email ID is contact@rubypowerslaw.com. And you can also visit her website, which is www.rubypowerslaw.com. So make sure to get in touch with Ruby for anything related to DACA or any immigration related cases of yours. But thank you so much, Ruby, for being here. It was so great having you. I mean, it was your first episode, but I really enjoyed this doing with you. I hope you can be back soon. Thank you so much for being here.
No, I appreciate it. And I'm glad to get all these questions. I want to be a resource for the community out there. Really great questions. Really made me thinking on my toes. Rajni, thank you so much for having me and the team. And yeah, let's do it again. Love to be a resource.
Thank you so much. Thank you so much for your kind words. And we are hopefully will be having you back, I think, now in 2025 next year. So until we meet again, happy holidays, happy New Year, and Merry Christmas, Ruby.
You too. Thank you.
Thank you so much. Guys, thank you so much for joining us on this amazing webinar. We are going to be back with Ruby with another great webinar. So make sure that you subscribe to our channel for all the updates, everything related to immigration and all, so that you receive all the updates regarding the shows with Ruby that we are going to do. So make sure that you subscribe to our channel. And for now, I'll have to take your leave. Wishing you all happy holidays, Merry Christmas. And also, I'm going to be back before that too, but still wishing you that. But for now, I'll have to take your leave. Bye for now. Take care. And always keep watching and keep subscribing to Immigration and Jobs Talk Show.
Hello and welcome to today's episode of Immigration and Jobs Talk Show. I'm your host Sam and I'm back again with a very exciting episode that is lined up for you today. So before diving into today's topic and announcing the name of our very special guest, here's a very important disclaimer. That is, by watching our videos, you agree and understand that the information provided by our experts and attorneys, including comments and replies from users, is not legal advice. So use of information is at your own risk. So, folks, once again, welcome back to Immigration and Jobs Talk Show. I'm your host, Sam. And today we are diving into a very critical and timely discussion. That is, how will the Trump's administration impact EB2NIW, EB1A, and asylum applications? So, as we all know, folks, that immigration policies have been a very significant, we have seen a very significant changes in recent years, and also understanding how these changes affect highly skilled workers, individuals of extraordinary ability, and those seeking asylum is more important than ever. So, to explain and clear all your doubts and to guide you on the right path, we have an expert with us today. Please join me in welcoming attorney Amin Yaqub, an expert in immigration law with an impressive track record, with a strong background in litigation. And before his current role at Bogan Months and Months, Mr. Yaqub ran his own solo practice, helping clients navigate complex immigration and litigation challenges. As an EB2 exceptional ability and NIW immigrant himself, Amin understands firsthand the complexities of the immigration process. His personal experience drives his passion for delivering top notch legal representation to his clients, ensuring not only quality but also efficiency. With a nearly 99% approval rate in securing EB2 NIW and EB1 visas for his clients, Mr. Yaqub is a true leader in the field. So, first of all, welcome to Immigration and Jobs Talk Show, and it's an honor to have a show with you. How are you doing?
Good, and thank you for the kind introduction. It's a pleasure to be here.
Absolutely, and it's an honor, to have a show with you, and we are really grateful that you are here with us. So, thank you so much for joining us. And also, I would like to ask that before diving into today's topic and going to talk about today's episode, I would like to know that were you expecting Trump to be back in White House?
Yes, I did actually. I would say I did expect him to be back when Musk, especially, joined forces with Trump, because Musk hasn't failed yet in any of his endeavors. So it meant a lot when he joined forces, and he was like giving $1 million a day to people and stuff like that. So it's just I felt like he's going to come back to office to correct the economy as well. So people are feeling it here in the U.S. and feel like they need to have a better economy, and that is usually the number one drive for the presidential election in the U.S.
All right. So, I would also like to ask that how do you think that under Trump's era, how do you see the future of US? Do you think it will be a new era or a nightmare for US?
Yeah, I think we've seen Trump before, so it's not like we're just exploring a new candidate here. So we've seen him from 2017 up to 2021, and it was, 2016 up to 2020, and it was not a bad year at all. Was the economy went up and everything was, in terms of immigration, nothing actually changed during his era. I would say Americans were, at least according to polls, were feeling satisfied with the economy. Were feeling satisfied with the low mortgage rates, interest rates, and everyone had kind of a chance in applying for jobs and having employment in Trump's era. But of course, people blame the COVID-19 2020 on what happened during Biden's administration. But my point is, it's just the last period that we actually witnessed Trump doing work as a president of the U.S. He was not as bad as the media might actually show, and it's all like a political fight in the U.S. Media is trying to show a picture of Trump. He's like anti-immigration and anti people who are willing to actually help the U.S. be a better country. And that's not true. And that's why I'm interested in talking about immigration under Trump, because it's a completely unpopular opinion if compared to whatever is going on the media or whatever is going on the newspapers. So that's how you. So the other party here is the Democratic Party, uh, everyone tries to influence the public somehow so that they vote for them, so that they actually get them to the seats of power. So we just have to be neutral and watch closely and, wisely in order to see what is true and what's not true.
Absolutely. And also, I mean, as you mentioned, that media has portrayed Trump in a little different way. And we can see that, even when Trump was serving food to in McD, then also that, that social media post just spread like fire. And it was also giving a different opinion that he's serving because he wants vote, or there was some kind of other opinion, that people were portraying in a different, actually in a little negative way. And
Yeah,
on the other side, if we look upon the Democrats, then I would say that for Democrats, the media was a bit lenient. They were more supportive, right?
yeah,
So
yeah.
I think that's why. But also, I would like to know from your side that can you be a little specific about that why Trump won in this election? Instead of, as media plays a huge role, and what media was portraying that what people believe, but out of that also, people supported Trump and made him choose him the leader. So can you please go ahead and share the reasons behind it?
Yeah, so you're asking about my personal reasons why Trump is coming back, not the objective reasons here, or
That's
not.
okay, you can give your reason.
Yeah. So again, Trump is a businessman. He has more knowledge about the economy and how it works. And we have seen, so that's kind of objective and subjective at the same time. We've seen Trump before doing his job as a president from 2017 up to 2021. And we have seen the vice president, Kamala Harris, doing her job as a vice president from 2021 up until now. So when we compare both candidates, we basically see two people who are not new people to us. They have been in power, they have been doing things, so we can just observe and see, was the economy better under the first or the second one? Was every aspect. So what was immigration better and faster for under the first presidential candidate, or under the second vice president who's currently still in office? And by doing that, just a simple analysis to me, it seems kind of obvious that we can see that actually Trump, even asylum, nobody would actually wonder that. It's like asylum was much faster under Trump, and I'm talking about affirmative asylum. So that's an immigration issue, and of course, this is one of the biggest uh, portions of the policy of Trump. So he's not anti-immigration; he's anti-illegal immigration. So he's what he wants to do is to vet people coming in so that he focuses all the efforts, all the efficiency of USCIS on legal immigrants and basically move things faster. In 2017 up to 2021, what we usually had happened was they actually accepted people in asylum in 5 6 months. They scheduled an interview in 5 6 months. Now an interview would be scheduled in 6 years. So we are seeing a completely different era in immigration under Biden's administration. And everyone is so panicking about Trump. Everyone is so panicking about Trump and immigration. Again, because of the media here. So that's why, I feel like it's important to actually show what is true and what's not. And my opinion, may convince you or not, but I'm relying on data here, and I'm relying on statistics as well. Approval rates of EB2NAW and EB1A under Trump's administration and under Biden's administration. So hopefully that will be useful, and hopefully that will actually make immigrants relax a little bit when they think about applying for EB2NAW or EB1A under Trump, not under Biden, because everyone is so panicking right now. And I want to say, do not panic. This is not going to be worse. I think it's going to be much better actually for you.
Wow, that's great. I think this is really insightful, and this conversation, I'm loving it from my side. And also, I mean, before delving into the questions that we have prepared for today's topic, there's one more question that's intriguing in my mind. That do you think, as Trump says, that there will be a mass deportation from the very first day that he'll be joining the office in 2025? So, do you think that that will happen because there are millions of people and practically that's not possible? So,
Yeah.
what's your call on that?
So, is it possible? Yes, it is possible. Is it practically possible? Possible? I don't think so. He tried to do the same thing in the first year he actually took office in 2017, and he couldn't. And when he's saying mass deportation, again, we have to be very specific about what kind of population he's actually trying to deport. So anyone who has legal papers is not subject to this mass deportation. But anyone who has entered the country without any legal papers, without a visa, and they entered through the borders and they came to the US unvetted, probably he will do his best to deport these people. Now, there is a status in between, which is people would actually come through the borders and try to obtain a legal status. So the question becomes, what happens to those in between people? So they would be in a safer condition than those who actually came to the US and remained without papers. And you would be surprised. We actually have many unvetted people coming through the borders. And I don't think that's wrong to actually, make a legal move regarding undocumented immigrants or people who have never respected a rule in the immigration law. I think that happens normally in all countries around the world. So no country actually allows anyone to come in. You have to have a visa. So it's not like something out of the ordinary here. But if you do have papers, no one is going to be able to touch you because you have to be before a court, which we call procedural due process, before an administration, whether Trump or anyone else, actually has any decision over you or deporting you. So if he decided to deport someone with legal papers, let's say a CO8 pending asylum status, then he would actually advise USCIS to refer them or defer them to court. And once they're referred to the immigration court, then they would have what we call a day at the court. So they can represent themselves, they can have an attorney. And if they won the case, they're going to be remaining here in the US legally. If they lost the case, then they will be deported back to their home countries. So that's important to clear some, again, complexities regarding the mass deportation and the media, hyperbole statements that's like, just people are leaving, people are going to be, Trump is going to basically take people, arrest them, and remove them from the US, all immigrants. So generalization is not accurate here. And it's important to distinguish between all these strata of people and immigrants in the US.
All right, that's great. So thank you so much, Amin, for explaining that and taking that question up. Now I would like to shift our shift our eyes on this topic, that how will the Trump administration impact EB2 NIW, EB1A, and asylum applications? So, I mean, my first question to you is that how might the Trump administration focus on merit-based immigration affect the adjudication process for EB2 NIW and EB1A applications?
Yeah, so that's one of the most important questions that we actually get on a daily basis right now. So how would he impact those kind of policies? So first, we have to distinguish between what he can do and what he cannot do. So as a president, he is having very specific authorities that he actually allowed to do. So, for example, we have the matter of Bansal right now, which is the landmark decision behind the EB2 national interest waiver. Is he allowed or is he authorized under law to basically reverse a court decision? That's a no here. So the answer is no. Is he allowed to change immigration law, the ENA Act of 1990, which actually put forward the national interest waiver, the EB2, and most employment-based immigration visas? The answer is no, because Congress has the authority to actually put it, reverse it or change it, amend it with a majority of votes, which is very, very difficult to do because we have, again, even if we have right now a Republican Congress, we still have people who are believing in the immigration under Republicans and under Democrats. So people would be rejecting any kind of change or radical change, I would say, to the ENA Act itself, which has been existing since 1990. So, what kind of impact would Trump be able to do to immigration? Would be direct impact. So, even though he has control over the borders, he can actually advise Homeland Security to not allow people in. He doesn't have much control over USAS except as directive opinion. So he would be giving a directive statement to USAS saying, well, please try your best to do better when it comes to evaluating the national interest waiver or whatever. And my idea, again, would be that he would actually broaden the scope, not as people think, that he would actually make it exclusive to scholars or scientists. And I believe so because he even suggested to give a green card to everyone who's graduating college from the US. So what we're seeing right now is Trump is probably pro legal immigration for the talented, for the people who are actually making a difference to the US. And people who are making a difference would be called, the EB2 NIW applicants and EB1A extraordinary ability applicants. So probably I would actually expect some broadness, and that is going to be broadening this kind of categories. And I'm not the only one who thinks so. I'm not the only immigration attorney who thinks so. So people who are versed in the field actually agree with me. So I believe he is going to be giving directives to USCIS to accept more applications under EB2 NIW and EB1A if really the person is going to be making a difference. And that question remains a question to be answered in the case itself, in the petition and the exhibits. So whether a person is going to be making a difference or not is basically proved in a case, which is usually like 200 up to 400, 600 pages of documentation. So it's a completely objective um, way of evaluating what Trump is about to do here regarding the EB2 NIW and EB1A applications. And I think they're going to be much better than right now, even though we do have a direction from Biden's administration when he took office to try to grant as many EB2 NIWs to people who are working on AI, for example. But from the statistics posted by USCIS, what we're seeing is a drop in the acceptance rate down to 65%. So that direction didn't help much, which shows the nature of the direction. It's not binding, it's just suggestive to the president.
Much, Amin, for your answer. And also, I would like to ask, and being a little specific about what specific changes to evidentiary requirements for EB2 and IW petitions can we expect under a Trump's administration based on past policies?
Yeah, so that takes us back to the matter of Dinosaur. So the matter of Dinosaur, as a landmark case, actually places all the evidentiary requirements that are required for EB20W, uh, and basically, if we complied with the case law, which is the matter of Dinosaur, and the ENA Act, we complete the case correctly. So there is no say of a president here. It's all legal work. It's all decided by a court. We cannot bypass a court. President cannot bypass a court. The court itself may revisit the decision if it wants, But at the moment, it has been existing since 2016, the matter of Dinosaur. Before then, we had a case called New York State Department of Transportation. So we have multiple case law that basically a body of case law precedents that actually put forward the evidentiary requirements for EB2NIW petitions. We never rely on what the president says or what the president did not say. We rely on case law, we rely on the law itself for regulations, and we have to comply, us and USCIS officers. If a USCIS officer might be subjective somehow, he or she might actually make a decision that is not relying on the regulations. And in that situation, the correct action is usually an appeal. Or a motion to reopen, of course. So it's just a matter of complying with regulations. I do not believe.
Um, Amin, can you hear us? I think due to some reason he might got disconnected. But there's no problem, friends. Still you can continue posting your questions, and we are definitely going to take them for an hour as Amin Yakub is with us for an hour. So till the time Amin will come back, we will try to have him back again with this episode. But you don't go anywhere. We'll be coming back with another short break. So don't forget to join us here. We'll be right back.
Yeah, I don't know what happened, but I'm back
Uh,
now.
no, no worries, no worries. I mean, not to worry anything about it. So, yeah, I was saying, everyone that I mean will be back again with a very insightful discussion as we were going on. So, I mean, please go ahead and continue with your insightful information. We would love to
Yeah.
hear that.
So where did it go off so that I can continue from where I stopped?
That's okay. You can give a brief about it.
Okay.
Yeah.
So I think the last question was, would Trump be able to actually influence the okay, now I see. So
Yeah.
what specific changes to evidentiary requirements for EB2NIW petitions? Uh, Again, I said briefly, based on past policies, he only can give directions, but for specifically EB2NIW applications and EB1A. For EB2NIW applications, we have to rely on the matter of Banasar, which is produced by a court. So only a court can revisit that landmark case. No one else can actually change it. A president cannot interfere with the court decision and produce another decision. So that's regarding the evidentiary requirements for EB2NIW and also the regulations in place. They're actually an extract from the ENA Act, which was passed in 1990. Again, it's not expected from the president under the Constitution to have the authority, which he doesn't have, obviously, to actually change something in the ENA Act itself by direct will. So if that needs to change, the Congress has to change it. Now, what remains is the EB1A, which is not a part of the question, but I can cover it. EB1A is also placed by the ENA Act. So again, Congress will have to change the law for us to actually change the evidentiary requirements. Now, what the USCIS officers might actually have from Trump's side is, please broaden your interpretation of the law a little bit, or narrow it. And I believe what we're going to be seeing according to what he said multiple times regarding legal immigration, and that he is pro-legal immigration, and also because now we would have Elon Musk, who's an immigrant himself in his administration. We will be seeing broadening of that interpretation of those evidentiary requirements that are put forward by the law itself, the ENA Act, and the matter of Danasar court decision.
Amin, I would like to ask from you that you are saying that we are going to see a broader aspect. We will be seeing more opportunities, for EB1 or for everyone. So I would like to know it from you that how can you explain it in a bit that how we can see a broader opportunities, because most of the time we are seeing that Trump is trying to implement this and trying to reduce or making the immigration process a little lengthy. Yeah.
Yeah. So now I will use some data, but I don't think I can share the screen here, but it's accessible. You can just type in Google USCIS statistics based on EB2 and AW. So you're going to find the graph going up in 2017, 2018, 2019 of the number of petitions, EB2 and AW petitions, and EB2 and AW approvals. Under
Amit, I'm so sorry to interrupt, but if you want to share your screen, you can also do that. Or you want us to share, then you can share the link in this private chat and we can share it from our side.
Yeah, okay, sure. Just give me
Yeah.
1 second.
Yeah, sure.
So here's
Will be
the
clear.
link.
Yeah,
This is just one statistics, but we have multiple statistics as well. We can go through this one, and
yeah, I think control, if you could please show this data. Yeah, I think we
yeah,
can.
can I control it? Can you scroll down a little bit? So yes, zoom in. So we have here 2017 as well was up. If we looked at here, it's going to be 2017, 2018, 2019 under Trump. And then 2020 was the COVID. And then 2021, Biden's administration. And then 2023, we're still in Biden's administration. Now we're going to see that the blue line, which is the receipt, EB2 and AW, or EB2 category in general, receipts, is still going up, but the green line, which reflects the approvals, is starting to go down under Biden's administration of 2023. In 2024, it went down even below. So what we're seeing here, except of course in 2020, which is an exception, is a rise in the petitions and a rise in approvals under Trump in 2018 and 2019, and in 2017 as well, based on another statistics. And if we can you go down a little bit? I want to show you something else. Yeah, next page, please. The one below this. The one below this. Yes, here. So here we're looking at the O1 petitions, for example, STEM and non-STEM related. So they kept going forward and upwards since Trump, again, had a hiccup in 2021, went bad a little bit, and then it went up again. So O1 is not as influenced as EB2 and AW and EB1A because they're non-immigrant visas. So we're not going to be seeing the same difference on E2s, O1s, and L1s as we're going to be seeing a difference on EB2 and AW and EB1A because they allow people to get green cards, basically. Can you go to the next page, please? Next page. Yes, here. So here we actually see approval rates. If you could zoom in a little bit, it's towards the right end of the table. So 2018, that was under Trump, that was 97%. In 2019, that was 97%. That's for EB2 in general, but it's included. The NIW is included in there. You would actually see the petitions included in all of this. In 2020, we have a high percentage rate, but then it dropped down towards the end of the table. to in 2023 down to 90%. Again, that's including the EB2 petitions that are sponsored by an employer, not only the national interest waiver. And that was published by USAS. It's not like something that I drafted for this live stream. So if we just took a look at the data, we're not going to be finding a source that would actually collaborate the statement that Trump's era was bad for EB2NIW and EB1A, especially. Maybe it was a little bit stricter when it comes to the H1Bs, which I agree with, but it's not the same for EB2NIW and EB1A. And I do not believe there is any reason to actually think that Trump's coming back would actually make things worse, because they haven't. So why would I be convinced that Trump would actually come and say, well, let's change it to 40%? So why didn't he do the same thing in the past administration if he wanted to do it? So it's kind of unconvincing to me. And based on what I said, again, the court has to change its decision. And I don't believe that's going to be happening anytime soon. Congress has to change the law. And I don't think that will be happening anytime soon either.
All right. I think that's great and that's very well explained. And thank you so much. For the data also, because that's pretty much very clear from our side also. And we can see the stats. So with this, we can have a clear picture about it. So again, thank you so much, for that. And meanwhile, I would also like to, greet our viewers, Ram, Jitendra, and Maisha. These are lovely viewers who has joined us for today's episode. So I think welcome to everyone. And here we have a question from our viewer from LinkedIn. That is, at the moment, how long average time to process EB1A and EB2 NIW?
Yeah, so regular processing usually takes 8 months up to 12 months for both EB1A and EB2NIW. If someone would like to have a premium process, they have to pay an additional $2,805 to USAS, and that would actually allow them to receive a decision in 15 days for EB1A and in 45 business days for EB2 national interest waiver. So a decision means an RFE, an approval, or a denial. So it does not mean that they're going to get an approval faster or like they're going to get so a decision can be very general. What usually happens is a premium process, especially for EB2NIW, would actually, and EB1A as well, would actually influence USAS officers to produce RFEs. And it has been the case since, I would say, last year, middle of last year. And that's because the applications went up. Again, we have to consider that everyone who came through the borders, illegal immigrants, they stood in the same line before USAS, but from the asylum side, because we have two types of asylum: the affirmative asylum for people coming through the borders in a port of entry, like an airport, using their passports and a U.S. visa, and people coming through the borders without passing through any CBP officers, without having a visa, and basically, getting their way into the U.S. borders through Mexico or anywhere else. So all these people combined, which is unfair for affirmative asylum applicants, of course, they're all in the same line before USAS. So people are asking me and asking multiple attorneys, what's happening? Why are applications being late? And what's happening in all of this? What's really happening is whoever came into the U.S. through the borders, they're standing in the same line as everyone else. So now I-140 applicants, they're paying a fee called an asylum program fee, which is an additional $300. So the USAS started charging the additional $300 fee so that they actually try to do whatever it takes to hire more officers to get the process going, because we have more than 4 million people who came into the U.S. through the borders undocumented. So what I'm saying here, or what I'm trying to get at, is if Trump really stopped whoever coming through the borders undocumented and only allowed legal immigration, things are expected to go faster in 2 years or 3 years, because we already have millions of people before USCIS. So it takes some time to actually finish the cases that the extra cases that they have, the frivolous asylum cases, and so on. So right now, as I said, just to summarize briefly, it's just 8 months up to 12 months regular process, and 45 days premium process for EB2 nationality waiver, 15 days premium process for EB1A.
All right. So thank you so much, Amin, for answering this question, and thank you so much, Mai Cho, also for participating in today's session. In case if you still have any follow-up question or would like to know about any other topic related to immigration, then please go ahead and dial on this number, and you can also give a call on this number and can also participate in today's session. And you can also comment us with any other different topic or any other follow up question that you would like to ask from today's attorney. All right, so now I would like to take Jitendra's question, and he's saying that I'm a physician applying for an EB2 NIW based on serving underserved communities. Could changes to the program's national interest definition under Trump affect how these cases are judged?
Um, U.S. will always welcome physicians, especially if you're focused on underrepresented people or underdeserved communities. And there is always, of course, I have to note here, a shortage is not a reason for the EB2 and IW eligibility, because it's covered under the perm process regulations. So if you are sponsored and you have a full-time job offer and you're basically before the Department of Labor doing the labor certification, what we call the perm process, there is an exception for having a shortage in your field. So the argument, the same argument does not apply for a waiver. But what I'm saying is a waiver is actually not reliant on the shortage, but it's relying on you serving those kind of communities. So that's different. But what I'm here, if you want to apply as a physician, your chances of approval would be really high, because USCIS really appreciates doctors and physicians, especially if you're really about to serve, or you have a proposal to serve the underdeserved communities or people who are being basically without doctors. But again, even though it sounds the same, we're not going to be arguing the shortage. We're going to be arguing that you're going to be serving those kind of communities, which is kind of different.
Absolutely. I think healthcare is the most important sector in any nation, and that's like a backbone of any country.
Yeah.
So I think that's very well explained. I mean, from your end, and to Jitendra also, if you want to know any other topic or if you have a follow-up question, then please go ahead and feel free to comment us on this session. All right. So, I mean, I would also like to ask about, are there any specific fields or professions that may be favored or disadvantaged under a Trump administration concerning EB2 NIW and EB1A applications?
I wouldn't say fields or professions. I would actually say how the case is prepared. So if someone is trying to argue that basically they're going to be a management consultant, but they're not going to be contributing to any specific field. There's just going to be a management consultant. That's not good enough. The proposed endeavor, of course, has to be very, very specific. It has to highlight how it would actually bring the difference in the U.S. To what sector or sectors, and technically, how would that happen? How would it cause that kind of difference and impact on that sector? So anything that is not specific enough would probably be denied. So it's not really about the field itself. It's about the specific proposed endeavor. And if you do have a specific proposed endeavor in even arts, that would be accepted, as opposed to having a very general proposed endeavor in being a physician or in being an engineer. So it's not about STEM versus non-STEM. It's not about being an engineer or a doctor or or an artist or a theater production, company or whatever. It's about the specificity of the proposed endeavor and how can we convince a USAS officer that you have already had some success in the past, which we should have prove in the petition, of course, and all the documents, and that you're aligning your education and professional experience and past contributions to your proposed endeavor in the future, which will bring in that difference, which is going to make America a better country in the future, or even a sector in the US a better sector in the future through business or scholarship.
Right. And we really hope that America becomes great again, as Trump says, and that's how, America feels. So, all right. We also have another viewer, Knife, here, and Knife is saying hi. Hi, Knife. And the question that Knife has is, do you think that Trump government can be doing all what he talking? And if not, what are the challenges?
I don't think Trump will be able to do so because we have laws here. The Constitution, you have to understand that the U.S. is a democracy, right? So its rule of law is dominant here. So Trump cannot be a one man who's doing everything. So we have the judiciary, and we have the Congress, and we have the president. So three branches of the government. They have checks and balances, of course. The Constitution says, or documents basically the relationships between all of them. So Trump does not have any authority to actually reverse a law that was enacted in 1990, which is the ENA Act that provides most of the immigration visas. Trump does not have the authority to reverse a court decision, which is a landmark case. It's a precedent. So a court can only revisit and reverse that decision. Trump cannot do so. He cannot basically interfere with the court judgment and say, well, I'm going to reverse it tomorrow because I feel like it. What Trump can do is give directions to USAS and CBP officers. Now, all these directions binding. The answer is not really. They're suggestive, and they are not binding. So USAS, and based on what I showed on the statistics, has been doing favorably. Basically approving many petitions for EB2NIW and EB1A under past Trump's administration. So there's no reason to believe that in the next Trump's administration, he's going to be doing something different. What I think is he's going to be actually broadening the visas, EB2NIW and EB1A, to some extent so that they accept more talented people. Because now he is having Musk in his administration as well, who is, I believe, is an EB1A or EB2 nationalist waiver himself. I would say probably he is either EB1A or EB2 NIWs, although some people argue that he's EB5. But why would he choose EB5 if there is a higher category? So, we should ask him this probably.
All right. So I would like to say, Kinfi, thank you so much, and my apologies for mispronouncing your name. But Kinfi, if you still have any questions that you would like to ask from our attorney, then feel free to post them, and we are definitely going to take them up. All right. So I mean, you are explaining fantastically about all the questions that we are taking up. Here's another thing that I would like to know from you, as you also mentioned about the border and about the security. So we all know that Tom Homan being appointed as border czar under Trump's administration. So how do you think that his approach will affect the border security, asylum policies, and immigration in the future?
So the question here is about asylum as opposed to EB2 NIW, or?
I think, okay, let's take about asylum, EB2, and IW, because we are taking that as a topic. So yeah, please go ahead and talk about it.
Yeah. So again, the affirmative asylum wouldn't face many challenges in the future, in my opinion, because these people enter the U.S. legally using a visa, and they are documented. We basically, USAS can easily, in connection with the FBI, can figure out if someone is or has been a criminal or not in their home country. So they vet people, and vetting is important to get people in. Affirmative asylum, in my opinion, would actually go faster. People would have interviews scheduled faster than 6 years, in 2-3 years from now, because we have to, again, the USCIS has to decide millions of cases so that it actually creates that faster process in the future after undocumented people came in through the borders. So that's number one regarding affirmative asylum. Affirmative asylum people who actually applied and got the CO8 legal status, which is a pending asylum interview, and they're waiting in the U.S. legally for the interview. They shouldn't be fearing anything, again, because they are documented. And the first sentence in the USCIS receipt that they have received actually says you may remain in the U.S. lawfully until you are scheduled an interview. So right now, they shouldn't be fearing any changes in anything. Also, you have to understand that from a legal standpoint, laws cannot be applied retroactively. It's unconstitutional. So even if Trump, let's say, which is, I would say it's an 0.01% chance. Let's say he said, well, now I believe that I want to get rid of affirmative asylees who are living in the U.S. legally with a CO8 pending asylum interview. That cannot apply to you because you are already here. You're already having the CO8 legal status. You already have the documentation. So that probably will stop people in the future from getting the same card as you, the CO8 employment-based, not employment-based, it's called the EAD, Employment Authorization Card. And that will prevent that for the future, not apply to the past or the present. So that's important to note because status quo will remain the same it is right now.
All right. So,
Yeah, I think there is an interesting question here, if I may reply to it. It's by Caveat.
is saying that for EB2 NIW applicants, there's a speculation that USCIS could enforce higher education or professional thresholds. So, do you think that applicants with advanced degrees but limited publications could be at risk?
Yeah. So I wanted to reply to that question because there is a misconception that is going around that you have to have publications and citations to have an approved EB2 NIW petition. And that's not true. So we have three kinds of applicants. We have the scholar applicant for EB2 NIW. We have the entrepreneur applicant for EB2 NIW. And the entrepreneur is not expected to have any publications or citations. And we have the professional path, which is a third unexplored path somehow, which is basically someone working somewhere in the US saying, through my employment in that institution, let's say nonprofit, I will be doing some novel technique, and that novel technique will bring in the difference on the US nationally and on the field itself, and therefore will have substantial merit and national importance to the US. So for the second and third paths for immigration under EB2 NIW, you wouldn't expect to have publications and citations. Only as a scholar, we would expect you to have publications and citations. So it's not going to affect you in any way right now or even in the past, since I would say the matter of Donosar, which actually reversed the New York State Department of Transportation. And the matter of Donosar said you can have a proposed endeavor that is important for the business, for entrepreneurship, for arts. So it broadened the criteria for EB2 NIW to actually cover multiple non-STEM fields and STEM fields that are not scientific or scholarly based. So that's regarding this question. Regarding the advanced degree question too, The ENA Act itself, which belongs to 1990, so it has been enacted for some time and never changed, is the one that actually states that you have to have a master's degree or a bachelor's plus 5 years of experience. No one can change the ENA Act except the Congress itself. Now, if the Congress decided to change it, that Congress needs the majority of votes, which is very, very, very difficult to get when it comes to immigration. So my answer is there is not going to be a change to the advanced degrees requirements for EB2 and AW, and there's not going to be a change or possible change for the criteria itself for non-STEM, STEM professionals, entrepreneurs, and scholars. All paths would be the same probably for the next 4 years. It would be interesting to see if he would really broaden the EB2 and AW category or not, show his directions to USCIS officers. But otherwise, I don't believe that there's going to be much change in this practice.
Wow, that's so insightful. And okay, so thank you, Kavya, for your participation and for your question too. So here's another question, that I would like to ask: that how might the reinstatement of policies like remain in Mexico affect the asylum seekers' chances of success in their application?
Yeah, that's a very interesting question. So if that person is Mexican, for example, and he or she has a visa and they can come into the U.S. Through a legal way, then probably they wouldn't face much challenges. Now, if that person wants to come illegally into the U.S., probably that statement will apply to them. Now, if that person is not Mexican, and let's say he or she is from Argentina and they traveled to Mexico and they wanted to come through the borders, Mexican US borders, then USCIS will actually try to stop them by, again, building a wall or whatever, and that will be through the CBP officers at the borders. So if Trump changed the policy again and tried to spend a lot on building that wall, that would be number one. Number two would actually be, and he tried to do that before. Actually, he tried to sign an agreement with Mexico, which we call in immigration a third safe country agreement. If you are an Argentinian living in Mexico, do asylum over there. Do not come to U.S. To do asylum, to seek asylum. And that's crazy because Mexico may not be safe for Argentinians or for even Mexicans. So he tried before to pass this kind of international agreement, and he failed. It's very difficult to do, and because Mexico is also in the NAFTA agreement, which changed to the USMCA agreement between Canada, US, and Mexico. It's very, very difficult to try to build a different agreement, especially for a safe third country, saying, well, anyone who is in Mexico on a Mexican land will have to apply for asylum in Mexico, and he or she would not be allowed entry into the U.S. So it's very, very unexpected. I hope that covers all types of people who might actually come from Mexico, whether Mexicans or non-Mexicans coming to the U.S. legally and versus, of course, illegally.
Absolutely, and I think that's very well explained. So, to our viewers, also, friends, if you are navigating, your immigration journey, or have any doubts, or need any type of guidance related to immigration, then please feel free to contact Attorney Eamon at the number that is provided. That is 407-578-1334. So this is the contact number that you can call him and ask your doubt. And with this, you can also email him on ayakub at boganmonths.com. And you can also visit his website, that is www.boganmonths.com. So these were the contact details that I would like to share. And now moving ahead with my one more question, that I would like to know about family-based immigration, right? So
Yeah.
now I want to know that how do you anticipate Trump's approach to family-based immigration will impact the individuals who are applying for visas or seeking asylum?
Um, Applying for visas or seeking asylum.
Mm-hmm.
So, if someone is marrying a U.S. spouse, they are allowed to adjust status based on their marriage if it's a bona fide marriage. So, if it's a good faith marriage, of course, and we could prove that, that you can actually skip all the asylum process, you can skip all the visa process, and completely go ahead and apply for the I-130 and the I-485, I-765, I-130 and one, and basically get all the cards you can get in the least period of time possible under USCIS. So family-based immigration is highly recommended if you do have an American spouse, or if for example you have a father or a mother who is a U.S. citizen. Now it differs from, again, it's just the categories are different. So you would have a first preference for the spouse's father and mother, and first preference is actually for the spouse, second preference is for the mother and father, third preference will go towards sons and daughters, and fourth would be the brothers and sisters. So the lower the preference, the more years you would have to wait. Otherwise, there is no interrelation between visas or seeking asylum and family-based immigration. We can see some cases where basically a person who is applying for asylum in the middle, having a CO8 card, for example, pending asylum, waiting for the interview, he may actually marry someone in the process. And just by marrying an American citizen, that will completely change matters into getting the green card through marriage, not through the asylum process. And later on, after they have the green card, they can basically send a letter to USCIS and ask USCIS to withdraw their asylum case and basically go ahead and do the green card through the marriage-based immigration, which is family-based. Otherwise, there is no foreseeable impact on these types of visas.
Absolutely. And I would like to know from your side that it's almost 1 hour that we have reached, but I have some more questions from my Facebook group. So if you have some time, is it okay for you to give 5 to 10 more minutes to our audience?
Yeah, sure. 10 minutes are okay.
All right, that's pleasure. Okay, so we can see here. I hope you can see my screen, right?
Yeah, I see it.
Yes.
So, what a
Yeah.
pending EB2 and IW affects you when getting H1B visa? Waiting time can acquire H1B while there is a pending EB2. G1 holder. Thanks, Burden. Yeah. So that's an interesting question. So the H1B especially is a different breed of visa. So we call it a double or a dual intent visa. It's an immigrant and non-immigrant at the same time. And that basically means there is no contradiction whatsoever between the H1B and EB2 and IW, because EB2 is an immigrant visa. So applying for a double intent visa like the H1B at the same time was applying for EB2 national interest waiver, which is an immigrant visa, that does not show any contradiction in any intent. So you can go ahead and apply for the H1B and also apply for the EB2 and IW. But the trick here is to maintain your legal status through the H1B, because otherwise you may actually fall out of legal status since the dates are not current yet for the EB2 and IW. Meaning that if you got an I-140 approved, you would have to wait some time before you can apply for a green card and a combo card. So that means between the approval and applying for a green card, you would need to maintain legal status through the H1B. So it would be highly recommended to actually go ahead and secure an H1B before you apply for the EB2 national interest waiver.
All right, that's wonderfully explained. And here's another question that is, do we need to submit ETA 9089 and related for EB2 and IW self petition?
Yes, it's a part of the regulations. So even though it sounds and it reads like it shouldn't be submitted, because it's basically a labor certification application for the perm process. You must submit it. You have to complete specific sections in the 9089 form. Right now, they have produced a new one, so you would have to download the new version and use it. And once you comply with the regulations and fill it out and sign properly, you have to include it in the submission. Otherwise, you will probably get an RFE requesting you to do so.
All right. So, moving ahead, here's another question that before submitting or mailing the petition, do we need to create an online account on USCIS?
No, you don't need to create an online account on USAS. I would say it would be helpful to do so, but you don't have to. You're not required to establish an online account on USAS. Now, it's helpful because it allows you to track the case, to actually get notifications whenever something is going on. If they updated your case, for example, into decided or approved or issued an RFE, you will get notified if you do have a USAS account. Now, if you're doing this through an attorney, your attorney would actually have access to your case and would actually get the notification from USAS on your behalf. So you don't have to do it if you have an attorney. You have, I would recommend doing it if you're doing this on your own and would like to stay updated regarding any changes that may happen to your case.
Absolutely. I think taking expert advice is mandatory in immigration process. So, friends, if you still, need any guidance or need any help, then here's the contact details of our attorney that is mentioned, and you can see the contact details like phone number, email ID, and also the website that is being provided on the screen. So, please go ahead and share your, any information or any doubts that you have, and I'm sure that attorney Amin Yakub is definitely going to take them up and he's going to solve them. All right. So, I would like to ask a few more questions, if you allow. That is,
Yeah, go ahead.
yeah, that's great. And I don't know why. Yeah, that's great. My screen is visible now. So, which part of the ETA 9089 need to be filled for EB2 and IW? I have already filled in the Appendix A and final determination forms.
Yeah, that's all what you need to actually provide for the new version. So it's just final determination and the appendix A. So basically, education, experience, certification, skills, which is appendix A, and then the two pages where you have to sign basically as the beneficiary, and that's all. And the preparer, of course. So you would have to sign. If you prepared your own 9089, you would have to sign twice on the two-page towards the end.
All right. So I think that's all from my end because I have covered a few questions that I wanted to ask from you. And yeah, I think, it's almost time for our very insightful session. And it's just 1 hour we passed and we didn't even realize. So from my side, it was a very, amazing, a wonderful experience and obviously an honor to have a show with you. And you were outstanding. You were clear. You made up a very great points that that was very insightful and that was very eye opening too with the datas and with all the facts and stats that you brought up. That was great. So how was your experience in today's episode? How it was?
It was amazing. I really enjoyed my experience, and I actually really enjoyed the questions as well. They're very, very interesting questions
Right.
from your side and from the audience side as well. It was really a pleasure being here, and thank you for the invitation.
Absolutely. And I think the questions, those were, interesting, but even the answers, those two were very much interesting. So I like that too. And there's another comment from Freelance Mastery also.
Yeah, let's
So
do that as the last question and move
all
on.
right. That's
Yeah.
great. So it's that what if my case was submitted under Biden's administration and got adjudicated when Trump's administration? Which administration am I entitled to?
Yeah. So probably that question has to do with the importance of the proposed endeavor than which administration would actually adjudicate the case, because they're the same USCIS officers. People think that, again, Trump is going to remove all USCIS officers and replace them with other USCIS officers. So they're just the same officers deciding the same cases under the same legal framework, whether under Biden or Trump. But your question might have a hidden question, which is there is a difference in the importance of there is a difference in the importance of policies between Biden's administration and Trump's administration. For example, solar energy is very, very important for Democrats and for Biden's administration, but it may not be as important under Trump's administration. So, since you have filed your case under Biden's administration, your case should be aligned with Biden's administration's importance when it comes to policies regarding solar, etc. Again, these are not black and white, so you have to understand that Trump is not like he's not going to dismantle the solar energy when he arrives. Again, like the biggest producer of electric cars is by his side right now. So we actually that's why.
I think due to some reason, Eamon, can you hear us?
Yeah, yeah. I'm just saying, last thing I wanted to say is um, there there is not going to be a huge difference in policies and the importance of those policies, because right now Trump is more convinced of not solar but basically clean energy and stuff like that. But he's not willing to sacrifice oil and gas either. So we're going to be seeing a new Trump administration basically focusing on all energies, probably nitrogen as well. He talked about nitrogen cars, but he said, well, they're risky. So now that Musk is on his side, probably we'll be seeing a different approach towards electric cars, towards solar energy, and towards policies that Trump was in the past kind of reluctant to accept as important. Otherwise, to answer your question directly, your application will be decided based on the policies that are considered important at the time your application was received. So when you have received your USAS receipt under Biden's administration, that's the time limit, that's the time estimate where actually the officer has to look around and say you have complied, you're actually contributing to an important policy under Biden, not Trump.
Wonderful, wonderful. So, yeah, I think, Eamon, we also took the last question of today's episode, and that too very well explained. So, again, to our viewers, also, guys, if you are navigating any immigration journey or having any doubts, then please go ahead and contact our attorney, and he's definitely going to help you out. And I mean, from my side, as I also said, that it was a wonderful experience to have a show with you. And you were also saying that you also enjoyed the questions that we prepared, the audience they were asking. So big thank you to attorney Amin Yakub for making this session a brilliant one and bringing a very insightful and a very eye-opening stats and facts about today's topic. And I think, yeah, that's all, and to our lovely viewers also who participated in today's webinar, thank you so much to everyone. Keep on posting your question, friends, and we are definitely going to keep them on asking and try our level best to provide a best solution to you. So thank you so much, everyone, for this amazing session. Don't forget to like, share, and subscribe to Immigration and Jobs Talk Show. I'm Sam, signing off for now.
Thank you.
Thank you so
Have a good
much.
day. Bye bye.
Hi everyone, welcome to Immigration and Jobs Talk Show. I'm Rajni Bharara, your host, and before I move ahead, let me read out this very important disclaimer by watching our videos. You agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. All right, after this important disclaimer, welcome back everyone to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and today we are here to unpack the ever-changing world of immigration with expert insights and a lively discussion. Whether you're navigating the complex maze of visas or just curious about immigration trends, you have come to the right place. Today's topic: EB2 NIW visas. Are USCIS making it harder to get it approved in 2024? Buckle up because we are diving deep into this hot button issue. And trust me, we have got the dream team to break it down. Yes, but first, let's give a warm welcome to our wonderful audience, whether you're watching us live or catching the replay. Thank you for tuning in. Be sure to stick around because this episode is packed with valuable insights and maybe a sprinkle of humor too. And don't forget to drop your questions in the comments. And yes, after we get answers from our dream team, we will be asking your questions to them. So now, without any further ado, let's meet the dream team, our incredible guest for today's show. First up, we have Rob Melvin, a 26-year veteran in the legal arena and a licensed attorney by the Texas Supreme Court. Rob's journey has taken him from litigating in Texas courts to serving as a Foreign Service Officer for the U.S. Department of State, where he held consular commissions under 3 U.S. presidents and adjudicated over 9,000 visas. From diplomatic scrutiny trainings to managing high-profile visits from the likes of Hillary Clinton and Mike Pompeo, Rob has done it all. Today, he's a powerhouse in employment, business, and investment-based immigration. So, Rob, welcome to the show.
Happy to be here. Thank you for the invite, and we're humbled to be on your show and thankful for the opportunity.
Of course, it's a pleasure having you on the show. And after Rob, everyone, let's meet our second guest, Philip Rodriguez, who might just be the Clark Kent to Rob's Bruce Wayne. Philip is a partner at Doss Rodriguez PLLC and brings 13 years of stellar experience to the table. He's represented clients globally, tackling everything from family-based petitions to removal proceedings with finesse. With a Juris Doctor from St. Mary's University and a knack for delivering personalized legal solutions, Philip is a force to be reckoned with. Philip, we are so glad to have you here. Thank you so much for joining us today.
Yes, thank you very much, Rajni. It's a pleasure to be here.
Well, thank you so much to Rob and Philip. And guys, let's get into today's topic. The topic, like I said, is the EB2 NIW visas. Yes, EB2 National Interest Waiver visas. With the USCIS rolling out the new guidelines, are these coveted visas becoming harder to secure? Are we entering a new era of red tape? Or is this just a bump in the road? Let's find it out from Rob and Philip. So now, without any further ado, Rob, I would like to come to you first. While I was introducing you, you have this 26 years of experience. I might have accidentally called you a 26-year-old, which you also look like, the both of you. But Rob, also I would like to know from you, recently the US presidential elections results were out and the Trump is back with his very aggressive team and his administration, because every day he's giving us a shocker with picking those controversial candidates and making it harder for immigrants to actually think that is it going to be possible for them to get into the US now, or is it going to be more difficult? How is the situation going to be? So it's so chaotic and it's all over the place right now. So were you happy with the results? Let's first come to you and then we can see how Philip felt about it.
Okay, well, I mean, to my knowledge, I don't consider this bad news at all, especially for Indian nationals. It may be bad news for people from the Western Hemisphere that have come over irregularly, because I could see removal practices being very more difficult. But there's some things that I think that maybe your audience should keep an eye. I mean, listen, there's 3 people close to Trump now that have his ear and will have it regularly. You have the second lady, Usha Vance. You got Vivek Ramaswamy, and then you have Kash Patel. All 3 of those people are going to be talking to him every day. And believe me, they've been in the U.S. for a long time. They know the plight of the Indian retrogressed visas and the problems that people have been having coming from India to here. As for like the comment on the adjudications becoming more difficult, we've actually seen in our practice, 2023 was the dream years. Those were the golden years for the EB1A. We were shooting 3-point shots, getting approval without a lot of pushback. 2024 actually turned into a bit of a quagmire. That I don't know what happened. I don't know if USCIS was pushing back against the administration because of all of the irregular immigration coming in. Maybe as kind of I don't know, retribution, if you will. But we have seen in 2024 more pushback, more stringent, more new requirements, almost pre-Danisar analysis to the EB2NIW than we did in 2023. So I have high hopes for 2025 for the Indian national population. They're some of the smartest applicants that we have, the most highly educated, the most qualified. And I mean, in my opinion, everybody's got an opinion. I think Trump and his team are going to be looking for people of that caliber that are going to come in and kind of lift the boat of the U.S. economy with especially STEM, financial investment, those types of visas coming in. So I'm actually super hopeful that 2024 will go away for the EB2NIWs because it's been a rough year. And that 2025, once things start rolling, we're going to see a better improvement. Again, that's if USCIS, each agency kind of has its own culture, does its own thing. I worked for state under Trump. They pretty much ignored Trump and just kept doing their own thing. I mean, of course, they had to do some policy and economic and political moves that he made them do. But I was in the consular section and they just kind of, they're like, yeah, whatever. So I don't know. I don't know if that is too much information or answers the question, but I think that we're going to see, I hope that we're going to see an improvement, especially in the fields of STEM and cases where we can make a really good argument that in addressing a very specific national interest for the United States.
Philip, what about you? Because, I mean, Rob said that it's going to be, with Trump coming back with his team, it's going to be good for the market and good for the economy. And, we have seen that Trump is already talking about putting those percentage of tariffs on those countries, especially Canada. And, recently Canada's Prime Minister Justin Trudeau, he met President Trump, and he actually joked with him for becoming, Canada becoming the 51st state of and merging into the US. And he said, you are more than welcome to become, you will not be the Prime Minister, but then you can become the governor of the 51st state. How about that? So, he has really scared Canada. And, there are talks about putting 100% tariffs on the BRICS countries if they think about, getting another, if they are getting those, instead of, if they will give priority to some other, anything else apart from dollar. So what do you think? Because, there are so many talks about that. So how do you see? Do you think it's going to be good?
Well, yeah, I agree with Rob in terms of the EB2NIW visa, right? Because that visa is for people who can show that their work is in the national interest of the United States. And touching on what Rob mentioned, how we have seen, so under a Trump administration, we may see a stricter interpretation of USCIS policies, but I don't necessarily think that that's because it's the Trump administration. If we go back, let's think about DANISAR, which is the guiding framework for an EB2 NIW petition. DANISAR became law in 2016 under Barack Obama. And since then, and think about that, 2016, that's only 8 years ago. So that framework hasn't been in effect for very long. Prior to DANISAR, we had a much stricter framework for EB2 NIW under the New York State Department of Transportation, and that went into effect, I believe it was 1998. But the point is, we may see stricter interpretations of USCIS policies under Trump. I don't necessarily think it's a function of Trump. I think we'll get into this a little bit later, but I think it's more a function of the fact that a lot of people are learning about EB2 NIW now, and a lot of people are filing those types of applications. It's become highly competitive, and that is why USCIS has to do a better job of sifting through all of these applications and finding out which ones are truly in the national interest of the United States. And I think what we're probably going to see is the industries that will be favored under a Trump administration are going to be manufacturing, I think national security, and I think technology, which may not be good news for those who would like to apply under the humanities or the arts. They may have higher hurdles to jump.
Okay. Well, thank you so much to the both of you for that amazing answer, and also for sharing your point of view. But with this, Philip, I would also like to know from you that what do you think? Do you think that USCIS gets influenced by who takes the office? Let's suppose, because earlier it was the Biden administration and now it's going to be Trump administration. So do you think they make plans and they make the policy changes or whatever updates that they give in? It somewhere gets influenced by who takes the office?
I think the leadership does have an effect on policy directives and adjudication standards. However, I don't think it's necessarily going to be a complete shift, right? I mean, USCIS is a relatively large organization. It has its own culture, right? So because a new leader comes into office who may have a differing opinion on policy, sure. I think it is fair to say that might influence some adjudication standards. However, I don't think that it's necessarily going to just make it impossible for people applying for EB2 NIW. As I mentioned, what we may see is a shift in the industries that are favored by this administration, because it's no surprise. Trump and his team have come out and said that they want manufacturing in the U.S., technology, and national security. And so I think we may just see a shift in the types of industries that are favored. Would you agree?
Rob, what about you? What do you think?
Definitely. I mean, it does depend who's put in charge of DHS, and then it flows down from there. And then they'll have the director of USCIS and the deputy director, and they will push downwards. But I've been inside the belly of the beast. I work for state, and I know they do have their own corporate cultures. I think, in my opinion, they're going to be more in line with, if these predictions are right, with the emphasis of Trump and his team continuing to be on manufacturing, tech, STEM, anything like that. I think it will influence the adjudicators in favor of pleasing their bosses. These people are all bureaucrats. I was a bureaucrat, right? So what's the one big fear to a bureaucrat? It's your career. And what is that? That's your review at the end of the year, okay? these are all civil servants. In fact, they're all graded on a G scale, which means you don't just get promoted. You actually have to, if you want a higher, better job, you want more pay, you have to apply for a higher scale, a GS 14 instead of a 13, right? Mm-hmm. So the only way that they're going to do that is they're going to have to show that they have a track record of pleasing their bosses. If their bosses are telling them, look, Trump says X, we need to go in this direction, and that's the order they're getting from the top, they're going to need to move that way if they want to eventually secure a higher level government service job and keep continuing on. There's some that'll be perfectly happily being a GS-12 and couldn't care less and just want to draw their check, do their 40 hours and build their pension, right? Mm-hmm. But there's some go-getters, and the hustlers are going to want to see, they're going to want to comply. So I think it's going to be a great year for EB2 and IW. 2024 has been a challenge for us in our practice, and I know it's not specific to us because we're members of ALA, and we have our distros with thousands of immigration attorneys all over the United States, and we constantly keep an eye on it because it's one of our areas of emphasis is employment, business, and investment, immigration. So we really keep a close eye on it. And I think it's going to influence them. Yes, I think there's a misperception that it has as much influence as it actually does, but that's just my experience in working for state. And I have a lot of friends at USCIS and DHS, so I kind of keep my thumb on that pulse as well.
Okay. So, but then, Rob, when you say influence, do you think that influence is going to be good or is it going to be bad?
I think for the Indian national community, it's going to be fantastic. Mm-hmm. It's one of the smarter applicant pools, one of the more ambitious applicant pools or countries, and just more qualified, and they're more hustlers. I mean, they just are go-getters. And I think that's going to be what the policy that they're going to want to be pushing downstream at DHS, down to USCIS and everybody else, to the adjudicators, is look, we're kind of changing the way we look at immigration. We want to do, as you've mentioned before, kind of a merit-based system. The family system will always be there, but they want to improve our economy. And the only way to really do that is to do a brain drain away from other countries. And India's got plenty of brain drain power to provide to the U.S. I think it's going to be good for India.
Okay. But then what do you think about the visa? I've still not delved into our questions that actually we have prepared for you, but I'm still coming up with the follow-ups. But then I would like to know from you, Rob and Philip, that then what about the wait times that India actually sees, from whenever the visa bulletin comes, the processing times, the wait times for India specifically are very long. So why do you think that happens? Philip, I would like to start from you.
Well, the reason you see these retrogressed visas and the wait times is because of the per country caps on green cards. It's a 7% cap on green cards from any country, and you have a lot of applicants from India. 7%, I believe that works out to around 9,000 visas, 9,500, something like that per year. Mm-hmm. But because we have so many applicants, that's what leads to the retrogression. And something that I think maybe we could see, there's legislation pending right now to remove the caps on green cards. And so that's something that we could see help with these retrogressed visas. But that's a great point that you bring up. And that is the biggest India-specific challenge, is that we're seeing retrogression for decades.
11 years to visa availability and 12 to adjust.
Yes.
Wow.
Yeah, so that's a very good point. And what you do in that instance, and what we advise our clients is, well, let's look for, if that's what you're going for, let's look for other ways to keep you in the U.S. lawfully keep you working. Let's look for other options, because the EB2NIW visa is just one tool in our toolbox, just one. We have so many available options out there. So that is key when it comes to an analysis for an Indian national who is seeking the EB2NIW.
Okay. And Ram, okay. So now I would like to actually ask from you that, but do you think in 2024, I mean, it's just about to end and 2025 is about to start, right? So do you think in 2025, EB2NIW is still going to be that golden ticket, you know, for the immigrants?
Yeah, I mean, so here's what's happened, and Phil can put in his 2 cents. I think the H1B program, the CAP H1B program, has become such a disaster over the last 2 cycles that everybody kind of flooded from H1B over to EB2NIW, and I think that's what's caused the problems in 2024. So what I would like to see happen, what I hope to see happen, is they actually fix the H1B, because people have been gaming the H1B so badly that the percentage of the lottery winners, I think, was 10% last year and 17% the year before. So people are opting for other ways. So they're going to the EB2NIW. EB2NIW is definitely the golden ticket. I mean, same with EB1, but you got to have a good package, you got to have a good plan, and you have to be qualified. You know, it's not the golden ticket for everybody. You know, we usually can knock out the first part relatively easy, to the EB2 analysis. It's when you get into the national interest NIW analysis, substantial merit, they usually just give it away, because the ones we're throwing up there, we're not throwing up to open up a McDonald's restaurant, right? We're opening, you know, we're doing naval inspections and maintenance on cargo ships, oil platforms, logistics and supply chain cases, warehousing and distribution. I mean, those types of cases, you're not going to just get an EB2NIW for any reason. But we usually, substantial merit, usually they just kind of give that one away, because it's easy to articulate how something might be in the substantial merit. So then there's 3 prongs, but there's actually 4, because the first one has 2. Then you get to the national importance. This is the one where they're currently really sticking it to applicants. Okay, so what? Your program, your subject matter expert has substantial merit. So what? How is what you're going to do going to be in the national interest? We have to now lay out the breadcrumbs piece by piece from their business plan, from their proposal, to the substantial merit piece, and connect the dots very explicitly for the applicants. And then you drop down to is well-positioned. You know, before, well-positioned was kind of like, well, they've got a master's or they've got a good professional history. Now they want more. They're even asking for kind of like, okay, you're going to do this. Do you have the financial wherewithal? Where are you going to get those funds? Do you have any kind of track record in doing this particular endeavor? So they're making that one a little bit harder, but that one is usually we're able to overcome relatively easily. But then they jump to the last one, which is the most nebulous of them all, whether on balance it would be in the interest of the U.S. government to waive the labor certification. Well, what the heck does that mean? I mean, I thought we answered that in the first three questions, but basically we're making the argument that this is so necessary that we need to just move away the year and a half labor cert process, which is currently just getting longer and longer and longer, and just get this person in. Let's get him in. Let's get him going. Let's get him improving the country. You know, whenever there's a national crisis that or an international crisis that we can link to and cling on to, that's related to our client's deal, we do that to, and try to file as quick as we can to, to hit that particular piece. Like, we need this person in now. So anyway, I don't know if that answered your question, whether it's the golden ticket. It's not for everybody.
Yeah.
Not for everybody. It's not the Willy Wonka chocolate bar. You have to actually, come in with merit in this deal. When we make you look as good as you can possibly look, but you have to have some juice behind you as well.
Right. I mean, if this is not the golden ticket, maybe US can also come up with, golden visas like Dubai or maybe, other countries. They offer golden visas, right? So maybe US can also come up with something like that. Right, Portugal. So, okay, coming back to my questions, Rob, I would also like to know from you that with President Trump now returning to the office, what do you think? What are the risks of reversing the more lenient policies recently adopted by USCIS regarding EB2 NIW applications? And how do you think that this might impact applications who already have begun their petitions?
Well, first of all, the more lenient policies, maybe that applied in 2023. We are not seeing that in 2024. So I think the question may kind of presume an erroneous answer. We think they're stricter now than they have been for the last couple of years. Although on paper they might be lenient, in as applied, they're much stricter. So everybody who's already in play, they're going to get adjudicated under the standards when it's on that person's desk. So whatever the policies are at that time, there's not going to be any kind of grandfathered in, because DONASAR is the standard, right? It has been since, what'd you say, 2016. So that standard hasn't changed. The way they implement the standard, that's changed. Couple things that have been problematic or troubling to us that we've seen is, we've read a lot of articles and tracked a lot of things that it looks like they're adjudicating a lot using AI tools, which everybody uses AI tools now, right? Problem is, I used to work for the government and I know what kind of software they usually get. And let's just say it's not ChatGPT 4.6 or whatever, we're seeing RFEs that are misspelled, incomplete sentences, jumbled garble, repeat boilerplate clauses just that maybe don't even apply to the same case or the same subject matter. That's a problem. We also saw the recent article, they've subcontracted a lot of their work to Chase. So here you have civilians adjudicating these cases. I can't say for sure that they're adjudicating EB2 NIWs, but by the RFEs we've received, it wouldn't shock me, because it seems like the person making the decision doesn't even know what the heck they're talking about for the case.
Yeah, it's Rob brings up. So a request for evidence, just for viewers that don't know what that is, that's what USCIS sends to us after they've reviewed our initial submission, our initial visa submission. If they would like to see more evidence about our application, they'll send us a request for evidence. And it is no exaggeration to say that we have seen, I would say, of the RFEs that we see, about 50 to 75%, they literally make no sense. And just like Rob pointed out, grammatical errors throughout, requesting evidence that was included with your initial submission. So on the topic of the AI and RFEs, I totally agree with Rob. And then as far as going back to the leniencies, I also agree with Rob. In our practice, we don't see any leniency. These applications, this visa is a very tough visa to get approved. Thankfully, we've had great success with that. One item maybe that could be considered a leniency is premium processing, and that may have been a leniency early on, but now you ask almost any immigration attorney who's in this area who handles these types of cases, and they will tell you maybe it's not such a good idea to file premium processing, because that's almost like you're putting a target on that application, and it may draw greater scrutiny from USCIS. I would say in our practice we see that more likely than not. Certain applications that are just stellar applications, maybe they could benefit from premium processing. But again, what we see frequently is that premium processing, which could be considered a leniency, wasn't so lenient.
Not only that, I mean, why would you pay $2,800 and probably some extra attorney's fees to do premium processing when your visa category is retrogressed by 11 years? So you're going to get a yes much quicker. People were doing that because of the elections. But now, I mean, we recommend our clients don't even utilize it at all because of the negativity. We think it's like a boogeyman out there that if you use premium processing, you're more likely to get a strong RFE, and they're really going to come at you because it's a war of attrition, right? A lot of people don't respond to the RFE on time, or it's much more work or much more cost. They just go away. So that's just that many less petitions that they have to adjudicate. But if there's no, like, it would be very difficult for me to imagine the benefit of a premium processing especially to an Indian national, a Chinese national, a Mexican national, any of the ones, Philippines, that are very retrogressed. Why do you care when you get your approval? Because you still got a long wait before you can do anything else.
Wow. Okay. As they say, nothing comes easy, and especially, if it is something really good. So I think those EB2 applicants, will really have to buckle up, and maybe they can start binge watching some stress management videos. How about that, Robin Phillip? So, but Philip, I would like to come to you and ask you, but do you think that with this, do you think there will be rush among applicants to file their petitions before, any anticipated policy changes? Because people, especially now that Trump has won, because they are every day thinking that some or the other policy change might happen. So do you think that there will be rush among applicants? And if people are considering that, what advice would you like to give them?
Well, I can tell you that the short answer is yes. And I say that because we've seen that. We have seen a rush in applicants trying to get their applications in before the change in the administration. We have had any number of applications, but also the EB2 and IW. We have people calling us every week, 10 to 15 possibly calling us a week, trying to get this EB2 and IW petition, trying to get it filed. So we do see a rush, and we're seeing a rush from all countries in all areas. People want to come to the U.S. And so what I would advise anyone who is in that position that would want to get their application in before this current administration, I'd say, talk to a lawyer as quickly as possible. Give us or someone else a call. However, be realistic about your timeline, because in all likelihood, the EB2 and IW, because as we've outlined, it is a difficult visa to apply for and come up with all the evidence. So it's not necessarily going to be filed before the new administration begins. So just be realistic about your timeline. And also, again, I know there may be some anxiety out there about the change, but come on, we change every 4 years almost. Whether it's the same political party or not, there's change in the administration every 4 years or so. And we've seen that in our practice, in Rob's employment with the government, in my practice in immigration law, in both of our practices. Change is going to come no matter what. You just have to select a team that is prepared to handle that change.
Right. So I think we are going to see a lot of people more than the attorney's office. They are possibly going to go to the astrologer's offices now, especially for these 4 years. Rob, I would like to come to you and ask you that what do you think? What do you think about the Muslim majority countries? How are people dealing from those countries? And are you also getting calls from those countries? Because Trump with Project 2025, I mean, Trump and his administration are thinking of putting a ban in the Muslim majority countries, travel ban. So, if you can please tell us about that too.
Yeah, I mean, we haven't seen a lot of that in our practice. I've seen zero. We both take calls and we usually interview the clients together. So we really haven't seen that as an impact at all. We have many clients from Muslim countries, and it's like the boogeyman effect. It's like that's something that may never happen. Maybe it will happen. If you're that afraid of it happening, then get in. Let's get your case filed and go. But I can't predict with any certainty that that's going to happen again.
Yeah, we don't. On the topic of the boogeyman approach, we cannot advise our clients based that are rooted in fear. Right? We try not to use fear. We do not use fear to influence the way we handle our practice. Again, change comes every 4 years, and sometimes faster, depending on what the judicial system is doing and what new case law is coming out. I mean, really, as Rob mentioned, we're members of the American Immigration Lawyers Association. Mm-hmm. It's over 1,000 immigration lawyers across the United States. And we are on listservs and distribution channels and emails. And so we follow this all day, every day. And I mean, new cases come out every day. Every week you get 3 or 4 or 5 new cases that change the law. I think the judicial system, it's on its track. It's going the way it's going to go. And I don't think that there's necessarily major influences on who's in charge.
Okay. Thank you so much again for answering the question, Rob and Philip. Now, I would like to come to you again, Rob, and I would like to ask from you, given the historical context of, the heightened security scrutiny during Trump's first term. So do you anticipate that the USCIS will revert to a more stringent interpretation of national interest? And if so, what evidences might applicants need to provide to counteract this?
Well, I sure hope they don't get any more strict than they already are, because they're at a pretty high level, and Trump's not even in office, and they've been at that level all year this year. So, like I said, the strategy is you have to have a strong business plan. So you need a professional business planner, right? And they're going to take all of your strengths and all of your history, and then articulate the national interest. But now we can't just say, okay, great, this person is in cybersecurity and has a good professional background. This is a national interest. We're getting hacked by Iran and China and North Korea. So that's a good match. Now we have to show this person is cybersecurity. The first 3 months they're going to do this to implement it. The second second quarter of the year, they're going to tie into these certain key areas of the economy or of the national landscape, and then these are going to be the results, right? So you really have to, more than ever before, for national interest, just lay down a crumb trail, paint a picture exactly how what you're going to do is going to help each aspect. It's very easy to articulate a national interest, but the way that they're saying national interest now is show me how your person is going to hit that national interest. It doesn't matter that, we've had the Panama Canal problems and problems in the Suez Canal. I want to know how your naval engineer is going to actually fix those problems. So then you've gone from just saying, hey, I've got a great naval engineer and I've got a great there's huge problems that are causing supply chain worldwide, massive damage. Now you got to say, this is what my naval engineer is going to do. He's going to go over to XYZ spot, address, ABC issue. It's going to result in DEF result. I mean, it's a lot more work and a lot more intensity. And quite actually, as a law firm, we have to raise our rates a little bit to correspond with the amount of time that we're having to put in these. I mean, because these are getting to be, much more intense cases than they were before already. Again, my hope in 25 is that what we're presuming is going to happen is going to actually be the opposite. I want to see, like with Elon Musk involved and the emphasis on STEM, that they're going to be seeing, hey, this candidate's great. We know what the national interest is. Approve this, this petition. I can't say that's going to happen. Those are my hopes, but it sure as heck can't get much harder than it is right now. And we're under Biden. We're under the Democratic Party. This year has been awful for national interest. So, I don't see how it gets much harder than it's been. Philip might have a different opinion, but
no, I agree. I think what we're seeing with national interest and heightened scrutiny has been coming down the pipe for a while now. And what we see is a focus more on immediate economic and job impact rather than long-term contributions. So part of the question was, what key evidence can we provide? Well, some key evidence is we need to have a quantifiable economic impact. What I mean there is we need to show the job creation, the impact, the benefit to the GDP. We also need to show that our applicants that they have industry recognition and they have endorsements within their industry. And we need to show specific examples of how their work aligns with the U.S. priorities, which we see as going more toward infrastructure and other critical industries like healthcare, like technology. That is some of the key evidence that we will have to show to show that these applicants will contribute to the U.S. national interest.
One more thing I want to interject, Raji, is that we've kind of taken a tact on our EB2 and IW cases, treating them almost as if they're EB5s. So we like to see at least 10 direct job creations under the business plan. And then we also want to show at least some significant impact on what's called the TEA type zones, the high unemployment, rural, those areas, because those are what, in the government's mind, those are, kind of policies that they want to address. We're trying to use that mindset from over here in the EB5 world, implement that into our EB2 and IW cases to kind of make that extra link on the national interest. Say, hey, not only is our person going to do XYZ resulting in DEF, but look, they're also going to create 15 jobs, 20 jobs, direct jobs, which will result in a downstream of 75 jobs, and they're going to help rural or economically disadvantaged or high unemployment areas in this way too. So we're just kind of having to try to get sophisticated, a little more sophisticated, and change the way we think about and approach these cases to kind of try to outthink the adjudicator, if you will. I don't know. It's, if you try the same thing and get the same result, then that makes no sense, right? We want to get ahead of the game.
Okay. Well, thank you for the answer, Rob and Philip. And Rob, you mentioned Elon. So I really hope that, he actually takes the national interest to the next level, but doesn't dodge it.
There's things that need to be dodged, Raji. Believe me, I was inside the belly. That could be helpful to us in our interest and your clients' interest. So anyway.
Yeah, that could also happen. So, but Philip, I would like to come to you, and I would like to ask you. But what about the applicants? In the fields outside STEMs, like maybe arts or social sciences. How can they stand in their case to potentially the stricter definition?
Sure. Well, so applicants that are in the STEM fields, if we're thinking more, which I think USCIS and immigration law on a whole is going toward more of a merit-based system. We know we're pretty certain that under the Trump administration, it's going to be more merit-based. And so taking that into account, and taking into account the effect that that might have on applicants that are in the arts or the education or social sciences, I think what we need to do is we need to have a clear, measurable benefit to the U.S. interests. We need to show evidence of these applicants' exceptional ability, and we need to show their national awards, their publications, their broad societal impact, how they're going to help the U.S. national interest. And so really the analysis is the same as any, STEM versus non-STEM, but we may just have to go deeper. As Rob mentioned, a key part is preparing this case as if we're applying for the big EB5 visa. And for anyone who doesn't know what that is, that's the big investor visa where an applicant needs to invest a minimum of $800,000 and needs to provide or create at least 10 U.S. jobs. That's a high threshold. And so I think part of the success that we've had with the EB1A petitions is that we take that framework and we try to apply it to these applications that have a lower threshold. But if we can hit that higher threshold, then that's great. And I think that's part of why we've had, and not just us, other immigration attorneys have been doing the same thing. But that's how we would show that a non-STEM applicant can contribute to the U.S. national interest and be successful with an EB2NIW petition.
But so, like, if you had somebody in the arts and social sciences, you just got to think, okay, what's a major problem? All these wars we've had in Afghanistan, all these soldiers that we've had come back with PTSD, part of their plan is going to be, we are going to go out into the veterans community and help kind of, rehabilitate and I don't know what the word is I'm grasping for, but kind of ease the pain of these soldiers through the use of our art program or our social
basically like coping mechanisms.
Social sciences, yeah. Sciences, yeah. So you got to think about how you're going to tie what would otherwise be, hey, this is just a great artist, this will improve our culture. If it was me, I would say, yeah, we're going to do that. But they're also, like, I'm just making this up, we're also going to help all the veterans with PTSD because we're going to go out to them, do outreach to them as a way to help them ease and recover, from the pain, mental pain that they have still from being in war.
Yeah. Mm-hmm.
Gotta get creative.
Mm-hmm. Yes, Rob, you were saying.
You have to be creative. You're just going to have to get very creative in those specific areas. It's not going to be good enough, I don't think, just to say, oh, I'm great at social sciences or great at art. You got to think about doing some other things and tying in some other aspects that you normally wouldn't do, but that are important to the Trump administration.
Right. Okay, thank you so much for that insightful answer. Well, we really hope that national interest, doesn't become, whatever that makes USCIS less bored today. It doesn't change to that because, that also happens, right? So thank you so much for that insightful and detailed answer, Rob and Philip. Now, a lot of people are actually posting their questions. So before I take my questions, how about if we move to the viewers' question?
Sure, whatever. It's your show. You tell us what you want to do.
Thank you so much. Okay, Andre is here and he says, I am Brazilian, and he says hello from Brazil, and he says this rule is not God or good. I'm not sure what he means by that, but
it's not.
Okay, let's take Asim's question maybe. So Asim says, one of my friends applied for an EB2 NIW visa last year and got denied. He's now thinking of applying again, but the process seems more complicated with the new guidelines. Do you think the new rules are making it harder to qualify? And if so, what different should be done to qualify? Rob, let's start with you.
Well, like we said before, Andre, the rules haven't changed. The way you approach the rules, you may need to change your approach because you don't see it. Your Brazilian friend doesn't see it because they just were a one-shot player, right? They just came up to the plate, they swung 3 times, and they struck out. You can retool those same cases, but use a firm like Rajni's or us or whoever you want to hire and rethink as to how they're being adjudicated now. What can we change differently? What can we change in your business plan? What can we emphasize more? And what different national interests can we try to hit and link to in a different way and maybe amplify the impact of your proposed endeavor so that you will be successful this time? Resubmitting it the same way you did it last time, you're going to get the same result, right? But the rules have not changed. The way they're implementing the rules have changed. So you got to stay current with that. You got to stay in the mind of USCIS. You have to stay, have your pulse, your thumb on the pulse of how they're adjudicating, not just your cases, not just Robin Phillips' cases, but the whole nation's cases. Mm-hmm. And it's not something that a layperson would know because they're just, just throwing it in there.
Yeah. We've got to. I agree with Rob. The guidelines haven't necessarily changed. The bar has moved a little bit higher, but again, EB2 NIW is not an easy visa to qualify for. Yeah. We often tell our clients that it is a superhero visa. We need to show how they are going to be a superhero to the U.S. interests. Mm-hmm. And so, if it didn't work the first time, that's okay. We wouldn't discourage you from trying again if you can do it in a creative way where you can really bring to the forefront and highlight your experience, your knowledge, your record of exceptional ability.
Okay. Thank you so much for that great answer, Robin Phillip. Asim, I hope you have got your answer. In case you're looking for a follow-up, continue posting it in the comments below. Meanwhile, let me quickly take Sanjay's question too. Sanjay says, I have been told that supporting documentation plays a crucial role in the EB2 NIW process. Has the evidence required changed with the recent updates from USCIS? And if so, what kind of documentation is now essential? Philip, would you like to answer it?
Sure. I think documentation and providing the key evidentiary documents is key. It is key to an EB2 NIW application. And the biggest one is a professional business plan, a business plan that outlines every single aspect of the applicant's proposed endeavor. We need to show that they will contribute to the national interest of the U.S., that they will have a substantial impact, that they are that they're well placed to follow through and execute their endeavor. Okay, so a business plan is key, and maybe not stop there. In several of our cases, what we've done is, sure, it's a requirement. Any client that we work with, it is a requirement that they submit a professional business plan that is prepared by an independent company who looks at our applicant's record, CV, and is able to interpret that is able to create a professional business plan based on that record. However, again, we don't necessarily need to stop there. We can provide expert opinions. So in several cases, we have gone out and looked for U.S. experts on the particular industry or topic that the applicant would like to apply based on, and have those experts explain how the proposed endeavor would impact the U.S. national interest, how it would improve, how it would bring significant benefit to the U.S. interest.
Yeah, the average, to answer your question on paper, our average filings in these cases are minimum 500 pages up to 700, 900 pages. Okay, so yeah, documentation is important. There's critical pieces that Philip's already mentioned. Number one is the business plan. Number two is if you're advanced degree, obviously you have to show that. If you're not advanced degree and you're going for exceptional ability, you're going to have a ton of documentation to prove up because you're going to have to hit 3 of the 7 requirements, and you're going to have to do those through letters of reference, from colleagues or people highly positioned within the government, business, or academic sectors, as high up as they can. But they got to know you. They got to know your past accomplishments and what were the outcomes of your efforts, and then also give a really strong prognosis of your future, your potential, your potential energy, so to speak, because these aren't letters of you should give XYZ a job because they're a great person. No, these are letters of hyperbole, like to the maximum. This is the best person I've ever known. They resolved all these problems for this industry. It had an impact on the actual industry overall. And wow, what a great day when they become a U.S. resident, because they have the potential to take their proposed endeavor, shoot it to the moon. So yes, minimum business plan, letters of recommendation, and then all your paperwork you need to back up either your extraordinary ability or just your master's or PhD or your bachelor's plus 5 years advancing professionally in your area. And the thing I like about the expert opinion letters, those are kind of silver bullets. I mean, that doesn't mean you're going to win because of it, but they are very impactful because they are from industry experts in your area of expertise, totally independent. They don't even know this person. They're just reviewing the record and writing a professional opinion. Many times the CVs that they attach to theirs are like 20 or 30 pages long themselves for that particular expert. So, I mean, these are heavy hitters. The other thing I want to tell you is expect an RFE. You're going to get an RFE on everything. Oh my goodness, I got an RFE. I have a horrible case. I thought you guys said I have a strong case. That's not what they're doing. They're beating you down by attrition. So don't give them all up front, right? One of the strategies is to just hold back a little in anticipation of the RFE, because then when they bring the RFE, you still have some bullets in your gun that you can fire at the RFE, plus maybe go to some of these extraneous sources like an expert opinion letter.
Okay. Thank you so much for that answer, Rob and Philip. So no nepotism. It will all depend on the skills and right. So Sanjay, I hope you have got your answer. So make sure that you have all those documents ready that were mentioned by Rob and Philip, and you have to keep in mind that the nepotism will not work, especially not anymore. And yes, Rob is nodding. He is completely against it, right, Rob? Especially with the EB1A visas.
If you're talking nepotism as far as like reference letter, hey, if you can get a reference letter from Trump, you get that reference letter. We've had cases where we've gotten reference letters from presidents of other countries for the national of that country. So don't shy away from that. But it can't be just, hey, this is my niece or nephew, let them in. They got to know your professional abilities, your professional history, and your potential. So they got to speak professionally to that. It can't just be, well, Raji's a great person, so she should really be a resident. It's got to have some depth and substance to it.
Absolutely. And I think that's the reason why President Trump also endorsed, he said now if you are skillful and if you are adding to the US's economy, you will be eligible to get the green cards. And no longer because you are applying and because you are in the wait lines, you'll be able to get the green cards. Only you are skillful, and if you are, getting graduated from the good universities of the United States of America, you'll be eligible to get the green cards. Is that why he also endorsed that, Rob?
Yeah, I believe so. I think, I mean, I just read an article, it was a Politico, right? Which is no friend of Trump or anybody on the right.
Right.
Yeah, so far left article basically saying, look, they are going to be looking for people with skill sets, especially in STEM. And sorry, I got a little off track. What was the question? Rajni, what was it?
No, even I forgot. I was too invested in your answer. Even I forgot what I was asking. But I was actually, is that the reason why actually Trump endorsed, the skills?
More of a merit-based system. And in reality, I'll let you go ahead and finish your talk on the article.
Yeah. So the article was saying, look, Trump is an Indian national's best friend because they have the skills. They have the intelligence. They're going to bring, they're going to bring the heat on the areas that he wants. They anticipated the biggest pushback is maybe a problem with Congress getting heat from their constituents because we've had so many problems in the U.S. with irregular immigration that I think people kind of got fed up with immigration and lumped it all together, whether it's legal or irregular. And so Congress might be more of a problem than Trump and his cabinet. But yeah.
And the thing with the merits-based system is, I think the benefit that I see to the way it's being laid out, or we anticipated it will be laid out, and how it was laid out during Trump's first administration is, I believe we're dealing with the merit-based immigration system as is. At least under the administration, is they're giving you the guidebook, they're giving you the blueprint. Here are the 10 items that we're focusing on, and here's how you can qualify under each of those 10 items. Whereas to me, it may be a little bit more laid out, a little bit more transparent versus what USCIS may have been doing in the past, where it seems more discretionary, right? So if it's more discretionary and USCIS decides, well, we'll put more weight on this one item versus this other item, a merit-based system that is clear, that is transparent, could do a lot of good for visa applicants who do qualify, as Rob mentioned.
It might be bad for us as attorneys because it won't be as complicated, but I think it's much better for the clients.
Yes,
because they maybe just have a scorecard, right? And I don't know. I think it's going to be good for a lot of people groups around the world. Others not so much, but for certain people groups, definitely.
And of course, and that's how it should be, right? If you have those skills, and if you are a merit-based person, and you should be eligible to get the green cards, and if you're adding to the US's economy, you should be eligible, to get the green cards. Whereas, but then, talking about Trump, that's a whole another conversation, because then what he sometimes says, then his actions are, complete against what he's saying, because, he wants to have the merit-based system for the immigrants. But then coming to his own team, he's picking Linda McMahon as the Secretary of Education Department. So, I mean, that's a little controversial, right? Robin, Philip, I mean, I know that's a conversation for...
Rajni. He's a non-traditional politician, but still a politician at the end of the day.
True.
I won't defend him on that, but I do like Kash Patel and Vivek. I'm not gonna apologize for that.
Well, even I not just Kash Patel and Vivek Ramaswamy, but even Tulsi Gabbard and then Stephen Miller and then Tom Hooman as the border czar. I think those are some great picks, right? Whether you agree with his policies or if you disagree with what he says, but then some of his candidates are really amazing. And yeah, thank you so much, Rob and Philip. But I would again like to maybe take a few more questions. Hari is here and he has posted a question from LinkedIn. He says, I'm eligible to apply for okay, this is actually for an H4 EAD. So would you like to take this?
No, we really shy away from giving case-specific advice to a non-client for ethical reasons. We don't know the facts behind their. If you want to speak generalities, it's fine, but maybe this one's not the greatest one. Yeah.
So maybe, Hari, what you can do is the details of Rob and Philip are scrolling below. You can directly, if you want to get in touch with them, you can get in touch with them, discuss your case with them. And yes, I'm more than happy to help you out, and you can, directly write to them. And let's quickly take Madhavi's question. Madhavi says, can you analyze the recent USCIS policy changes and court decisions impacting EB2 and IW visas and provide specific examples of how these changes have affected the approval rates and processing times for NIW petitions?
Well, I'll start. So sure, as far as the new cases, I mean, and so the biggest case that we've seen come out with EB2 NIW is the matter of Danisar case. That's what provided the three prongs that we've been discussing all along that gave it a more streamlined approach to the pre-Danisar era, which was guided by another case, New York State Department of Transportation, which that required, it was a little bit tougher under that standard because what it required was proof of national scope and specific labor market unavailability. That was challenging for many applicants. And so what Danisar did in 2016 is it now focuses more on substantial merit and national importance. So we were talking about work by an applicant that it has inherent value and can be important to the U.S. interests. So what we've seen is a shift from the focus of market unavailability to the applicant's unique contributions to the U.S. And how I think that has affected the EB2 and IW petitions is it has like we were talking about with a merit-based system, it is laid out. Now you have a playbook with specific guidance as to how you can meet those requirements and have a successful visa application. And what we've seen is there has been an increase in the rates of approval. It's still a tough visa, but we think now we have a clear standard under which to apply.
As far as the court decisions that was mentioned in the last question, one thing that I see all the time on our distros, one thing to keep in mind, the NIW piece is completely discretionary. Completely discretionary. You cannot challenge that in federal district court, the U.S. Supreme Court, whatever. You will get knocked out at the knees immediately on a motion to dismiss your case. So if you lose your EB2 NIW case and you want to fight them in court, for wrongfully denying your case, and if they made that decision based under the NIW piece, it's a loser case, we call it. So if there was other key legal factors in the EB2 qualification part, you may have a case to go forward. But the NIW piece itself, I mean, it's in the adjudicator's hands. I don't remember the name of the case, but there was a recent case that came out speaking to vice consul, the inviolability. I always have trouble saying that word. It's inviolable. Inviolable. You can't violate the vice consular's decision, right? They're the judge, jury, and executioner in let's just call it the B1, B2 context, but really in the adjudicating consular process cases. This recent case that came out totally strengthened that position. Before, there was a lot more challenges you can make to the consular decision, the vice consular decision-making process. But now they've been narrowed down tremendously, which was weird because just before that, there was a case coming out limiting the Chevron case, limiting the administrative ability of agencies to basically legislate upon, us.
Mhm.
So, but since we're specifically talking about this concept, the cases are against any type of appeal to a district court in a federal lawsuit context.
Yeah.
It'd just be a refile would be your
Yeah, and just to add to part of the question was how has it affected processing times? We've seen shorter processing times in general for EB2 and IW. As a matter of fact, right now, as of this morning, we're looking at 10 to 13 months processing time for the Form I-140 for an EB2 and IW case. And then, of course, you think if you do premium processing, which we've discussed some pros and cons about that, then you're looking to a shorter time period of 15 days. So what Datasart has done is it's created a clearer path to the EB2 and IW visa.
Mm-hmm.
If there's one thing I can add to, when we file our cases, we always put for consular processing, even though we hope we don't have to, because you can always adjust status even if you put consular processing on the petition. All you have to have is your receipt number for the approved petition. And if you have a legal way to stay in the U.S. And your case and your category is current, then you can adjust status from within the U.S. If you have to run the gauntlet of consular processing, you're basically going to get re-adjudicated again by the vice consul. You already got adjudicated by the USCIS officer. But that's not the biggest issue. The biggest issue is got to run through NVC first in Washington. There's going to be administratively a couple months to get you documentally qualified. And then they just wait. And they wait for post to have an interview available for you. We have cases that have been ready for interviews since September 2023 and still have not had an interview date yet in that country. And I don't know what the case is in India at the embassies or consulates there, but in general, I think they're taking low priority on scheduling interviews versus the relative family member immigrant visa, which is means the most to Congress because that's the people that vote for them.
Right. Okay. Thank you so much again, Rob and Philip, for answering the question. Let me quickly take Trisha's question because she has also posted one question over here. She says, I'm considering submitting a waiver of job offer for the EB2 and IW visa, but I'm uncertain about how USCIS is viewing these types of cases under the new guidelines. Can you explain how they assess the waiver and what strategies might help to improve the approval odds in this area? Philip, let's start with you.
Sure. Well, with the NIW, of course, as we know, the benefit of applying for EB2 NIW is to waive the job offer, going through the perm process, which is, time consuming, a little bit, more expensive. So what we have to do is we have to show why it's in the best interest, why it's in the national interest to waive the job offer. And explanations of how the way we do that is we need to show that waiting for the job offer is not feasible or practical for this particular endeavor, for the proposed endeavor. We need to show that the applicant's skills and expertise, that they're highly specialized and they're not readily available in the U.S. workforce. That's another way to do it. And finally, a third example is we have to explain how waiving the job offer would accelerate the project's progress. If you make this applicant wait the 2 to 3 years, you're delaying this really important work that they can do in the U.S. So if you waive that job offer, what you're doing is you're accelerating that progress. You're accelerating the benefits that this applicant is going to bring to the U.S.
One other thing along that line on the whether or not it'd be in the best interest of the U.S. to waive the labor cert is to hit if you have a case where it's impracticable, like say this person, if they take a job offer at a certain place in this industry, will have a non-compete clause automatically because that's the industry standard. So they won't be able to benefit the industry as a whole. They will be pigeonholed into one specific employer, which will not help the national interest. So therefore, it's in the U.S. best interest to waive the labor cert. Or this person holds a patent on a widget that, it's impracticable because they own the patent, on the widget, and, no one else is going to get it. So let's bring them in and let's get them started and let's get them helping the U.S. Thrive.
Okay. So, Trisha, thank you so much for your question. I hope you have got your answer. Now, Rob and Philip, there are a few questions posted in a Facebook group by our viewers. So, if you don't mind, can I share my screen and maybe take some of the questions from there?
Sure.
Great. Thank you so much. Okay, I'm quickly sharing my screen. Okay, can you see the screen? Okay, so this person, I think Javier, has posted that he says, I'm a Spanish teacher. I have applied for EB3 and NIW I-140. Does anybody know if there is any possibility to be approved? What would you like to say?
I would say no, because there's no such thing as an EB3 NIW.
EB3. EB3. Yeah, we assume she meant. I'm going to assume she means EB2 NIW, and we like to say that no case is impossible, right? We would need more details, but speaking hypothetically, a Spanish teacher isn't automatically ruled out from an EB2 NIW. However, what we discussed earlier, you've got to be creative. We've got to show what experience does she have? How would she benefit the U.S.? In the U.S. here, we're dealing with an ever-increasing Hispanic population, right? And unfortunately, sometimes a lot of the Hispanic population is in underserved communities where someone like the caller, the questioner there, could potentially benefit the community. We have to show how does her experience as a Spanish teacher improve the U.S. economy, U.S. national interest. So again, we don't like to say any case is impossible. That could potentially be a tough case, but it's not impossible.
Yeah, I think if she's got especially if she can hit the advanced degree portion, I think with some creativity and a good business planner, you can easily weave that into a strong national interest argument because of the just like Philip said, the segment of our country right now of the Latino segment is humongous. Yeah.
Or maybe having the right attorney might help in cases like these, right?
Sure, that is key. Having the right legal team at your side to help you navigate something that complicated.
Right.
Yeah.
So,
sorry.
No, please go ahead, Rob.
Identify the need and then connect the dots. That's what you got to do. Identify the national interest and then connect the dots in the proposed endeavor. It's just very explicit, and I that one alone, I think I could come up with about 35 different ways that we could make a strong argument on her behalf.
Well, Javier, if you're looking for an attorney for yourself, maybe get in touch with Rob and Philip. The details are scrolling below, so you can note them down. And we are also going to, I'm also going to read out the details for you. So if you are looking to get in touch with Rob, you can give him a call on the number 512-293-3023. I would like to repeat the number, 512-293-3023. You can also email him. His email ID is robmelvin@melvinlawgroup.com. robmelvin@melvinlawgroup.com, and his website is www.melvinlawgroup.com. And if you're looking to get in touch with Philip, you can give him a call on the number, which is 979-776-1325. I would again like to repeat the number, 979-776-1325. 1325. You can also email him. His email ID is Philip, PHILIP at dosrodlaw.com. Yes, and you can also visit Philip's website, which is www.philiprodlaw.com. So make sure to get in touch with Rob and Philip. They'll be able to help you with your case. I know it will be a little complicated and a little tough in comparison to others, like Rob and Philip mentioned, but they are the experts and they are surely going to help you. Thank you so much.
Just to let your viewers know, Rajni, both of those telephone numbers for Philip and I are also WhatsApp numbers. So if you have any WhatsApp users out there, they can send WhatsApp messages through those channels.
Well, perfect. What's better than that? Rob and Philip are just a WhatsApp message away, guys. So get in touch with them right now. Right. And also, I have one question which was actually posted 2 hours back, and it is from a girl named Kripa. And she says, I have an approved I-140. I'm waiting to file my I-485. My current employer told me that they won't file my I-485. Can I change my employer for I-485?
Well, Kripa, it's not clear what visa you're talking about there, unfortunately. Because what we're discussing is an EB1A visa, which does not require an employer. So maybe some clarification would be helpful. As Rajni mentioned, if you'd like to, you can reach out to us, offline, and we can get some more information about your particular situation and do our best to answer your question.
Perfect. Let me take one last. Rob, Tamar says, does the premium processing affects the approval percent in the EB2? What do you have to say?
Back when I was young, it was the $64,000 question. Now it's the $64 billion question, right? Depends who you ask. I know some very well-seasoned attorneys, immigration attorneys, that have done tons of EB2 NIWs. They say premium processing is the biggest joke, the biggest waste of time, and it's just a throwaway of money. I know others that say it will actually prejudice you because you're putting heat on them. Remember, these are bureaucrats. I was a bureaucrat. You want to do the least amount of work that you can to get the day over so you can draw your check and build your pension. These are not go-getters. If they can kick you back an RFE in a premium processing case, and then kick the can down the road, it's probably what's going to happen. I can't say it with 100% certainty that it will prejudice you. I've heard others speculate that it will. My opinion is they're worthless because of the retrogression. So why, unless there's some insane pressing need to know the answer in 45 days that I would be glad to discuss with anybody offline. We try to talk our clients out of using it. Some people were so afraid of Trump winning that they insisted we used it. We used it, and they had to go through all the same stuff that anybody else had to go through. Thank goodness they were approved.
Yeah, and let's think about what premium processing does. What Rob mentioned is USCIS. You can't blame them. They've got a lot of work on their desks. And what we're asking them to do with premium processing is cutting down a 10 to 13 month process into less than 45 days, 15 to 45 days. You've got to think about what that does. If we had a project that normally takes 10 to 13 months and we had to cut down to that short period of time, they may have a lot of questions. And so what that may lead to is a request for evidence. So again, you're going to get a different answer based on who you ask, which immigration lawyer you ask. But yes, in some cases, maybe premium processing is the way to go. But what we have seen is in the majority of cases, it may not be the value that people think it is.
In that vein, of all the comments I've heard on premium processing, and I've heard hundreds, if not thousands, I have never heard somebody jumping up and down saying, yay, I'm so glad I chose premium processing because it was wonderful, and it was so beneficial to me. Not once.
But Rob and Philip, people are so scared of RFEs. As soon as they get the RFE, they panic and go into that chaotic zone and chaotic mode. So but RFEs can sometimes also be helpful for their cases, right? So in situations like this, how should they deal with? I mean, what should they do, and how should they deal with that?
As Rob mentioned early on, you go into, and we always explain this to our clients, potential clients early on, you have to go into it expecting an RFE, right? What we're proposing for our clients oftentimes is a very complicated endeavor. They're highly specialized, they're highly skilled. So there are going to be questions about the process. So we tell our clients an RFE is probably going to come, just expect it. What we do is we're going to be ready with additional evidence if we need it. For example, Rob mentioned the expert letters earlier. Those aren't required in the initial submission. They're not required. The business plan in most cases is sufficient. So sometimes some clients, in order to preserve resources from the initial submission, may say, let's not submit the expert letters right now. Let's submit the business plan. Let's submit the best initial submission we can. And if and when we get the anticipated request for evidence, well, then we provide that additional evidence. Like Rob mentioned, we keep a little bit back just so that we can respond effectively to a request for evidence and provide a clearer picture to USCIS of what our client is trying to do. So again, the takeaway is, in this visa category, a request for evidence is likely to come. Just be aware of that up front so that you're not surprised by it when you get it.
The only case that I can remember us having where there was no RFE was the proposed endeavor had a direct impact on the amount of filing fee income generated to USCIS at an exponentially humongous amount. For some reason, that case sailed right on through without any RFE. It was amazing.
Yeah.
Well, I think that's a great way to actually put it. You should go with the expectation that you will get an RFE. I mean, expect the worst and you will never be disappointed, how they say it, right? But thank you so much, Rob and Philip. It was so great having you both on our channel and on our show, Immigration and Jobs Talk Show. We had an amazing show. We were actually supposed to have this for an hour, but we actually did it for an hour and a half and we didn't even realize it. So thank you so much for being here. And even after doing it for so long, we couldn't even cover half of the questions that we actually planned for you. So maybe how about we do another episode on the same topic and we get into the depth of it.
Anytime.
Perfect. So guys, if you're looking to get in touch with Philip, you can give him a call on the number 979-776-1325. His email is philip@dosrodlaw.com. His website is www.philiprodlaw.com. So make sure you give him a call, WhatsApp him, email him, and also check out his website. And if you're looking to get in touch with Rob, you can give him a call on the number 512-293-3023. His email is robmelvin@melvinlawgroup.com and his website is www.melvinlawgroup.com. So make sure to get in touch with the both of them. And like they said, their numbers are also available on WhatsApp. So make sure that you also send them a text on their WhatsApp numbers. They are just a text away. So again, thank you so much, Rob and Philip, for being here. Any closing note from the both of you?
No, thank you very much for having us on. It's been a pleasure. It's an honor to be on this show. We know you have a lot of viewers. We know that your show is putting out a lot of good information to all of your viewers, and we're honored to be a part of it.
My only thing to say is, India, keep your chin up. It can only get better, and I think it's going to get better for you. I think you have a lot more people in your corner than you think you have, and I am very hopeful for you, not only just in the EB2 NIW category, but also hopefully bringing down the retrogression numbers and the weight that you have for your visas or your adjustments of status. So keep your chin up. Let's keep in there. Let's keep fighting. And we're here to help you out.
Thank you so much. Thank you so much to the both of you. Can't wait for the both of you to be back on the show with our next episode. And thank you so much again for being here. You both have a great day ahead.
You too.
Thanks. You as well.
Ciao. Thank you.
Guys, thank you so much for tuning in, and thank you so much for posting those amazing questions in the comments below. You can continue posting them whenever Rob and Philip are going to be back. Maybe we can take those questions and ask them in the second episode, or whenever they are back for the next episode, or maybe we can get in touch with them, write to them and get a reply from them, and we will post the reply in the comments below. So you make sure that you are continuously posting your question in the comments below. But for now, I'll have to take your leave. But you make sure that you are always tuned in to Immigration and Jobs Talk Show. So stay tuned with Immigration and Jobs Talk Show for every immigration update. I'm Rajni Bharara, your host, signing off for now. I'll see you very soon. Bye. Keep watching and keep subscribing.
Bye-bye.
Bye. Hi everyone, welcome to Immigration and Jobs Talk Show. I'm your host Rajni Bharara, and before I move ahead, let me read out this very important disclaimer. By watching our videos, you agree and understand that the information provided by our attorneys and guests, including comments and replies from users, is not legal advice. Use of information is at your own risk. Welcome back, everyone, to Immigration and Jobs Talk Show. Like I said, I'm your host, Rajni Bharara, and today we are here to discuss the latest trends and insights in immigration law and employment opportunities. Well, I'm thrilled to have you all join us with us today, and I want to again extend a heartfelt welcome to all of our viewers today. Thank you for joining us. Your interest in these important topics is what makes this show very, very special. So thank you again. And today we have a very special guest joining us, Erin Green, an esteemed immigration attorney and an H1B visa expert. Erin brings over 20 years of corporate management experience, working with clients ranging from venture startups to large multinational corporations. He is the founder of EEG Immigration Law Group, where he provides exceptional legal services and strategic solutions for complex corporate immigration issues. Erin has a remarkable track record, having overseen thousands of immigration petitions for high-tech, defense, and biotech companies. He has served as the exclusive U.S. immigration advisor to the American-Israeli Chamber of Commerce and has extensive relationships with Department of State officials representing corporate clients at the U.S. Embassy in Tel Aviv. In addition to his legal practice, Erin is a passionate educator, frequently delivering presentations on immigration processes and compliance to large audience across the country. His commitment to transparent service and dedication to his clients truly sets him apart in this field. Today, we'll be diving into an important topic, H1B visas, current trends, fraud crackdowns, and what to expect next with none other than Erin Green. We'll explore the latest developments in H1B visa sponsorship, discuss the recent crackdowns on fraud within the system, and look ahead to what applicants can expect in the upcoming year 2025. So without any further ado, let's welcome Erin Green to the show, everyone. Erin, welcome to Immigration and Jobs Talk Show. How are you doing?
Hey, good to be here. Doing good. Thank you.
Thank you so much. It's a pleasure having you on the show, Erin. Thank you for agreeing to be a part of the show. And guys, we have Erin's details displayed on screen in case you want to write it down. So you can write down his phone number, his email, and his website in case you want to get in touch with him. So make sure you do that. Now, Erin, without any further ado, I know we are here to talk about H1B, but before I do that, I actually want to talk to you about, the picks of Trump's administration. I mean, the picks that Trump has had in past few days of in the last 1 month for his administration. So, Erin, how do you anticipate these appointments are going to influence immigration policy, and particularly regarding H1B visa?
I think the new administration will be very strong on the border, on preventing the mass illegal waves of immigrants coming in. That's the focus. That's what he ran on. That's the people he's putting in place. Mr. Holman and all these others are going to be focused on that. What we have right now is a free, open border on our Mexican side where anyone can just walk in. I'm completely against the asylum scam that is going on and the ways that the last or the current administration has ignored immigration law to levels that are just unexplainable. For those of you who don't know, asylum means you're in a country, but you have to get out, you have to flee, you're in fear of your life, the government's going to come and kill you or cause harm to you. And if you can get to the next closest country, you're supposed to file an asylum claim and be there until your case is heard. Unfortunately, while we do have a lot of poor people coming from these countries that just want to work, they do not qualify for asylum. And asylum was not created for someone who just happens to need a job or to be poor or maybe lower class. But what they've done the last 4 years, and even before that, they've allowed these folks to come in illegally using this asylum. It's a big scam, and the government's perpetrating it. So to get back to your point, I think most of the efforts will be on securing a border, like every country needs, allowing people to come in legally, allowing real asylum claims to be heard, and hopefully not allowing millions and millions of these phony asylum claims to be perpetuated. With regard to the H1B and the business community, I happen to think that Trump is a businessman. People working with him are looking to increase the economy. The economy has been down the last 4 years. We've had inflation. We've had a lot of problems. So on the business side, I expect things to get better, get smoother. Hopefully wait times will go down. And we'll see better processing and intakes of cases. And those are some of the things I'm looking forward to. There's a lot of fear mongering out there done by whether it's law firms or just particular political interests who always want to fear monger and hope for the worst. But we don't see any evidence of that. For what we see so far is a business-friendly administration like we saw last time.
Okay. But Erin, a lot of people are also saying that it's not only going to Trump and his administration are not only going to go after the legal ones, the illegal ones, but also it's going to be bad for the legal ones and strict scrutiny. And, basically, it's not going to be good, not just for the illegal ones, but also for the legal ones too. So what do you have to say about this? Do you think it's going to be hard or bad for the legal immigrants too?
I don't think so. I don't think. We've seen 4 years of this administration. In my firm, we processed thousands of H1Bs. Certainly, where they're stricter on, for example, third-party client-side cases, and then it goes back. We've seen trends where there's more RFEs, and then less RFEs, and then more RFEs, and then RFEs targeted. We see them coming in trends. But the trends don't really correlate with the administration that's in power. It doesn't matter. It seems like they are more internal, and they just seem to adjudicate in different ways in trends. So if you're talking about H1B adjudications, it's hard to predict what the next trend will be. I mean, for example, I can tell you 20 years ago when we used to do L1s, L1As, and L1Bs. L1As would never get an RFE. They were so straightforward. For example, if you flash forward 12 to 15 years, you have them starting to RFE L1s as a trend, and L1As particularly. And so there's nothing correlating with the law or changes in law or changes in administration. It just seems to be internal trends that seem to come up and down, with what we see in our data. But I don't predict any stiff change where they're going to say, oh, we're not accepting H1Bs. They can't do that. I don't see how they would do that or why they would do that. That would just harm the business community.
Okay. But do you expect any changes in the H1B lottery process with the new administration?
So to give you a little bit about background about the H1B lottery, as you know, before they went to this electronic system the last couple of years, they had just the lotteries where you prepared the entire case and you sent it in with your filing fees, which were a lot. Then they would do the lottery, and then they'd send the ones back that didn't have the paper, that didn't get accepted in the lottery. Then they went to an electronic system, which they forego all that paper being produced and sent in and all that mail, which is smart. However, it kind of opened up the door a little bit for easier methods of fraud. But before, I don't know if you're going to ask me about fraud, but before we get to that, I don't see it. And are you asking about how the process has changed this year's particularly from the years prior?
No, yeah.
Well, okay, so let's talk about the fraud, for example. So when they announced that they were going to electronic, I said in my head, I said it right away. It just popped in my head. I said, this is going to be a catalyst, and we're going to see hundreds and hundreds of thousands of more applications. Not necessarily because the economy is better or they're needed, but because it's going to be easier to do fraud. Because think about it. When fraudsters come together and they put these ploys in just to get H1B approvals or lottery applications, the law is that you can't. So if you have a related company, you can't submit multiple applications for the same H1B applicant. But if the companies are not related, you can do that. When they went to an electronic, now, of course, there was fraud existing before. Companies could do that, and they were willing to submit these huge applications with all the fees. And I guess if they got more than one applicant accepted, they would lose a little bit on the fees, right? When you go to an electronic system and you don't have to send any fees in, you're just entering names and maybe their birth dates and passports, etc. Then you have less overhead. The fraud scams have less overhead in terms of having to put all those fees up front. So what happened is they got a little bit smart, and I predicted it. If to get around the law, if you think about it legally, if let's say 20 people came together and opened 20 different companies, okay? But none of those people were related or had any other ownership interest or relationship with any of the other 20 companies, right? So you have 20 different companies. However, now let's say they have 100 people and they want to get them H1Bs, right? So let's say each one of those 20 companies enters those 100 people into the system, and they could do that because technically they're not related, although it is technically a fraud scheme because let's say they're colluding to do that. That's where it can become so much easier to perpetuate fraud with the new electronic system. But now we see a lot of crackdowns going on, so they're getting a lot smarter. I think this year what they've done differently is they're starting to, they're asking for the passport number of the individuals now. So this year what they've done is they're looking at the individual. So if they're accepted, supposedly they're not accepting them again. If that makes sense, if that same individual has, and they announced that in their bulletin in January, and they've done that supposedly. So that's one way that they're cutting back on the fraud schemes. And then the other way is they're doing a lot more investigations into the filers when they see that.
Right.
For example, I have a company now, and we were doing an H1B, and then we got an RFE or a NOID, a notice of intent to deny, which is similar to an RFE. And it talked about the past filing from the CAP, which I've never seen one of those before. And it was talking about, so the person we were filing for our company, but they had been accepted in the CAP for another company. And they were looking into the companies and asking questions about the companies prior. So you can see that they're on to these companies now who are doing that, which is a good thing. which will make it more fair for everyone who needs H1Bs.
Okay. So hopefully it's going to be all good for the H1Bs at least, and also for the immigrants.
Yeah, I think so. The only changes for next year, I think, is they're going to probably implement instead of $10 to enter someone, I think it's going to be 200. And they wanted to do it this year, but at the last minute, they decided to keep the $10 fee in place. So it'll be a little bit more. I think it'll be 200 per person you want to register.
Okay.
Which is interesting. But other than that, I don't know if they're going to change much from this year's fiscal year cap to next year. We don't have the announcements yet, but they usually start announcing them around this time, and then in January they start coming out with announcements and changes if they want to make any. But I can tell you, 780,000 caps last year was not a result of the economy. It was, I mean, if you look at versus the previous years, it's several 100,000 more. It's that was because it was easier, and I predicted it. It was easier because you don't have to file all the and they've gotten smarter in how they're doing it and set up these fake phony H1B. We used to call them job shops when I worked at Infosys, and they're out there. They crack down on them, but they're out there. I can explain what that is if you want, or we can move on.
Yeah, please go ahead. We would like to know more about it. Yeah.
So when you're looking at an H1B, a job shop, so technical staffing companies like yourself can have legitimate jobs and legitimate clients. And the requirement is technically that you're supposed to have a bona fide offer of employment for the employee that you're submitting the H1B for. What the job shops do, and your H1B employees or applicants or people who want to get H1Bs have to be very wary of them, is they come along and they try and they say they can get you H1Bs. They don't really have jobs lined up that are ready to go, bona fide job offers. They just try, and some of the other things they do is they try to take money from the employees. So anybody out there who's looking to get an H1B, be very wary of these job shops. What they're doing is they're making a profit by trying to get H1B lottery numbers in high volume and then utilizing those by placing people in the U.S. after the fact. Whereas a legitimate staffing company or a legitimate IT consulting company will obviously have clients and have jobs ready and available and file based on those jobs. And even when they're entering the lottery, should have that those jobs in place. There's a little bit of a difference there you can see.
Okay. But hopefully now that Trump is going to be back with this strict administration, it's going to, if not completely go away, at least it's going to be slowed down, right?
I really don't know. In terms of enforcement and investigations and audits, I mean, even during the Trump administration, we saw times when there were more audits and less audits. For example, FDNS audits are random site visits, which they do on H1Bs and L1s, where they're supposed to come to the office or the place of work. A lot of the officers are lazy and they'll just email you. But so I can tell you the last 4 years, we hadn't seen a lot of them. I've seen very, very few. I just even got one recently. But so I can tell you just within the last 4 years, there was like virtually none. And then maybe now lately a little bit of ramping up. But it's very sporadic. So it's hard to say that just because this administration comes in, there's going to be more FDNS visits and we're going to do a lot of them or. But in any case, a legitimate H1B should not be worried about an FDNS site visit. They're very straightforward. They want some documentation. We did tons of those when I worked at Infosys. And so it's not something that should alarm anyone. And even if you get an FDNS site visit, they're looking just to make sure that what's in the application matches what's on the ground. That's basically all they are.
Okay. Thank you for answering the question, Erin. Now, I actually would also like to know about, because in Trump's last administration, this Buy American, Hire American was his initiative, right? So how do you foresee this policy actually being reinforced or maybe altered in this new term, especially, concerning H1B visa holders?
Yeah. So the argument, the H1B argument on are H1Bs good for America and the economy versus are H1Bs taking American jobs has been going on for a long time now. At least the debate back and forth.
Mhm.
I can probably argue both sides. But more likely, for starters, let's look at it this way. We have the most IT jobs in the world here. I think that's a fact. Statistically, anyone will know that. We have universities and our Americans who go to study, and they don't really go into the computer engineering or these IT fields. A lot of the STEM fields, they're very weak on that.
Mhm.
We have such a high demand, and those jobs are here and plentiful, and they need to be filled by foreign workers, for example, H1Bs, whether they're studying here or whether they're coming abroad to work. So the argument is that the American kids just simply don't go into this field. And I think there's a lot of statistics to back that up. I don't have them on me, but I've lectured about this and I've talked about this in different places. So there's a great need for IT workers specifically. And when you're talking about H1Bs, as you know, the vast majority of H1Bs are IT fields and certainly STEM fields. So you can make the argument that this is a much needed, our economy it needs these workers to come in, these H1Bs to come in and do this work.
Mhm.
The flip side is sometimes what happens is these companies, whether it's, Wipro or Tata or Infosys,
Mhm.
they come in and they do an efficient job. They have clients who have, at least in the past, have had their own legacy IT departments. And what happens sometimes is that these vendors will come in, these companies, and do a great job. They'll hire him and they'll completely replace the IT department. So let's say there were 200 Americans working there, or mostly Americans, and then you bring in someone like a Wipro or a Capgemini or an Infosys. They
Mhm.
come in and they just basically take over the whole function for the company. And this is where you can see a lot of American workers being laid off, and then it becomes a political issue, and then it gets into the press. And even though it might not be that many workers at the end of the day, it could be a whole IT department of a company, a major company. Sometimes they're replaced or rehauled, and then you can see the political drama that unfolds. Well, here you can see people are talking about losing their jobs or
Mhm.
having to train their replacements in many of the situations, and I've seen that. I would tend to think that if there is a robust IT hiring here where there's just so many jobs that if those folks are really talented, they will find jobs, number one.
Mm.
But I can see the argument where you have specific cases, and they're more emotional cases because they're more like one-on-ones, but you can get a lot of sense of when a whole IT department is replaced and the new folks coming in, they had to transfer knowledge. I can see that argument. So I can see both sides, but I really tend to think that if those folks were really talented folks or
Mhm.
needed, that they could find jobs when those kinds of changes happen.
Right. So now everything will boil down to the talent and the skill that the person possesses.
Yeah. Now, as far as Trump, he's business friendly. I mean, he's coming in to make the economy grow again, and we want to be the best in the world. I think he knows and he realizes, and I have seen interviews with him in the past, from the last time, where
Yeah.
he's acknowledging that fact about the H1B. So
Mhm.
when you read all these articles coming out about Trump's going to do and Trump's going to do, a lot of it is fear mongering.
Mhm.
A lot of these people just don't like Trump because that's the fashionable thing to do on one side of our country. But you got to read it and look if there's any facts to it. And yes, definitely on the border with the illegals, I think that will be a boost. That will be a boost to business immigration because you need law and order. I mean, I have clients waiting years and years. I have all my clients, none of them want to overstay their I-94. None of them want to do anything, even remotely illegal or looking illegal or something that could get them in trouble. And these are the folks that need the services of the USCIS, which is, you're talking about wait times for EAD cards and people have to come off payroll. I mean, these are people too, and they've come here legally. They've paid thousands of dollars. Their companies have filed the right way,
Right.
and they've taken a back seat to allowing millions and millions of people to come in for what purpose?
Mhm.
So that's my opinion on it.
But Erin, do you really believe that it has now become fashionable or cool to say that we are anti-government, especially anti-Trump? We don't believe in his policies or what he says, even though everything that he has said or done has always favored the country.
Well, when I'm talking about, well, if we're going to talk politics now,
No,
when-
let's just take immigration. I mean, because mostly that whatever policies or actions that he has taken so that so that illegal immigrants cannot get in, and so that the borders are the border policy is strict, so that illegals can't get into the country. But then people don't really favor that idea also, and say that he has always been against immigrants. So what do you have to say about that?
Well, his whole platform is that he wants people to come in legally. He wants people to respect the laws of our country. And if you can utilize those laws to come in, then you should. He doesn't want there, and there should be borders, and there should be places where you enter, and there shouldn't be, drug cartels running in. People leave the crime and the drugs alone. There shouldn't be drug cartels organizing people to come in illegally and finding loopholes because there's no boundaries or no wall or this or that. I mean, no country in the world would ever put up with this. So when he's talking about that, he's not talking about, well, we shouldn't also allow legal immigrants because they're bad. He's never said that. And so the perception that will flow over into business immigration is just completely false. And there's 4 years of evidence of that. And when I try to argue with some of my immigration colleagues who are very, let's just say, anti-Trump or pro-open borders, as I call it, I say, well, why don't you point to something in 4 years, which he's done? And then they talk about, if you remember during COVID, when they kind of shut down visa processing and a lot of embassies. Well, that was shut down because of COVID. I mean, and that slowed the entire world for traveling. And I come back and I tell them, that's not a good example, because that was a few months, yes, and it was hard maybe to get an H1B visa, and maybe a few people got stuck abroad here and there. But that was really due to the disease, the COVID that was killing people. And yes, movement was stopped everywhere by every country. So if you want to argue this, I'll argue with any immigration lawyer who wants to come on here and tell me that these asylum cases are actually legitimate and can show me how. But they won't, because they don't have the facts on their side, and as usual. But anyway, not to get into the other side of immigration. We're here for business immigration, and I don't see the fear. People who are reading all these articles, who just read them with a grain of salt. That's what I'm saying, because nobody knows what's going to happen. Number one, and number two, if you look at the track record, those 4 years, L's and H's, which is mostly what your audience is interested in, not killed or hampered, or there may have been delays here and there, but that was due to COVID. So just be careful when the fear mongering starts, because the new administration's coming in and one side has simply lost the election. So just be careful. That's all I'm saying.
All right. Thank you so much for that insightful answer, Erin. And a lot of people have joined us and have also posted their questions. So we are definitely going to take their questions. Or maybe let's just start with Hosam's question. So Hosam said he has posted this on YouTube, and he says, I'm a medical laboratory scientist certified ASCP. How can I apply with you?
With me. So, okay. So as you know, most, whether it's a green card or simply, petitions, O1s, and you need a sponsor company. So if this person is a scientist and he's working in the or I guess he's not in the US, I don't know. I always tell him, like, I don't find job. I guess that's your job, but we're a law firm. Our clients are companies, and we can certainly file, extraordinary ability or outstanding researcher green cards. There's an O1 category if he meets that. But like I say, most folks outside the US who really don't know much about how the process works, maybe they didn't go to school here. Really, you need to find that company that wants to hire you. You have to look either in your home country, or here, find your field, apply to jobs online. And then at some point, when someone is interested in you and your services, the question will come up if they need sponsorship. That's where I come in. So
Right.
we're not, I can't, I'm not going to find jobs for people. We're a law firm. I think you do that. If you're a staffing company, that's probably what you would do. But yeah, after they have a job and they're like, okay, now how do I get the person into the US? We want to hire them. Then they come talk to me and we strategize and we find what solution they can have, you know, to work in the US legally. I think that's the person's probably outside the US, I guess.
Right. So, Hosa, maybe you can write to me. My email is rajni@staffingly.com. And yes, maybe you can share your profile with us. If we have anything else, anything for you, we are definitely going to get in touch. But thank you so much for your question. If you have a follow-up or a question for Erin, make sure that you post it in the comments below. Meanwhile, let me quickly take Kavya's question, which she has posted on LinkedIn. So Kavya says, Erin, she says, can we expect more jobs for students with H1B sponsorship? Currently, companies are not ready to take students because they need H1B sponsorship. Is there an increase in H1B sponsorship of IT jobs for immigrants?
Okay, so it's hard. Okay, so look, when you're talking about are there going to be more H1B opportunities, or are there going to be less H1B opportunities, that usually goes with the economy. I think now that we're going to have a business savvy administration coming in, we saw the last few years companies like Amazon and Meta, which was Facebook, we saw them lay off. I can tell you, Meta laid off like over 22,000 employees, or one of them in like a 2-year period. Large layoffs, and yes, a lot of them affected H1Bs. They were in STEM fields, they were in IT fields. I can tell you, we had some of my companies. They were calling me like, hey, we got a new person we're hiring. We got a new person. And they seem to all be coming from Meta. So in terms of answering the overall question, it's hard to say, well, there's going to be more companies are going to want more H1Bs or less. Companies want talent, and they have roles and jobs they need to fill. They don't care if they're H1Bs or non-H1Bs. Now, I can tell you this, if companies are hiring H1Bs, it's because they really need the talent and it's there. If you think about it, to hire someone who needs sponsorship is going to cost them, in terms of lawyers and fees and all the headaches and potential green cards and perm filings and all those fees. If you look at it from a comparison basis, it's going to cost them a lot more, obviously. So if they're willing to spend that, it tells you, and it goes back to the first question you asked me, if they're willing to spend that, they don't have someone equally talented or even right there who's going to cost them $20,000, $30,000, $40,000 less in the long run, which goes to show you that the vast need, and I think it's only going to grow. We can see a lot of movement. I don't know if anyone's out there is doing AI, but a lot of those companies are coming up. And then the traditional companies like, the big FANG like Google and all of them, they're still hiring. Their numbers will fluctuate. I think there's going to be more opportunity, but it's hard to say, it all depends on what you're doing and what field you're in. And then, the market is still good for students, for foreign students coming out and then, sending in resumes and being hired based on their talents. Yeah.
Right. So, Kavya, I hope you have got your answer. Thank you so much for your question. If you have a follow-up, please continue posting your follow-up. We are here with Erin for some time. We'll be taking your follow-ups too. So right now we have questions from Rag, then RK, Ankit Goel, Lokesh. So many questions are here. Guys, I'm definitely going to take your questions and ask it from Erin. But before I do that, Erin, I would also like to know from you that what factors do you believe have contributed to, the decline in H-1B visa approvals in 2024?
The decline in approvals. Well, I can tell you, so are you looking at statistics where you have the top 10 visa filers and like Amazon went down a few thousand? Is that what you're talking about?
Yeah, Amazon and then Google and so many companies actually went,
So if the question is USCIS getting any more stingy or harder to approve? That's not the situation. I will go back to individual company hiring and the economy. When the economy is slow and these companies aren't making what they do, they tend to lay off. So that's probably what happened there. I don't know internally at like Amazon. I don't think they would say, well, we're just going to lay off. Although there are companies who do take a policy I've seen lately where they might say we're not hiring those who need sponsorship. I mean, obviously you can't discriminate, But for business necessity, you can ask that question when you're recruiting people. Will you need sponsorship? So that might be a trend, but I think it's more the economy has been bad. And we're in the last year or two, we're seeing ramifications of some of these big companies just wanting to lay off and making cuts and maybe not hiring as much until they can get back, until the economy can start rolling like it did, prior to the last several years.
Okay, so it has nothing to do with USCIS's strict approach, or nothing to do with the government or the law?
No, I file H1Bs every day. They're very straightforward. Yes, you'll get an RFE. Sometimes you'll get an RFE when it's not warranted, but there's not. I would say it's even easier to get an H1B approved now than it has been. If you think about third-party client sites, they've completely, in the past, I can remember getting massive RFEs on the third party. Oh, where are they working? They're not working at the company. And they've stopped doing that the last several years. So we don't see those RFEs anymore. If you got a US degree, they're not going to question the specialized knowledge. Yeah, they'll throw, those are usually boilerplate RFEs, and you get those and they're unfortunate and they create a little bit of a delay and more cost. But right now, I don't see a huge uptick in those. I can tell you, I have seen months in the past where there's so many H1Bs or a particular year where they're going, but it really doesn't correlate with changes of administration from what I've seen in my experience.
Okay. Thank you so much for answering the question, Erin. Let me again move to our viewers' questions because we are getting quite a lot of them. So let me take maybe RK's question. So RK says, just like the perm process, if you have major layoffs, you can't file new perm. That should be the case. If you do major layoffs, your site should not be eligible, get H1B for the fiscal year. H1B is a great program, should help add workers, not substitute. If a company has 10 American workers, then apply for 5 H1B at the end of the year. That should have 15 workers, not 10 or worst 8. I don't think so there's a question, but this is what he says.
I think he's trying to say that he doesn't want H1Bs to replace American workers. I have a lot of clients. I've worked with big companies, small companies. I don't think these recruiters, and I deal with them a lot, I don't think the recruiters are trying to say, let's get this person because we don't want the American number one. And then he'll make the argument, well, maybe the H1Bs will work for less, so they're cheaper in the recruitment. We know about that when we're recruiting. Maybe we can get them cheaper. It's hard to qualify that. I just think if they need more, they're going to hire more workers, and they're going to hire them where they can get them and as fast as they can get them to get them in there. If a company's growing and the IT needs are growing and the AI is growing and all that stuff, then they need them. They're going to find it's a market out there. These recruiters are cutthroat. And then if you're coming out of school and you have a skill, like lately, I saw maybe 4 or 5 years ago when AI started to become popular and all those AI jobs. I remember some of these students would come out and my client would be like, we got to offer them this and the perm and the green card. We got to give them everything because these kids come out of school. They got 3-4 offers. They got companies after them for these skills. It's amazing. So yeah, I would have to counsel my client and be like, I'm doing your immigration, but yeah, I can see the talent pool. These guys with these niche talents, guys and girls with niche talents, they're just they're so sought after that you're gonna have to offer them the perm quicker. Some of the companies would start their perm right away, right at even they're doing their EAD and they're on their OPT and they start it right away. So yeah, I just think it's economics basically. Are there cases out there where companies won't think they can fire Americans and hire cheaper labor? Probably it exists, but I think the overall mass numbers are because these jobs are there and these companies need them and they'll get them from wherever they can.
Okay. Thank you so much again, Erin. Let me take, Rizwan is here. Rizwan says, hi. Hi, Rizwan. Please post your question if you have any. And then Dezaljin, I hope I'm taking your name right. I'm sorry if I'm not. He says, hello, everyone. Please post your question in the comments below. And now let me take Rak's question. So here, Rak said, "Will L1A for a tech non RFE?" What do you have to say?
You broke up there. Let me see if I can read that question. Will L1 tech nonprofit face extra scrutiny or even an RFE? L1A for a tech nonprofit. So there's really no difference whether you're filing for an L1A for a nonprofit or a profit. The issue with scrutiny will come whether the company can support the salary of the L1 worker, and is there a structure in place where the L1A will be overseeing professionals or supervisors. So the scrutiny is across the board for L1A. It doesn't matter whether you're a nonprofit or not. That's what they look at. And yes, L1As have been harder over the past 10 or 15 years. They used to be just a piece of cake. You didn't hardly have to file anything. Now, when we do an L1A application, we put in org charts and emails of the manager actually overseeing people, really the nuts and bolts evidence to try to avoid the RFE. When I used to do L1A petitions, they were like 2-3 pages. Now my support letter has gotten to 15 to 25 pages. And I'm trying to avoid the RFE for my client is what I'm trying to do. So I'm trying to get everything in there, as much evidence as I can. So you can just see the trends. And, L1B has been traditionally the hardest, application to be approved of all the work visas. And those you really have to put together a very strong L1B argument. It's evolved over the past 20 years from, like I say, maybe 2-3 pages and a little bit of explanation to 15, 20, 25 pages and exhibits like this. So there's been a big evolution in the L1 field, even though there's been really no changes to any L1 restrictions or laws or adjudications or obviously numbers, because there's no limit or lottery on L1s. So it's interesting.
Mm-hmm. Okay, so Rak, I hope you have got your answer. Thank you so much for your question. Please continue posting your follow-ups. Sita is also here. Sita says hi. Hi, Sita. I hope you're doing well. Please post your questions in the comments below so that we can take it and ask it from Erin. Meanwhile, let me take Ree's question. Reese has posted this on LinkedIn. Reese says, so if most companies are laying off, why do we need to import labor? Does the law have some throttle for economic slowdown?
If most companies are laying off, why do we need to import labor?
Mm-hmm.
Well, we talked about 2 big companies that had big layoffs in the press. And yes, other companies do lay off from time to time. I'm not sure if most companies are laying off right now. I don't know if that's the fact. But assuming that is the fact, if most companies are laying off, and I guess you're talking about H1B fields, IT workers and STEM workers,
Mm-hmm.
do we need to import labor? Probably not. And that might be the reason why Amazon's or H1Bs went down 3,000 in 1 year, or some of the other companies in the top 10, their numbers went down. That's probably the answer, is they weren't importing labor or sponsoring a lot of H1Bs. So you might have answered your own question right there. Does the law have some throttle for economic slowdown? I don't know. What do you mean by throttle?
Reese, if you can please, write your question in detail. What do you mean by this? Because I was also trying to figure out what actually this question meant. So maybe if you can explain us what you actually want to know from Erin. Meanwhile, let me take Rizwan's question. So Rizwan says, hi, I moved from Pakistan to the USA 3 months ago. I am a front-end developer and I have applied for lots of jobs but not received job. Please, any job or intern. Okay, well, again, he says this is about a job opportunity, which I don't think we should be talking about here. Rizwan, how about you send me an email on my email ID, which is rajni@staffingly.com. Reach out to me there, and I can help you with something if we have an opportunity for you. Okay, so Rak says people manager L1A has better success than functional manager.
Okay. Where's the question? Okay.
Yeah.
People manager, regular L1A has better success than functional manager. I would agree with that.
Mm-hmm.
We do functional manager, but functional manager L1A are much harder to prove. you have to really show that the function of the company that the person is managing has some intrinsic value or worth. So, for example, let's say it's a project you're managing. When we do those, and we don't do them a lot because, as he says, they are much harder. But let's say we have to do that because there's simply no management of people in the traditional sense. We would show that project, we would show the financial figures, number one, from that project versus, let's say, what the company's income revenue is. We really have to build a case and show them, yes, they're managing, but it's functional and how intrinsically valuable this is to the company. And you can do that with numbers. You can do that with revenue. You can do that with letters. If it's a project management situation where they're managing that project or that function for the company, it can be a project. Then you want to bring in additional evidence, maybe letters from the client showing the longevity and the importance of the project to the company, how that project, without that project, the company wouldn't exist, or things like that. But yes, they are very hard to do. He's right. The functional manager is very highly scrutinized. That's not to say that the L1As are not scrutinized as well, but it's just a functional manager. You have to really put in the worth of the function that they're overseeing or managing.
Okay, so Rag, thank you so much for that comment. And Ankit is also here. Ankit says, my company is filing multiple H1B petitions for different candidates, including me. How does USCIS determine if a company is trying to game the lottery system? Could my application be impacted even if I'm not involved in any wrongdoing?
So if he's describing a situation where an unscrupulous company is somehow filing multiple H1Bs illegally for the same person, yes, you could be impacted because even if it's approved, they're doing investigations and they can come back and revoke the H1B at a later point in time, which means you're going to lose your H1B, even if you're not even working for that company anymore. An example I gave at the beginning of the show was one of my clients. They're working for this company, but now they're challenging how they were picked in the lottery, and was that legal and was that correct? And that's something new. So that's interesting to see. And it's good that they've got people who are looking at this, and they maybe have a better electronic system in place where they can kind of, look at the data and see who's filing for who. And that's why they're asking for your passport number. Because they can easily see how many applications were filed for. Maybe 150 applications were filed for one person. They could see that, and that's where they're going to start looking. So that's good for them in their investigative process.
Right. So, this reminds me of a question that actually I prepared for you, Erin. So I want to also know from you, how can applicants actually ensure that their job offers are legitimate and not at a risk of being categorized as fraudulent?
Yeah, that's a good question. Research the company who's offering you a job. See who they are, number one. I guess if you're in India, and there's a lot of companies in India, and some of them are legitimate companies and some of them are not, right? And I guess that's the situation we have here. Some red flags are they're requiring you to pay for your H1B. You're not supposed to be paying for your own H1B, number one. So that's a red flag. If you're the company and they're like, hey, yeah, we're going to get you an H1B, we just need you to pay for it, or we need you to forward us some money here, be wary of that, number one. Number two, ask questions. Where am I going to be working? Where's the job? That should be in place. A lot of times, obviously, the employee is not going to see the contract between their employer and maybe, the client, but try to ask questions around what you're going to be doing, where you're going to be, where's the physical location of the job. If you're an employee and they're filing, you're entitled to see the LCA, although that will come later after you've already decided to go with that company. But your H1B employees are entitled to a copy of their LCA. They can see everything that's been submitted for them. You should also have a copy of the I-129, which tells the government, here's the job, where it's going to be, what the person's going to be doing, here's the salary, all of that stuff's in the application. So if you're an H1B, if you're looking to become an H1B, just research the company, look for some of these red flags, and don't pay money to a company in India who says, yeah, I can get you an H1B, just we need $500 up front or something. So look for those red flags.
Right, right. But Erin, do you believe that stricter penalties for fraud will deter companies from questionable practices, or do you think that can happen?
Yeah, I mean, if they're starting to crack down on them and they can actually get these companies and prosecute them, yes, certainly stopping them from filing H-1Bs. The problem is, these companies they morph. They're one set, and then they find them and they stop them, and then they open up new companies, right?
Mm-hmm.
So if they're in the business, and if they're in the criminal business of job shopping, they might not even be in the U.S. They can certainly prosecute the ones that are in the U.S. easily, and they have. There's been some cases, you've probably read about them. But if they're overseas and there's a lot of players involved and they're savvy, they simply open up another company tomorrow and they repeat the process, right?
Mm-hmm.
But yeah, hopefully they will have more efforts to be able to locate these, and then they prey on the cap lottery. This is their big money maker, right? Every year.
Mm-hmm.
So hopefully, with all the it's gone electronic, but with all the data that they want, they can do a better job of pinpointing who the lawbreakers are and who are the actual legitimate H-1B filers.
Right, right. So now, with upcoming changes under under Trump's administration, what adjustment should applicants anticipate regarding H-1B visa policies?
Okay, like we discussed before, I don't think there's going to be a negative impact to companies filing H-1Bs, adjudications of H-1Bs. I hope it gets better. Just this past year, we have fees on H-1Bs and Ls and other business immigration visas that we've never seen before, called the asylum fee. I don't even know how this is constitutional, because these companies are filing these petitions and they're paying now an additional asylum fee on top of all the other fees we have to pay for the illegal asylum scam program that's going on the border. Now, why that floats into business immigration, I don't know, but you can see there's something that hopefully they will do away with. I don't understand why businesses have to pay an asylum fee for a program that is just overwhelmed and in my opinion is a scam. So hopefully that will go away. That will make things a lot easier for small companies who are already paying exorbitant fees, and now they got to pay an extra $300, and even bigger companies who have to pay $600 for every application, on top of the ACWI fee, the fraud fee, the I-129 fee, and all these other great fees that we have. When I started practicing immigration law, I was in Israel at the time. This must have been around 2000 or 1999. Mm-hmm. The fee for an H-1B was $85. There were no other fees. Wow. Now I file a fee for my client. They're looking at almost $5,000, not including premium, for one H-1B. $85, $5,000 premium. I remember when they started the premium program, it was an extra $1,000 or even less. I think that's gone up every year. Now it's $2,800 for the file to add premium to your case. Lovely. And USCIS takes in so much money in fees. Just USCIS, if you think about it, if it was run properly, they could make massive profits for the government. But apparently they don't, because now they got to add more asylum fees onto it. So they're not making profits, and the wait times and the client service, in my opinion, in 20 years I've been doing this, has gone like this. Now you can't even talk to. I mean, a year and a half ago, I could at least get someone on the phone. Now they've gone to all these things where you got to email them. They've gone to the lockbox. The lockboxes are just a nightmare. Now they have vendor companies coming in and intaking all the mail before it even gets to USCIS. And I can tell you the folks doing that are not the best, let's just say. And these lockboxes are sending cases back at a rate I've never seen in over 20 years. We're getting cases back for the stupidest reasons, for little things here and there. It's just very frustrating what's going on right now. And I'm hoping with all of these efficient people that he's hired to look at USCIS and efficiently clean that up, because that could be a moneymaker with these fees as high as they are. You could be efficient and make money and bring back the client service that we used to have, which wasn't 100% the best, but at least it was some good client service where you could, they make mistakes and clients pay a lot of money. So when you make a mistake and clients pay money, you need to have some client service that can help efficiently. So hopefully that will change for the better as well.
Okay. Well, let's hope that. Thank you so much for answering the question. Erin, RK is back, and this time he says, do you think it would be a good idea to make it that 70% of the H1B must be granted to individuals like F1 students who have already invested, lived, worked inside the US?
It's interesting. It's an interesting. First of all, as you know, F1 students, if they're in the STEM field, they're going to have 3 H1B lotteries to make it. Now, most of them do. I do have some. We have some that go 1, 2, and 3, and unfortunately, they get unlucky. So I can see that. I don't know if that would be a solution. Maybe something for F1s where after their STEM OPT was finished, and they could show that they applied for 2 or 3 lotteries and didn't get it. Maybe they could get some kind of extension. That could be a good idea. And then they could keep applying for the lottery. Maybe that could be when you focus on 70%, that might not be fair to other companies who rely on H1Bs who maybe don't have a lot of F1s. So I have both types of companies as clients, but yeah, there's a lot of things they can do. They've talked about in the past, making it. You could also say, well, some of these big companies, they get thousands and thousands, and you might be a little company and you only need 1 or 2 H1Bs. Is that really fair that they're depositing 3,000 or 10,000 H1B lotteries and you're depositing 3? And maybe all the ones who are small companies should get all those filled before all the big file. Well, that would hurt the big filers. There's been a lot of different proposals on how to make it. They had it they proposed maybe H1B should go first to the highest salaried applicants. The problem there is now you're going to kill small businesses. Microsoft and Google, that'd be great for them because their salaries tend to be very high. But now you're killing the other side of the H1B filer. So I don't like that. There's a lot of proposals to make it more fair. Right now, as we stand, it's traditionally anywhere from 33 to 40% chance of you making an H1B lot, closer to 40 if you're a master's. If you have a U.S. master's, probably closer to 32 or 33% if you don't have U.S. master's. So those are pretty much the numbers. Now, I can remember one year, a few years ago, where we didn't have a lot of, they didn't fill the numbers. That was when the economy was really bad, if you recall. And the H1B went on. When I started doing immigration, there was no lottery. Of course, there were 300,000 H1Bs a year, and they went on year round. So we just filed them whenever they came up. Yes, this lottery system is interesting, but I guess it has to be there because the demand is so high. How else could you have a fair way of intaking them? But there's a lot of different ideas out there. I don't know what the best one is. It would have to be really thought through and fair to different kinds of H1B filers.
Right. People can come up with their ideas, but ultimately it will depend upon the government, what they come up with and what they decide to do, right? So thank you so much.
Yeah, F1 students are a big part of, they're already here, number one, and they tend to be very talented in terms of these niche IT fields, even more so than your run-of-the-mill, let's say, H1B worker at one of the big Indian companies. You know what I mean? These folks are very highly specialized. They're already here. Culturally, they're very attractive. They've already blended in. There's a lot of advantages to them. So maybe they should look at something to help the F1 students a little bit more. The STEM OPT is great. We haven't had that forever. That was new a couple of years ago that came in. Maybe an extension of that, but yeah.
Okay, so actually Lokesh also wants your advice. He says, I have been with my current employer on H1B for 3 years, but I received a better offer from another company. With the current climate of fraud crackdowns, how likely is that my transfer petition might face extra scrutiny? What can I do to avoid any delays or rejections?
Okay, so H1B transfer, or what we call H1B portability cases, is exactly here. You're working and you have a great job offer and you want to jump ship. You want to move to the new company. So first of all, the first thing to note is that your current employer will not see the new H1B application. They have no way to see that. So your current employer will never know that you talked to a new company or that even the new company filed an H1B for you. So as long as you're staying with your current employer and don't tell them anything, you really don't have any jeopardy of losing your current job. That's why a lot of the H1, we do a lot of H1B ports. When the H1B workers are porting, they always want premium because they want to have the H1B approval in their hand. Mm-hmm. So first of all, H1B ports can start working when the application is filed. They don't have to wait for the approval, which is great. However, a situation like this, where you already have a good job and you got another good job is going to file an H1B for you, this guy wants the premium so that he can have the approval notice before he says anything to this job. I understand. It's a sense of security because you could start working with the other employee based on the approval, based on the filing, and then something can go wrong in that application. Now you screwed yourself, and you're going to be really screwed. So yeah. So if the new employer could file in premium, that might be good for you. That way you don't even have to involve your current employer until you have a new approval notice, and then you can move. That's usually what's been going on. That's what we see most of the time. My client gets a new one. They're like, yeah, but they want premium. And then the client's like, well, I don't want to spend $3,000 if I don't have to. They can start working with me now. I'm like, yeah, but a lot of these port H1Bs will not start with you until they have that a little bit of the security of knowing they have that approval notice.
Right. Okay,
now, if you're talking about, go ahead, sorry.
No, please go ahead.
If you're talking about fraud crackdowns based on what's going on with the lotteries, that can come and hit you. If you were involved in a lottery with an unscrupulous company and you feel that maybe they were doing something, they were one of these, what I call job shoppers, then you got to be careful. That could come back and hit you at any time. That's out of your control. You're not going to know what investigations are going to be done against a company that you had an H1B with 2 years ago, and then they're going to bust them, and now they're going to revoke every single H1B they had. And then, yes, you could be affected by that. So.
Yeah, right. So thank you so much for that advice and for that answer, Erin. Lokesh, I hope. And Erin, we also have questions which are posted by the viewer on a Facebook group. So if you allow, I would like to share my screen.
Yeah, sure.
If it's possible.
I can run over. I have time. I can answer questions. That's fine if you want to go a little longer. Yeah, I can hear you.
Okay. Thank you so much. Okay, I would like to share my screen. Okay. So this is one group where people have posted questions regarding H1B. So this anonymous member says, because of long waiting time of NIW, this is, I think, an EB1, maybe let's take H1B related question. Okay, Kaushik has posted this 14 minutes ago, and he says, hi all, if you valid visa until April 2025 and have renewed H1B petition till April 2028, you are good to enter US with the existing visa along with renewed petition without restamping with new petition, right?
As long as the visa is valid, unexpired visa, correct. So let's say I work for company A, I have a visa for 3 years, I port to company B, I got an approval notice, and now I want to travel. With the new approval notice of company B, you can use the visa from company A as long as it's valid. In my example, it's valid for 3 years. Yes, you can keep using that visa to go in and out, even though you're not working for company A anymore, but you must have the approval notice for company B to show them every time you enter, if you don't want to get a new visa stamp.
Okay.
But the visa always has to be valid. You can't come in on an expired visa. That's one thing you cannot do.
Right. Okay.
Okay.
Kaushik, I hope you have got your answer. Let me quickly read. Okay. So actually, we've been continuously getting questions on this group. Please respond fast. I have doubt. I have Dropbox appointment today. My pay stubs have old pay and company didn't mention my new salary in employment verification letter. And in Dropbox, they won't ask my revised offer letter, but I have it. How will they know about my new salary? What should I need to do?
If you've already submitted everything in the Dropbox, there's nothing you can do. They're going to you've already submitted your passport. They'll send it back to you with the new visa. If they have a problem, they'll let you know. Getting increased salary is not a big deal. In fact, if you're an H1B in the US and you've gotten a huge jump in salary, we don't file H1B amendments for that.
Okay.
So I don't panic. This person's panicking too much.
Right. So maybe they need to calm down a bit.
Yeah.
It happens because you have just applied for the visa, so that's fine. This anonymous member says, can I get stamping to passport, which will be expired in 7 months? Once stamped, I can get passport renewed and can fly to US from India with all new passport and valid stamping.
Yes. If you have let's say you got an H1B visa, but then the passport expires, but the visa is still good, you get your new passport, you travel with both passports, and he will look at the visa in the old passport, and you can travel like that. Correct.
Okay. So, okay, this person says, hi guys, I worked with DXE Technologies in India, which was an HP enterprise back then. Now I skill set. Okay, no, this is not related to. Hello, please assist me in understanding the table. Okay, this is again a table. Okay, this person says, I got NOIR, H1B after USCIS site visit. Any idea how long will it take for USCIS to take final decision? Employer replied for the notice.
So the NO notice of intent to revoke was received, and the employer already responded to them.
Mm-hmm.
And that was outside a regular filing, I guess. Or was it a premium case that was filed?
Not much details are here,
well,
but this
I mean, if
it
it was
says H1B after USCIS site visit.
After a site visit, okay.
Yeah.
It's hard to say. Those can sit for a long time. I guess there's no premium in play here. So if they've responded, it's hard. It could be all over the map. It could be a couple months. I don't know. We've had those that have pended for a long time, and we were like, wow. I mean, the good news is you're still working and you don't have to leave or anything. So
okay.
It's hard for me to get timelines. Are the hardest questions I have from my clients, because you can look online and see timeframes, and those are usually not really good. And then someone's asking you, well, when am I, it's not premium. When am I going to get my case? And we can look at trends, but it's hard to really give really good pinpointed timelines of when you'll, outside of premium, of when you'll get cases back. It's tough. That's a very frustrating part of it.
Okay. So, all right. Thank you so much for answering these questions, Erin. I think we have had a great show with you. We did try to cover a lot of questions, though still a lot of them are pending, but we still try to cover a lot in today's episode. So thank you so much for being here. And to our lovely audience, I would like to say that if you would like to get in touch with Erin, please give him a call on the number. I would like to display on screen, or maybe I would like to request a control to display on screen.
Yeah, 469-459-1771. That's the office. You can reach me.
Right. So please give Erin a call on the number if you're trying to get in touch with him. His number is 469-459-1771. I would like to repeat it, 469-459-1771. You can also email him. His email ID is erin@eeglawgroup.com. And you can also visit his website, which is www.eeglawgroup.com. Yes, you wanted to add something to it, Erin. Please go ahead.
I was just going to say, if you're calling me, I can give you advice and help you. But if you're really looking for a job and you don't have an employer, we're a law firm. You need to, find some recruiting companies. After you have an employer in place and maybe a job offer, and you need assistance or you have questions, I can answer those questions. But I can't. I sometimes we get questions where they're just looking for a job, and it's we're not in that business. So
if you're looking for a job, guys, you can get in touch with me. My email is rajni@staffingly.com. And if you're looking for any immigration, looking for help related to your immigration related case, so for that, please get in touch with Erin. We have already displayed his information and also have read the information for you so that you can note it down. So make sure that you get in touch with Erin as soon as possible. And thank you so much for joining us today. Erin, thank you so much for being here. It was lovely having you. Maybe we can have you for another episode so that we can cover more questions in that show. But thank you so much for being here again today.
No problem. Good talking to you. Thanks for having me. Good to be here.
Thank you so much. And guys, thank you so much for your questions. Please continue posting them, because whenever Erin is going to be back, we are going to take those questions in that episode, or maybe we can directly ask him by writing an email to him asking for the answer. So we are going to reply to your questions in the comments below. So you make sure that you continue posting your questions in the comments below. But for now, that's it from my side. I'll have to take your leave for now. I'll be seeing you again tomorrow. But for now, thank you. Keep watching and keep subscribing to Immigration and Jobs Talk Show. Bye for now.